besides this is obviously going to be, you want to know what really happened, you need to watch this. This is the only place you're going to get this type of interview or I
don't really know what this is, but I didn't do it. I'm innocent, Judge. I'm not guilty. I'm innocent.
We, the jury, being duly impaneled and sworn, find the defendant Matthew L. Moore not guilty of murder as he stands charged in count 1 of the indictment.
People, it's over. Elvis has left the building. It's done. Over.
Press the like, press the like, press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Like and subscribe, everyone. Let's fucking go. Hello, everyone. Welcome back. Good morning, good afternoon, good evening, whatever it is with all of you. Here we go. Christine, hello to you. Deb, hello. Daffy Dilla, hello. Thankful, hello. Sarah P in the house. Hey, Mama Ames, how we doing, my darling? Yeah, you're Deb as well, you? Deb as well? I forgot your name, Mama Ames. Apologies. Storm Catty, hello to you. Lady Di, here we go again. Being here, but just listening and working and laughing to them. Thank you, my darling. People at work are probably like, what is wrong with her? Joe, Presto Chango. Let's go, Joe. And we're back. We are here. Lisa, hello to you as well. Hippie Chick, hello. Robin. Ouch, I landed on my head. I think my boss will let me go home. Robin, let's go. DSG, she couldn't find you. What? Well, you're here now, so that's the main thing. You're here now, Bev. There you go. Hey, Carol. There you go. I approve. Raul, hello to you. I think I got everyone. Dana's in the house as well. Let's go, Dana. I think we got everyone. Have we got everyone? Luby. I'm just on the cusp for day 2 when you're on to another. So, no, we're not. You're not even on day 2. That was just day 1. Day 2 is not happening till this afternoon, Luby. So watch that. Then catch up here. I'm going to stream day 2 and day 3 probably tomorrow. We'll just go with us. Just go with us. It's all good. It's all good. Yeah, Trucker. Yes. All right, hang on. Carlene's back. Hello to you, my darling. Tracy, hello again to you, my darling. Bill, how we going? Hey, Bill, have you been sliding into DMs again? Look, Bill's got a picture up. Ladies, Bill's got his picture up. Let's go, Bill. Hope you're getting some luck there, Bill. Teresa, hello to you, my darling. This trial streaming. Yeah, I'll stream it now. What the hell is this? This is a Erin Hack. I think it's in Erin Hack. It's in. Oh, where the fuck is it? Waukesha, Wisconsin. So it's Erin Hackland. It's a Torbs. It's Erin Hack. We are back. We are. Hey, Christopher, darling. Hello to you. Bill has a photo. He does. Reality check. Hello to you. How are you doing? Just dropped by to say good morning, recovering from pneumonia. Oh, no. Hey, T's and P's. Get better soon, reality check. Everyone seems to be ill here, so get better soon, my darling. Hope to see you soon. But you're always missed. Don't forget, hit the like. Bill, let's get on, Bill. New trial Erin, let's go. Bill, finally. Waukesha. Well, it says Waukesha. Waukesha. Thank you. Nobody's X'd you. Hey, you need to slide into those DMs. But also, like, hey, you know what it is? You got to start as friends first, though, Bill. Do you know the score? I got like 10 new followers or ladies. Some of them are married though, so you can't message them. But you know, you're a nice guy. You seem a nice guy, Bill. And that's a nice picture. You seem like a good looking lad. So hopefully get some luck, Bill. Amy. Why did I think Deb? I don't want to know why I thought that. Amy. Sorry, Mama Ames. There's so many names now. There we go. Waukesha, Wisconsin. There we go. Right. Let's get the thing up then. Not that thing. I mean the screen thing. So you guys can see what I'm looking at. I'm trying to find it, but I can't find. I can't find it. Here we go. I got it. So, Wisconsin man punched over tattoos, dies. Kevin Sehmer trial begins. So just a reminder, people, please, don't go searching for stuff, because what's going to happen is you're going to see day 2 and day 3, and it's going to spoil it for you. They're on day 3 now, and the state and defense have all rested. They're going into closing statements. Fuck. Hang on. Something went off in my head there. It's the other. I don't know the trial opening. Hello, Julie. Hello to you. Hope you're well, my darling. Nice to see you. Rebecca, yes, it is. Hi, Scott. Nice to see you, fella. Nice to see you, buddy. Since I checked in, curious what this kid. Well, I'll show you now. How much coffee? Not enough, Hackster. Not enough. But here we go. Just walked by and gave me a crazy look because I was singing Jingle Bell Rock. Nice. Hello. Right. So, trial begins. So, the trial of Kevin Sehmer, the Brookfield man. I don't know where Brookfield is. Erin Hack will tell us. Punching there you go, Lisa. That's dedication for you, that is. Thank you, Lisa, my darling. But you get to watch it now. The only reason I say about don't go searching, because you'll see what's happening. So, obviously you can if you want to. Do you know what I mean? But please don't spoil it in the chat. Hello, Stephanie. How are you doing? Hope you're well. Stephanie SG. Right. So Brookfield man accused of punching a Delafield man. Again, I don't know what that's got to do with it. In the head over tattoos. Began on Tuesday. So today's Thursday. Began on Tuesday. Kevin Sehmer is 65. Is charged with felony murder, which is battery. He was previously charged with second-degree reckless homicide. Oops. We like to watch with. Thank you, lady, as well. Thank you to you, my darling. Brookfield is like 4 hours away from me. Never be there. Yeah, the trouble is, Erin, all these murders are happening next to you. That says something about you, I think. No spoilers, yes. I love coming to trial, but yeah, this is just to give you a narrative what it's about. That's all. It's just giving you what it's about, nothing more than that. State House was very fun, but I need to put those pictures together, Scott. I'd rather watch with all of you. Yes, Lita, thank you, my darling. There you go. I live a couple of miles from Brookfield. Oh, there you go, TJ. Hey, welcome, TJ. So here we go. So it's a bar fight. Was it an act of rage or self-defense? The events of June 17th, 2023 are now playing out in front of a jury with video surveillance and witness testimony. My client has been acting like, may have been acting like a jerk, but you can't attack someone with a stool, defense attorney Scott Skiro said. Near Milwaukee and Waukesha. Hi, Aaron Hack. Hi, Dana. So Davies fell backwards, hit his head on the concrete, and died at the hospital nearly a month later. Skiro argued Davies was grossly intoxicated and said Sehmer was trying to protect himself as Davies lunged at him with a metastool. Josh Davies fell as he was trying to attack my client. The state doesn't have to prove why or what his motives was. We just have to prove that he committed battery, and it led to him dying. Investigators said Davies suffered 2 skull fractures and bleeding on his brain. Sehmer denied punching Davies, but told police he did violently push him. Police said both men were strangers to each other before the altercation. So there you go. That's the background. Pub brawl. Defendant went with a chair, and then this guy says he pushed him, but the state is saying he punched him. So what I'll do, right, I'm going to put this link because people could be joining us and saying, what's this about? What's this about? And I get it, but I can't stop it all the time. So what I'll do is I'm going to put this in the description box below, right? So in there, description box. So mods or anybody else, details of the case, it's in there. So people can either go there, post a link, or whatever. But it's in there now for anyone that does come and ask for a link. The older man is on trial. Older man is on trial. So the plan moving forward is, people will do as long as I can on this today, as long as I can, and then tomorrow we'll go to day 2 of, or whatever. I'll sort out tomorrow when it comes. I'll sort out tomorrow. I'm going to try and pull I cannot do more than 12 hours today. Just remind me, I cannot do more than 12 hours, which I don't want to do because that's 4:30 in the morning. No worries, Hackster. Hey, Hack. I've got 2 trials going. Hack, you go and enjoy yourself, Hack. You do not need to be here because, in fairness to you, you're tired. So go, leave. I'll see you soon, Erin. All right? I'll see you next week, my darling. Here we go. No worries. From VA. There we go. Right, everybody. Are we ready? So what I'm going to do... No, wrong one. Let me get that back. What do we do with a drunken... Dana, what do you do with a drunken sailor? What do you do with a drunken sailor? What do you do with a drunken sailor? Early in the morning. Oops. Dana used to be a sailor. Dana used to be a sailor. Dana used to be a sailor. So that is why I sing it. Right. Hang on. Okay. Stop screen. Let's go. Let us go. So what I've got it is on Fox 6 News, and basically they've cut it down. So the first bit we're going to watch is the opening statements and the first testimony. So hopefully they've all cut it down for us. And just to reiterate, I'm not promising we're going to get through it all today. All right? I'm not promising we're going to get through it all today. I'll try my best to keep going as long as I can. But I think there's about 9-10 hours before, closing statement. So we'll probably watch it tomorrow. Patricia, hello, my darling. How are you? Right, let's go, people.
We're reconvening after the lunch break. The court had distributed preliminary jury instructions to the parties prior to taking a break over the lunch hour. My intent would be to review the preliminary instructions with the jury immediately when they come into the courtroom prior to opening statements. Does the state have any modifications or objections to the preliminary instructions?
No, sir.
Does the defense?
No, sir. Thank you.
And in terms of the opening, is the state prepared?
Yes, Your Honor.
Will you need to utilize any media or any technology as part of your opening?
No, just the podium.
Thank you. Is the defense prepared for opening?
Yes.
And will the defense need to use any media or any technology as part of your opening?
Yes, sir.
Computer projection? You're going to use the computer to project?
Right, let me try it at 1.25. If this is too quick, people, I'll put it back to 1 normal, right? But let's try 1.25 to see if it is okay or not, right? If it's not, we'll go back to normal, right? So just tell me if you're struggling. I no way could we. I would play at 2.0, Lady Di. I would personally be playing at 2.0, but I know some of you struggle. And if Dave Hamburg was here, I have to play at 1 because he can't keep up with 1.25. So let's go with 1.25.
Verified that that's working?
You have it working. You checked this morning.
This morning we checked.
Okay.
You want to double check?
Sure.
Why don't we do that? I've directed that the jurors be lined up in the back hallway. It's going to take a minute. So let's just make sure that technology is working. It's not the first time that I've had it work in the morning and not in the afternoon. I don't know what that means, but it seems to be the courtroom.
I could skip some of this as well, so this is good.
There we
Is
go.
that right?
Yeah.
Have you tried? Is there any?
Jury coming in.
All right, please be seated. Well, welcome back, ladies and gentlemen. Before the trial begins, there are certain instructions that you should have to better understand your functions as a juror and how to conduct yourself during the course of the trial. Your duty is to decide the case based only on the evidence presented at trial and the law given to you by the court. Anything you may see or hear outside the courtroom is not evidence. Do not let any personal feelings about race, religion, national origin, sex, or age affect your consideration of the evidence. Do not begin your deliberations and discussions of this case until all the evidence is presented, and I've instructed you on the law. Do not discuss it.
Hang on. Let me get a volume up for you people, just in case. This is the loudest it can go, right? So if it's too loud, let me know, right? Oops. Because I know some people struggle. So mind your ears here now, right? It is being boosted. So because I know some of you might struggle a bit. Hello, Elsie. Nice to see you, by the way.
This case amongst yourselves, or with anyone else until your final deliberations in the jury room. We may stop or recess from time to time during the trial. You may be excused from the courtroom when it's necessary for me to hear legal arguments from the lawyers. If you come into contact with the parties, the lawyers, or the witnesses, do not speak with them. For their part, the parties, the lawyers, the witnesses will not speak with you. Do not listen to any conversations about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit any scene. Do not read any newspaper reports or listen to any news reports on radio or television about this trial. Do not consult dictionaries, computers, websites, or other reference materials for additional information. Do not seek information regarding the public record of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you were serving on this jury. Don't use a computer, a cell phone, or other electronic device with communication capabilities to share any information about this case. For example, don't communicate by blog or email or text message or Twitter or in any other way on or off the computer that I have no capacity to do myself. Do not permit anyone to communicate with you, and if anyone does so, despite telling them not to, you should report that to me. I appreciate that it's tempting when you go home this evening to discuss this case with another member of your household, but you may not do so. You can make Judge Domino the bad guy. Tell him he's people in your family that he's a meanie. He's a grouch, and he won't let me talk about it. People not serving on this jury have not heard the evidence, and it's improper for them to influence your deliberations and decision in this case. After the trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and to the taxpayers. You are to decide the case solely on the evidence offered and received at trial. Is there some kind of mechanical recording? I'm picking that up for some reason. Is it turned up? Can you turn it down? Evidence is first the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which I've directed you to find. Anything you may see or hear outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You, jurors, are the judges of the credibility of the witnesses and the weight of the evidence. You are not required to, but you may take notes during this trial, except during opening statements and closing arguments. I will provide you with the material. In taking any notes, you must be careful that it does not distract you from carefully listening to and observing the witness. You may rely on your notes to refresh your memory during your deliberations. Otherwise, keep them confidential. After the trial, your notes will be collected and destroyed. You will not have a copy of a written transcript of the trial testimony available for use during your deliberations. You should therefore pay careful attention to all the testimony because you must rely primarily on your memory of the evidence and the testimony introduced during the trial. During the course of the trial, the attorneys may refer to or use police reports with a witness. Normally, these police reports will not be provided to you. If you are not provided with a police report, you should use your collective memory regarding any reference to police reports. It's the duty of the jury to scrutinize and weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based upon a witness's race, national origin, religion, age, ability, gender identity, sexual orientation, income level, or other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during this trial which tend to either support or to discredit the testimony. Then give to the testimony of each witness the weight that you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things that people say to you. You should do the same thing here. The first count of the information in this case charges that the defendant, on or about Saturday, June 17th, 2023, at 111 East Capitol Drive in the village of Heartland, Waukesha County, Wisconsin, did cause the death of an individual identified as victim A while committing battery bodily harm. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charge beyond a reasonable doubt. When reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. The lawyers will now make opening statements. The purpose of an opening statement is to give the lawyers an opportunity to tell you what they expect the evidence will show so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. First opening statement will be given by the state. Ms. Zillaviv.
Thank you, Judge.
Good afternoon, everyone, and thank you for being here today on behalf of myself and the Waukesha DA's office. We thank you for your service for this jury. And as the court just said, this is a one-charge felony murder. And as the court just told you, I must prove those charges to you beyond a reasonable doubt. And just essentially what that all means is that this defendant, Kevin Sehmer, committed the crime of aggravated battery against the victim, in this case, Josh Davies, simply meaning he caused great bodily harm to Josh Davies. And as a result of that aggravated battery, as a result of causing him great bodily harm, Josh Davies died. That's essentially what this case is about. And it's really about what happened to Josh Davies that night. And the state believes that the evidence will show that the second Kevin Sehmer, this defendant, saw Josh Davies, he had it out for him. Kevin Sehmer was aggressive, both verbally and physically, for the very short time that Josh and Kevin were in contact with each other this night. And we believe that the evidence will show that this defendant punches Josh in the head, causing Josh to drop to the ground, hit his head on the concrete again, which ultimately led to Josh's death. And you will first hear testimony from Officer Tyler Martins, Heartland Police Department. He will tell you that this all occurred on Saturday, June 17th, 2023, a very classic Wisconsin summer evening. There was an outdoor concert at Beer Snobs down in downtown Heartland. Part of the street had actually been closed down. Officer Martins was there patrolling the area, and he'll explain to you where this area is, the general setup of this area in downtown Heartland, the bars around there, and he'll show you some maps, and we'll go through it so you can orient yourself to all the places. Towards the end of this night, June 17th, 2023, around 11 p.m., maybe a little bit before, Officer Martins, while he's on routine patrol, gets flagged down by a group of individuals on the sidewalk in front of Tabby's Bar and Hometown Pharmacy at 111 East Capitol Drive. And Officer Martins will tell you there was a male lying on the sidewalk. That male was Josh Davies. Josh Davies was surrounded by two different people, his wife, Jen Davies, who will testify, and his friend, Bryan Richardson, who will also testify. And essentially, there are 4 civilian witnesses in this case and some videos that will show you exactly what happened to Josh Davies that night and why he ended up laying on the sidewalk, which ultimately caused his death. And those 4 civilians are Jen Davies, like I just told you, the wife of Josh Davies, Bryan Richardson, the friend of Josh Davies, Laura Burke, a friend of Jen Davies, and someone completely unrelated to Jen, Bryan, Laura, and the defendant, John LaPorte. Now, Jen Davies and Laura Burke, they will tell you they've been friends for several years. Jen does Laura's hair. They will tell you they decided to meet up for this concert at Beer Snobs that night. It's an outdoor concert. Jen had come there with her friend, or with her husband, Josh, and Josh's friend, Bryan. They were out there enjoying the concert. And Laura Burke will tell you that she was out there, she was at the concert, and before meeting up with Jen, Josh, and Bryan, she was just walking around, talking to people. Eventually met someone she didn't know, but struck up a conversation with them. And that person was Kevin Sehmer. Kevin was there with his friend Tom. Laura starts talking to them. Kevin's kind of trying to set Laura and Tom up. And Laura will tell you she never met Kevin before this night. She doesn't know him, never met him before this night, never met Tom before this night. But they were talking throughout the night on and off outside at this concert. Kevin even puts his number in Laura's phone. Laura then connects with Josh, Bryan, and Jen, the people that she agreed to meet up with. And, they're outside, they're enjoying themselves, as I'm sure we all have on a Wisconsin night outside in the summer. Towards the end of the night, as the band outside is getting done, getting closer towards 10:30, 11 p.m., Jen, Laura, Josh, and Bryan, those four, decide to go to Tabby's Wine Bar. And again, Tabby's Wine Bar is in the same general vicinity as Beer Snobs. They walk to it, still in downtown Heartland. And Tabby's Wine Bar actually has video surveillance inside that is both audio and sound. And you will see on this video surveillance, Kevin Sehmer at the end of this bar, and you will see Jen and Laura walk in first from the back. And then you will see Josh, the victim in this case, and his friend Bryan walk in from the back. And they walk all the way across, and you will see on the video that they end up meeting at the end of the bar with Kevin. So now it's these five together in Tabby's Wine Bar. And you will also see in the video that other witness I talked to you about, John LaPorte. John was a musician playing at Tabby's that night, separate concert from the one at Beer Snobs. He has no relation to Mr. Sehmer, the defendant, no relation to Laura Burke, no relation to Jen Davies, no relation to Josh Davies, no relation to Bryan Richardson. Doesn't know any of the five people involved in this. And he was at the end of the night, and he was at the end of his concert, and he's packing up, putting his instruments back in his car. So he's kind of walking in and out of Tabby's is what you'll see. And what you'll also see in that video and what you'll hear from the witnesses is that almost immediately this defendant sees Josh and starts making comments about Josh and his tattoos, marking up God's work. And Jen and Bryan, they'll tell you, and Laura will tell you, they've never met Kevin before. They don't know why he's going in on Josh and tattoos. And they'll kind of tell you they thought maybe Kevin was just joking. They didn't think much of it. And you'll see after this initial interaction on that Tabby's Wine video between Josh and Kevin, Josh separates himself. Josh goes to a different side, separates himself from Kevin. Kevin continues to be aggressive with Josh. You'll hear on the Tabby's Wine video him say F you to Josh, go out there and practice falling down, saying that to Josh. And I want you to listen to Kevin's tone, Mr. Sehmer's tone when he does that. It's not a joking tone. You'll see his demeanor. You'll see him be aggressive with pointing. You'll see this on the video. And even during this second interaction between Josh and Mr. Sehmer, you will then see Kevin walk over to Josh, get in Josh's face, say, shut your effing mouth, pointing in Josh's face. Josh stands there. Josh doesn't, you're not going to see Josh make any aggressive moves toward Kevin in this Tabby's Wine video. John LaPorte, the musician who was walking in and out that you'll see in that video, will tell you how he heard the defendant making these statements towards Josh Davies that night, heard swearing, heard those things. Now, after Mr. Sehmer gets in Josh's face that second time, you'll see on the video, you're going to hear from Jen Davies, hear from Bryan, hear from Laura, that basically Jen kind of has Josh and Bryan leave the bar. It's towards the end of the night anyway. She kind of has them go outside. So yet again, you'll see Josh separate himself from Mr. Sehmer. Now, on the video, you'll see Jen and Laura. They're going to remain inside with Mr. Sehmer for a little bit. And eventually, you'll see Josh Davies on this Tabby's Wine video again, standing at the door. Doesn't go past the front door, doesn't come back into the bar necessarily. And he makes a comment to his wife, Jen, are you still talking to that a-hole? And this is when this whole incident really starts to happen. Like I said, in this video, you're not going to see Josh go beyond that front door. You're not going to see Josh come at Mr. Sehmer. You're not going to see that. You're going to see Kevin rush out directly towards Josh from the wine bar. You're going to hear from Jen and Laura. You're going to see on the video that Kevin pushes past Jen and Laura to try to get to Josh. You'll even see Laura try to grab Mr. Sehmer's shirt to keep him back from going outside. You'll see Jen standing at the door, that front door to Tabby's wine bar, to try to keep the two separated. And once Kevin goes outside, everything happens very quickly. Now, what happens outside on the sidewalk where this aggravated battery occurred, it's not going to be as clear as the video from Tabby's wine. You will see some video from Hometown Pharmacy. It's directly next to Tabby's wine bar. And Officer Luke Joswick with Heartland PD, he went and got the video from the owner of Hometown Pharmacy. Now, this actual camera is actually inside the pharmacy, inside the store, and it points out through the windows towards that sidewalk. And so the view from the Hometown Pharmacy video is going to be through the window, and you can kind of see some of what has happened between Josh and Kevin on that sidewalk. Again, it's not going to be perfectly clear, but you are going to see some things. And James Armstrong with the State Crime Lab, he's a forensic imaging specialist there. He enhanced the video in certain ways so that you can see better, so that you can see the parties better. And at the end, the state believes that that Hometown Pharmacy video will show Mr. Sehmer advancing towards Josh, Josh backing up as Kevin continues to approach him, and then Josh falling to the ground. And then you'll see Kevin walking away. Now, the four civilians, Laura, Jen, Bryan, John LAport, they're going to fill in what that Hometown Pharmacy video doesn't show clearly. Jen, Bryan, and John were all outside somewhere on the sidewalk, but in different positions, and observed the altercation, observed Mr. Sehmer advance towards Josh and hit him. They're also going to talk about how there was a stool involved. There were stools that were in front of Tabby's wine bar. You'll see them on some photographs, that there was a stool involved in that. And on the Hometown Pharmacy video, I believe you'll also see the stool fall to the ground when Kevin and Josh are advancing towards each other. Now, Laura, she was still there, but she was still inside Tabby's. So she did observe some of what would happen from their vantage point. And after Josh falls to the ground, Jen, his wife, will tell you that he was taken to the hospital. He was there for about a month, but ultimately he died from the injuries that he sustained on June 17th of 2023. Dr. Lynda Bidirzycka, hopefully I say her name right, but she'll clarify that for you. She's our medical examiner in Waukesha County. She's been the Waukesha County medical examiner for about 26 years now. She's also a medical examiner in Washington County. She has extensive training and experience on forensic pathology. She'll testify that she was the one that ultimately conducted the autopsy on Josh Davies. And she will tell you that Josh Davies died as a result of the head injuries from this night on June 17th of 2023. Now, Detective Paula Hoffa, she's sitting at the table behind us. She will also testify. She was called in that night to assist in the investigation. She was one of the lead investigators on this case. She learned that this defendant, Kevin Sehmer, was involved. And she even went to Mr. Sehmer's house that shortly after, hours after this incident. So the morning of June 18th, 2023, pounded on his door, tried to make contact with him, unable to. No answer from Mr. Sehmer. Other officers who were on scene that night, Officer Tyler Martins, he will tell you that they also looked for Mr. Sehmer that night to try to figure out what happened. Couldn't find him. Now, there's some things that the evidence won't show because there's certain things that the state doesn't have to prove. And one of the biggest things is exactly why Mr. Sehmer did this to Mr. Davies. The state doesn't have to prove why Mr. Sehmer committed this crime against Josh. Doesn't have to prove what his motive was. We just have to prove that he committed an aggravated battery against Josh Davies, and that led to Josh Davies' death. Why Kevin got so mad at Josh from the beginning, that might not be an answer that we have. But I also want you to remember, that's not necessary to finding out if the defendant committed this aggravated battery, which resulted in Josh's death. What the state believes that this evidence will show through the witnesses, through the videos that you're going to see, is that this defendant violently attacked Josh Davies that night, hit Josh, causing Josh to drop to the ground, hit his head on the concrete, and ultimately led to his death. And at the end of the case, DA Opper, she'll come back up here. We'll ask that you find the defendant guilty of the sole count of felony murder. Thank you.
The next opening statement will be given by defense attorney Shiro.
Thank you.
This case is about somebody trying to hit my client with a stool. And my client stopping this person from doing so by stopping the momentum of the stool as it came rushing towards him as a result of Mr. Davies' actions. Videos actually tell us a lot more, I think, than what the state is suggesting. A lot more. While I have seen more clear videos, more clear movies, I've seen movies that I've made that were better than this, but they're going to tell us something fairly important. Now, it is true that my client and Mr. Davies got into a stupid argument that was mostly, quite frankly, my client's fault. I mean, it was stupid. And you're going to see that, as counsel said, she wasn't wrong. My client was weirdly angry about this tattoo that Mr. Davies had. I don't know why he cared so much, but it seemed stupid, seemed not really appropriate, quite frankly. And at some point, my client goes and pokes his finger at him, calls him a name. And at some point, his wife, Jen Davies, suggests and kind of tells Josh and his friend to leave. Not suggesting that she did that because she was thinking her husband had done anything wrong. She just thought, let's separate us. But this argument ended then, okay? That it was over. What you're going to see is that not only was it over, but my client was actually talking with Mrs. Davies and with Laura Burke, and they were having a very friendly, quite frankly, discussion. Such though that at some point my client appears to be kind of hugging both Ms. Burke and Ms. Davies. This is what happens at about this. It's already left. That is, Josh is already left.
It's a pussy.
Can you just step for 1 second? On the left is Ms. Davies. On the right is Ms. Burke, the two women that my client's the big guy behind them, and he's talking to those two. Okay?
I needed a seat. Maybe you guys are later. 20 years. 20 years. Maybe you're taking it. Maybe you should make
I'm certain
Maybe she's
don't take it. What did you say?
We just saw in that upper left corner, that was Mr. Davies. He came back in. This argument was over. In fact, you just saw, and the evidence will show, that my client was kind of hugging Ms. Davies and Ms. Burke. And Josh came in and yelled some profanities because he appears to be angry that his wife is still talking to Mr. Sehmer, and perhaps that Ms. Burke is still talking to Mr. Sehmer. And then my client goes out that door and yells and says something like, "What did you say?" and then runs out. That's what happened. Okay. Now, Mr. Sehmer, when he goes outside, go ahead. You're going to see that he's obviously upset. Jennifer Davies and Laura Burke try to go outside, and they go outside. Now, Ms. Davies is going to tell you, Josh's wife, that her husband picked up a stool, put it over his head. That's what they say. And Ms. Burke sees things. She says, Ms. Burke, remember there was the two ladies, there was Ms. Davies and Ms. Burke. She says, "I saw through the window that Josh had a chair raised above his head to hit Kevin as he approached." Okay? This is really what happened. And further, that Ms. Davies says her husband picked up a chair and stood to defend himself. So I know the state has told you that my client, poked his finger and was being kind of obnoxious, and he was. What he didn't do is try to pick up a stool and hit somebody with it. He used words, or he poked his finger. That's a lot different than somebody picking up a stool and going after somebody. Now, so we have the two principal witnesses, I think, are going to tell you that when my client went outside, after Josh, decided that he was upset that my client was having a friendly conversation with his wife and Ms. Burke, he decided he was going to make this physical. Go ahead. And the video is going to show you something. I want you to see this, but if you could just stop for a second.
What you have to do, really, ladies, this is that, and gentlemen, this is the photo through the pharmacy, okay? If I had a good little pokey thing, I could show you that. What you're going to see is two people are moving from right to left. And the witnesses, either the officers or a number of people will say, look, from the right is the door to Patty's, okay? That's where both Josh had gone out, came back in and yelled, and then left. And Mr. Sehmer is coming out, okay? From right to left. Go ahead. Stop. That's Mr. Davies backing up, okay? And it probably would have been a little harder, but you could have also been able to see Mr. Sehmer, a larger person with a white shirt. Go ahead. Now look, stop. Did you see that video just showed you Mr. Davies?
No, Jack, that's argumentative and for closing, Your Honor.
He says this is opening. It's intended to demonstrate what each side thinks the evidence will show. The court overrules the objection. You can continue with the opening statement.
Thank you. Obviously, it happened kind of fast. I won't back it up. But what you saw, and when you see it again, in various configurations, by the use of law enforcement and the state crime lab and trying to make this, you're going to see one thing that's clear in every single one. That as my client and Mr. Sehmer are both moving from right to left, Mr. Davies launches himself at Mr. Sehmer. And remember,
his wife has told law enforcement, and Ms. Burke told law enforcement, that he had a stool above his head to attack my client. The only violent act that was shown, that will ever be shown to you in any of the videos, is not my client going after Mr. Davies, but Mr. Davies lunging with a chair in his hand at my client, and that he then goes down. Now, and when I say goes down, I don't mind to minimize this, because it is Mr. Davies' fall to the concrete that caused his death. Now, I understand that there's at least a couple witnesses who claim that it was my client punched him, but the video evidence will be uncontroverted that it was actually Mr. Davies moving towards my client. And that the evidence, I think, will establish that Mr. Davies fell to the ground for three reasons that are, I think, sensible, logical, and irrefutable. First, Mr. Sehmer stops Josh from hitting him with the stool that he's got in his hand. That, if we look at, actually look this up, Newton's law, third law of motion. Act the code. The causes force will be met with resistance, and they sometimes are equal, sometimes they're not. So if somebody tries to hit you with a stool, and that person is able to stop that momentum, that motion, that energy has to go somewhere. And it's going to go into Mr. Davies, who then falls down. That's one reason. The second reason is that in another video, and we won't do it all now, but later, you're going to see that it appears that Mr. Davies actually is tripping as he is jumping, launching himself towards Mr. Sehmer. That's another reason that we see him falling. And thirdly, you're going to find out that Mr. Davies was grossly intoxicated. Not a little intoxicated, grossly intoxicated. You are going to find from the evidence of both the medical examiner as well as Dr. Ronald Henson, who I'm going to call, that the medical records show that Mr. Davies, when he went in, his blood alcohol level was somewhere between 2.4 and 2.67, depending upon whether the alcohol testing was done by serum or whole blood, and neither know exactly. So there's a range. But the minimum range is over, I think, 2.4 or 2.2, and as high as 2.67. And Dr. Henson, who has been working in this field involving alcohol testing and alcohol and arrests, he was a former police officer. You will learn his credentials on how he deals with people with alcohol and drug issues and their impact on people. And he's going to tell you what, quite frankly, all of the nurses and medical people on this jury know, that when somebody gets really drunk, not a little drunk, when they get well over 2.0, their ability to move, to coordinate, to keep themselves in position as they're launching themselves at somebody is impaired. So this person who tried to attack somebody may have fallen over a stool and was also very, very drunk, fell to the ground, not because of a battery, but because he tried to attack my client. My client may have been acting like a jerk, but you can't attack a person with a stool. And remember, this was, as the evidence indicated, this argument was over. Now, as you're going to learn, as you probably aren't surprised, is that my client, as does every person, has a right to defend themselves from an unlawful interference. Sometimes that might be kind of vague in terms of, well, what interference are we talking about? That's not really a circumstance that we have to concern ourselves too much here. Because the interference is, you don't get to hit me with a stool, a metal stool, by the way. You don't get to do that. I don't have to take it in the face because I said I was mean to you earlier in the night. You have a right to prevent that. And you have a right to put up your hand and stop yourself from being struck. And that's an unlawful interference. You don't get to hit somebody with a stool. And again, this isn't, my client saying he hit me with the stool. This is Ms. Davis saying that he did that. Ms. Burke said he did this. And it is fast. Okay. The evidence will show that this whole incident goes very, very quickly. Okay. And it is terrible because, somebody hit their head. But he didn't hit their head because my client battered him. And the judge is going to tell you that if my client is preventing somebody from interfering, as Mr. Davies was by trying to hit him with a stool, not only does the state have to establish that there was his battery, but that my client didn't do so, exercising his right of lawful self-defense. In other words, they have to prove that he didn't have the right to do that beyond a reasonable doubt. And we don't get, and you don't get to, when you're examining the evidence, think, well, how would I have reacted today? No, it's at the time of the event. That's when you look. Was he acting reasonably in stopping this person from hitting him with a stool? I would say at any time anybody can do that, but the government has to disprove this. And I think when you're done and you look at these videos, and unfortunately, you're probably going to see these videos numerous times because law enforcement, as counsel indicated, did some efforts to try to make it more visible. And the more clearly we get this, the more clear it is that Josh Davies fell while trying to attack my client. And he fell because he was trying to swing an object, which my client stopped. He tripped, perhaps, and was exceedingly drunk and couldn't do that without falling down. And I'll be asking that you find that he properly exercised his right to defend himself and that you'll find him not guilty. Thank you.
Stay prepared with this first witness.
Yes, the state calls Officer Tyler Martins.
Officer Martin, would you come forward, please? Witness stand is behind the court reporter. Step up there, raise your right hand. You swear the testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God.
I do.
Have a seat. Black bar with a red light is a microphone. I'd ask you to keep your voice directed to it. Right. Can you hear the level of my voice?
I can.
Yes, that you keep your voice up so we can all hear you. Counsel, this is your witness.
Thank you, Judge. And we will be using one of our computers at the back table. So
you want it switched over?
Yes, Your Honor.
All right.
But I can continue with questioning. I just wanted.
Yeah,
your
I think we've done it. Go ahead.
Got it. Officer Martins, how are you employed?
I'm employed with the Village of Heartland Police Department as a police officer.
How long have you been with Heartland? PD?
Approximately 2 years.
And what are your general duties or what's your role?
I work routine patrol.
Okay. And do you have a certain shift that you work?
I worked third shift and just switched to second shift.
What's third shift? What time?
Third shift is 10 p.m. to 6:20 a.m.
And second shift?
Is 2 p.m. to 10:20 p.m.
So you upgraded to second shift?
I did.
Okay.
Yeah.
And in order to become a police officer in the state of Wisconsin, did you go through the basic police academy?
Yep, I went to a police academy and I graduated and started patrol a week after.
And where did you go to the police academy?
Waukesha County Technical College.
And what year did you graduate?
I graduated in 22.
After you went to the police academy, did you become a certified law enforcement officer?
I did.
And since your graduation in 2022, have you maintained being a certified law enforcement officer in Wisconsin?
I have.
Okay. Now, I want to draw your attention to Saturday, July 17th of 2023. June. I apologize. Thank you. June 17th of 2023. Were you working as a Heartland Police Department officer at that time?
I was.
And were you working third shift?
Yes.
Okay. So that night, were there any festivals or outdoor concerts going on?
There's a little festival that one of the restaurants downtown holds. It's called Snobs Fest. It's ran by Beer Snobs, which brings in a concert and a decent sized crowd.
And Beer Snobs is located on what street?
It's on Haight.
On Haight.
Which is right off of West Capitol and Conwood.
Okay. And was Haight Street closed down at all for this festival?
Yeah, because that's where they set up a concert and the whole stand is the road shut down
Okay.
for that part.
And so I want to bring up exhibit number 1. So are you able to see exhibit 1 on your screen right now?
Not yet.
Nope.
Just a minute. It's up.
Okay. And do you know what exhibit 1 is?
Yeah, that's a overview of the location. It's got West Capitol Drive and then East Capitol Drive.
Okay.
And then Haight Street's on there as well.
And is that a fair and accurate map of that area?
It is.
I would move exhibit 1 into evidence and request to publish to the jury.
Any objection?
No.
Exhibit 1 will be received. You may publish. Ladies and gentlemen, just tell me if that's in your jury box. I'm going to hope that that's the way it's going to work the whole time you're here with me. Go ahead.
Thank you, Judge. So let's first start off with, let's point out, actually, can we zoom in a little bit, Ms. Gussie? One more out. Okay. So first of all, you're able to draw on the screen in front of you. So can you circle on there where Beer Snobs is that we just talked about?
I just circle right away.
Yep. Okay, and that's kind of in the bottom left corner of the map.
Yep.
And Haight Drive, where you said that street was closed down, where is that? Can you just draw a line?
Probably about there, give or take.
Okay, so where you drew that line, is that how far the street was closed down?
It was closed from Cottonwood or West Capitol to Goodwin because the stage was right in the middle of the street.
Okay, and what about Tabby's Wine Bar? Where is that? Can you circle that on the map? And back in June of 2023, where was Hometown Pharmacy?
Right down.
Okay, so we have Tabby's Wine Bar and then directly west and next to is where Hometown Pharmacy was.
Right.
So if somebody was at Beer Snobs at this concert, what are the different ways they can get to Tabby's Lake Country?
So there's a few different ways. They could either go from that corner of Conwood and Haight Drive and then walk up West Capitol to East Capitol and then just cut across on the front side. They can cut through between the building with 110 on it.
You can, if you want to draw a line,
Okay.
how you can get there.
So they can cut through from Haight up through here and then go down the sidewalk to Tabby's. Or they could come here off this road. It's kind of like a parking lot back there. And then access to the backside of Tabby's in the patio. Or they could go around like on Haight Drive and Goodwin, go up Goodwin, go north on Goodwin, and then west on East Capitol.
A lot of different ways, back way, side way, every way you can think of, right?
Correct.
Okay, so let me bring up another map just for you.
Just a minute.
Oh, actually, can we take a screenshot of
Request
this?
to preserve. This will be Exhibit 1A.
Yes, Your Honor.
Any objection?
No.
Exhibit 1A will be preserved. All right, counsel.
And we can take that down now.
All right. Turn the publication off. Thank you.
I'm going to bring up with you exhibit number 2. And that should be on your screen soon.
We just have a little delay. There it is. It's up.
Yep.
Okay. Officer Martins, do you recognize exhibit 2?
I do.
And what is exhibit 2?
So that's a street view from East Capitol Drive to the front side of Tabby's and where the old hometown pharmacy used to be.
And this is 11 East Capitol Drive in the village of Heartland, Waukesha County, Wisconsin.
Correct.
Okay. And that's fair and accurate depiction of it?
Yes.
Request to publish exhibit 2.
Moving its mission.
Moving and then requesting to publish.
Any objection?
No.
Exhibit 2 will be received. You may publish.
Looks like the jury is staring at something, so I assume it's on their screen. And so, first of all, which one of these buildings that we see here is Tabby's?
This one here.
Okay, so it has black and white awning stripes.
Yep.
Okay. In the front there, are there any stools and tables?
Yeah, on the sidewalk, there's stools and tables.
And right directly next door in a building that looks like it's connecting to it, what is that? At least back in June of 2023, what was that?
That's the hometown pharmacy.
And can you draw a circle around there? Okay. And I would request to preserve and mark as exhibit 2A.
Any objection?
No.
2A will be preserved and received. Next question.
Thank you. Now I'm going to ask that the publication come down. I'm going to show you exhibit number 3. Okay, do you recognize exhibit number 3?
I do.
And what is that?
It's the backside of Tabby's, so your view from Haight Drive.
Is that a fair and accurate depiction of
Yes.
the back of Tabby's and from Haight Drive?
Yes.
Okay. I would move exhibit number 3 into evidence and request to publish.
Any objection?
No.
3 will be received. You may publish.
Okay, and just on here, can you circle, actually, can we go one zoom in, Ms. Gussie? Okay. So I see that there's like a purple sign. Do you know what that says?
Yeah, that's a sign for Tabby's. It's on their back balcony.
And is this one of the ways you can get into Tabby's wine bar?
Yes.
And that's kind of the back way that you described previously on the map?
Correct.
And then next door, that building that looks like it's connected to it, what is that the back of?
The hometown pharmacy.
Okay. And again, is there, for Tabby's wine bar, there's a door back there, right?
I believe it's covered by this tree right here.
Okay, so you have a pink arrow, but kind of difficult to see, but
I didn't mean to do that.
that's okay. I would just ask to preserve exhibit 3 as it is and make it 3A.
Any objection?
No.
3A will be preserved and received. Next question.
Okay. And now we can take that publication down. I'm now going to show you exhibit 4. And do you see exhibit 4 on your screen?
I do.
And what is exhibit 4?
Well, that's the front side of Tabby's from East Capitol Drive.
And was this picture taken the night of June 17th of 2023?
Yes.
That's a fair and accurate depiction. Is that true?
Correct.
I'd move exhibit 4 into evidence, Your Honor.
How many more photographs of this area do you have to go through?
After this one, too.
Do you want to just have him identify the next 2 exhibits? So,
Sure.
That might expedite it.
Exhibit number 5, you can bring up. Okay, and you see exhibit 5 on your screen?
I do.
And what is that?
That's another view of Tabby's. It's from the east side, I guess, east view, showing the sidewalk in front of the building.
Okay, and hometown pharmacy would be in the back of this photo, right?
Correct. You can see the back corner of it.
Was this photo also taken the night of June 17th, 2023?
It was.
Actually, is your squad car in this photo as well?
This is my lieutenant's squad car.
Okay.
Yeah,
That's a fair and accurate picture.
it is.
Okay, and lastly, I'm going to show you exhibit 6.
That's the view from the west looking east. It's the front side with the sidewalk and the bar stools and tables as well.
So now, from taking this photo, this is from taking it almost in front of hometown pharmacy and looking towards Tabby's.
Correct.
And that's also a fair and accurate picture?
Yes.
Move exhibits 4, 5, and 6 into evidence and request to publish.
Any objection?
No.
Exhibits 4, 5, and 6 will be received. You may publish.
Start with exhibit 4. So, like you said, this is Tabby's wine bar. And again, out in front, it looks like there's stools and tables. Is that right?
Correct.
Okay. And can you just circle those on here? So there's several. And those were there that night when you arrived on scene?
They were.
Okay. I would request to preserve 4A and move into evidence.
Any objection?
No.
4A will be preserved and received. Next question.
Okay, exhibit 5. And again, we see Tabby Wine Bar, and then in the back would be Hometown Pharmacy where we can see more lights.
Yep.
Is that right?
Yes, correct.
Okay. Tabby's looks pretty dark. Is that how it looks in here?
Yes,
And then the lights that we're seeing, those are street lights and maybe coming from Hometown Pharmacy.
correct.
And exhibit 6. And this is just from the other side of Tabby's as if we were standing in front of Hometown Pharmacy. Is that right?
Correct.
We can take those down. So around 11 p.m., you were on routine patrol in your SWAT car, is that right?
I was.
Okay. Around 11 p.m., did you get flagged down by a group of people in front of Tabby's Wine Bar?
Yes.
And tell me, what did you see?
So I was traveling north on West Capitol Drive at that intersection of West Capitol Drive and East Capitol Drive. When I stopped at the intersection there, I turned to check for traffic on East Capitol Drive and saw a fairly large group of people waving their arms in an attempt to flag me down. So I advised my dispatch of the situation and drove over in that direction.
Okay. And what did you observe when you drove over by that group of people?
When I drove over there, I immediately got out of my squad car because obviously something was going on. When I exited my squad car, there was, like I said, a fairly decent sized crowd. And I had people telling me that something just happened, some guy just got hit. I have information coming from a lot of people.
Judge, excuse me, I'm going to object to him testifying to what people told him.
On grounds?
Hearsay.
Sustained.
What did you see? That's what I want to know.
Judge, I move to strike that portion of his answer. That you object, whose objection?
I sustain the objection and the record will stand. Next question.
What did you see around this group of people?
I saw the victim laying on his back. That he was not moving. I saw that he was breathing, and I saw a male and female standing or crouched down next to him, tending to him at that time.
Who is the male laying down on the sidewalk identified as?
Joshua Davies.
And you said that there were 2 people surrounding him. Who were those 2 people?
They were later identified. The female was identified as Jennifer Davies, and the male was identified as Bryan.
Bryan Richardson?
Yes, yes.
Okay.
One of their friends.
And once you saw this, you took, not asking what they said, but did you gather some initial information from these witnesses?
I did.
Okay. And what did you do next?
I advised our dispatch of what had just occurred. I notified them that there was a fight, that the victim got punched in the face by an estranged man.
Just a minute. But he objects. Is there an objection, sir?
Yes.
So say the word objection.
Objection, hearsay.
Thank you.
It's foundational, Your Honor. It's not hearsay. It's not being used.
Offered for the truth.
Right. It's just to say what he did next so people can understand.
Court is going to allow the characterization for purposes of foundation. I'll overrule the objection. Witness can continue the answer. Do you recall the question?
Can you just give me the question one more time?
Okay. So you saw people lying on the ground, and what did you do next?
So I advised our dispatch that there was a fight that just occurred, and that a male had fallen to the ground due to being punched in the face, causing him to go unconscious. And then I had additional units respond to the scene because I had seen and heard that the suspect was no longer on scene, and we needed to attempt to locate him.
And from these witnesses, did you get a description of the suspect?
I did.
Okay. And what was the description?
Description was a male white, approximately 60 years of age, glasses, heavier set, wearing a white and blue striped shirt and jeans.
And did you relay that information to dispatch?
I did.
Okay. Now, did you remain on scene by Mr. Davies at this time?
At this time, yes.
Did any other officers do anything else that you're aware of?
My patrol lieutenant, Conrad Saboniak, he arrived on scene. The information was relayed to him from myself and another witness. And then he went and checked the area for the suspect.
And then did you go and focus more on Mr. Davies and Jen Davies and Bryan Richardson?
I did.
Now, during this time, while you're calling for your lieutenant to go look, you're calling in dispatch, did you ever see Mr. Davies get off the ground?
No.
Okay. Did you go over by Mr. Davies?
I did.
And did you try to talk to Mr. Davies?
I did.
Can you tell me what you observed Mr. Davies to look like at this point?
At this point, I went over by him. I tried to see if the people identified as Jennifer and Bryan were comfortable staying by him. I observed that his eyes were closed, but he would open his eyes every once in a while. His body movements were minimal. And I did see that he was breathing. I attempted to ask if he could hear me. I couldn't get a verbal response from him, but I did see him attempt to open his eyes. And then I tried a sternum rub, which is an attempt to, have somebody react to the pain. And his body didn't react, but once again, his eyes did open.
And for a sternum rub, can you kind of demonstrate what you're doing on yourself, maybe?
Yeah, so you're like taking your knuckles and you're just rubbing on the sternum up and down like this. And like I said, that's supposed to make somebody react to the pain because it does cause a little bit of pain.
And how did Mr. Davies react when you did that?
He just opened his eyes. He didn't verbally say anything or like try to move my hand off of him. He just tried to open his eyes.
Now, you said that, were you ever able to talk to Mr. Davies?
No.
Okay. Did you ever get a statement from Mr. Davies?
I did not.
You said that Jennifer Davies, his wife, was around him. Is that true?
Yes.
What was her emotional state?
She was frantic. You could tell she was in distress. I mean, rightfully so. There's really no words for it. She reacted how anybody should in that situation.
And while she's in this emotional state, did she say anything about what occurred?
She said that he got punched in the face and he fell down. The punch caused him to go unconscious, which made him fall to the ground.
Counsel approach. Behind.
Okay, first sidebar. Let's have a look. We could skip it, you see, so. The beauty of watching a trial, not live. Sidebar. No worries, Ernie. Nice to see you, buddy. Pop back in any time.
Did you call for any ambulance or EMS to arrive to the scene?
I did.
And was that for Mr. Davies?
Yes.
And eventually, they arrived on scene. Did they take Mr. Davies away in the ambulance?
They did.
Okay. During this time, did you ever personally go and look for the suspect in this case?
Yes.
And where did you go to look for the suspect?
I went through the building. Well, I looked inside of the bar first, or inside of Tabby's. I want to make sure he wasn't still in there. Nobody didn't say anything. And then I went around the buildings through Snobs Fest, which was that festival that I talked about earlier. I went all the way down Haight Drive and could not locate the suspect.
Okay. And you had your squad car there?
I did.
Was your squad car equipped with squad video?
Yes.
And did it at least capture this initial scene that you had arrived at?
Yes.
That's fine. Okay. Yeah.
Ms. Gussie, if you could please bring up exhibit number 7. Okay, Officer Martins, do you see on your screen exhibit number 7, which is a squad video?
I do.
And does this look like it's from your squad, Squad 3, the night of June 17th of 2023?
Yes.
And that looks like a fair and accurate depiction of it?
Yes.
And have you reviewed your squad video before coming here today?
I have.
Okay. And I'm going to move exhibit number 7 as evidence. I don't plan to play it with sound, Your Honor. But it'll just be a short clip of the scene.
Any objection?
No.
Exhibit 7 will be received.
And just to confirm with Ms. Gussie, the sound is off.
And you're asking for it to publish?
I'm asking to publish, Your Honor.
Any objection to that?
No.
You may publish.
Okay, and I'm going to wait. Okay, I'm going to start exhibit 7. Actually, Ms. Gussie, can you go back? It's at 01. And prior to us playing this, Officer Martins, do you see yourself in this video?
I do. I'm on the sidewalk.
It says police on the back. Is that you?
Correct.
Okay. And where's Mr. Davies?
Where I'm first standing here, you can see his feet pointing towards me. His head's kind of towards the corner of Hometown Pharmacy and Tabby's.
Okay, and looks like somebody's crouching next to him. Who is that?
That's Jennifer.
There's a guy in a white shirt standing by that pole. Do you know who that is?
I do not.
Okay. Can you kind of see Bryan?
Yeah, you can see the corner of his red shirt, and his foot in this picture.
Okay. And if we could just start playing. Just going to stop it for 1 second, and we stopped it at 45 seconds. I see somebody in a car in front of you that just opened the trunk. Do you know who that is?
There was a musician that was playing inside of Tabby's that night.
Okay. And we can continue at 45 seconds. I'm gonna stop it at 1 minute and 50 seconds. Are you talking to another squad car? Another person in another squad car?
That is my Lieutenant Conrad Saboniak.
So are you relaying? What are you talking?
I relayed the information that I gathered so far along with the suspect description so he could go try to attempt to locate the suspect.
Okay. And continue playing at 1 minute and 50 seconds. That's the end. It was a total of 2 minutes and 36 seconds. And that was a fair and accurate depiction from that night.
Yes.
We saw that you were talking to two women who had kind of followed you to your lieutenant's squad car. Who were those women?
They're both bartenders inside of Tabby's that night.
And they gave you a description of the suspect?
Yes.
After the scene had calmed down and the ambulance took Josh away, where did you go?
I ended up following the ambulance to Summit Hospital.
Aurora Summit Hospital?
Huh?
Aurora Summit
Yes.
Hospital? Okay. And did you stay at the hospital?
I did.
Did you also get a written statement from Jennifer Davies at that time?
I did.
While at the hospital, were you ever able to speak with Josh Davies?
No.
Were you ever able to get a written statement from Josh Davies?
I was not.
Did you see Josh Davies at the hospital?
I did.
Was he awake?
No.
I don't have any further questions, Your Honor.
Cross.
Just could we be criticized out the minutes?
Yes.
Yes.
You finished your schooling back in 22, is that right?
December of 22, correct?
Okay. And I presume you've had some training since you became a law enforcement officer?
Yes.
And you received training while you were studying to become a police officer, correct?
Correct.
And one of the things that you are trained to do is prepare reports regarding abuse. Is that true?
Correct.
Okay. And it's my understanding that you prepared a report in conjunction with the investigation. Is that right?
Yes.
Have you seen it?
Yes.
Okay. So I'm going to look at a portion of it. And where you indicate that you received a written statement from Mrs. Davies. You did that, right?
Correct.
In fact, you actually, seems to me, typed out what she wrote in her handwritten statement. Is that correct?
Correct.
And they're basically word for word. Do you agree?
Yeah. Yes.
So, and you would agree that in neither her handwritten statement nor your recitation of it in the report, does she say that Mr. Sehmer punched her husband? Isn't that true?
I don't recall what was exactly in my report.
I can show it to you.
Okay.
You may.
Do you see this? Take a moment to look at it. Am I right?
Correct.
So in her statement, she doesn't say, either in her written statement or your typed version of it, that she saw Mr. Sehmer strike her, punch her husband in the face. True?
Correct.
And she had both an opportunity to talk to you and to write out the statement, correct?
Correct.
And that was, I think, that night?
Yes.
Okay. All right. And I saw in the squad video that it appeared that Mr. Davies' feet were to the west of his head. Am I right?
Yes.
So his feet were closer to hometown as opposed to the entrance of Davies, correct?
Correct.
All right. Now, I presume that in your law enforcement experience, you've had to deal with people who have had too much to drink.
A few times.
Okay. You made any arrests for drunken driving, for example?
Yes.
How many times?
An objective relevance.
Overruled, it's foundational.
On the road,
Anywhere.
approximately 30.
Okay. So on approximately 30 times, and I'm not holding you to this, on approximately 30 times, you've had occasion where you were taking law enforcement action to determine whether a person may have had too much to drink, correct?
Yes.
And I presume that because you've made stops and perhaps arrests for drunken driving, you had opportunities to try to determine the condition of a person. That is, have they had too much to drink, correct?
Through standardized tests. Correct.
Right. And those tests, those standardized field sobriety tests, include tests which says that persons who have too much to drink have difficulty doing, having good coordination. Would you agree?
Yes.
That's pretty normal, correct?
Yes.
And while you're not a physician, your experience would tell you that persons who have a really high BAC are going to have even more pronounced inability to exercise coordination, correct?
Correct.
All right. I have nothing further, but thank you.
Any redirect?
We just talked about how you would do field sobriety tests on somebody who was intoxicated. Were you able to do any field sobriety tests on Josh that night?
No.
Why not?
Because he was unconscious and unresponsive.
And the suspect, if you learned that he was intoxicated, would you have done field sobriety tests on him potentially?
Judge, I'm not objecting to that.
Overruled.
If he was driving and I had reason to believe that he was impaired, I would perform the test.
Okay. And now, Mr. Hero showed you part of your police report. I think it was page 2, and it described Ms. Davies' written statement.
Yes.
And he asked you if anything on page 2 said that she said that the male party had punched Josh, right? That's his line of questioning.
Yes.
I'm going to show you the first page of your report.
No. Counsel, that's what it says. I don't mean that. I know what he wrote.
Ladies and gentlemen, I'm going to ask you to retire to the jury room, take a break. We're at 3 o'clock. It's a good point to stretch your legs. I'll have you back here in a few minutes. Please do not discuss this case.
All rise.
Hot mic. Hot mic. Counsel, I got excited there. I love that shit.
Court will stand in recess 10 minutes.
Okay, then recess. I'll fast forward that. I love that shit. Let's fucking go with that kind of stuff. Hot mic. Council? That is not what. Hot mic. Hang on. I'll skip it. Let me go back a second. You can listen to it again. It was amazing.
No, she does say it. She is. Council, that's what it says. I don't need that. I know what he wrote.
Ladies and gentlemen, I'm going to ask you to.
I love that shit. Hang on, Annie. Here we go. I'll just go in and skip ahead the break, so we'll get back to it. As I do that, listen to this. Press the like, press the like, press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Like and subscribe, everyone. Let's fucking go. So please like and subscribe. Here we go. They're just back from the break, and here we go, people. Let us go.
A couple of things for the record. There was a question that was asked of the officer soliciting information offered through a witness that was represented to be the spouse of the victim. The question was, did she tell you, or what did she tell you, meaning the spouse of the victim? The witness, the officer, answered, among other things, that the defendant punched her husband in the face. There was objection based on hearsay. Court held a sidebar. I informed counsel that I felt the objection was tardy, that the question had been posed soliciting the information. It wasn't until the information was offered that it was objected to. Based upon that, I overruled the objection. I held it at sidebar because we have a difficulty currently with the fact that the jury is being housed when they're not in the courtroom, not on this floor. And so I'm trying to minimize the amount of movement that occurs for this jury because it involves some involved process and delay, which is why I chose to do sidebar, informed the parties of what I was going to decide, because I did not want to have argument in front of the jury as to the substance. So when I released the parties back to their place, I indicated the objection was overruled and I asked them to move forward. I also had instructed the state at that I felt they were asking for information that could be substantively hearsay. They had my impression at the sidebar complaint about that they felt they could meet a burden regarding excited utterance. I informed the state that these issues could have been dealt with in pretrial. They were not raised. I'm not going to deal with them in that fashion here. So that was the decision that I made. That's the record I'm making regarding that decision. Are we ready to proceed?
I would note that there is disagreement about what the state can show Officer Martin's on the stand. So the line of questioning was, Mr. Shiro showed Mr. Martin's his report saying, this is word for word the written statement Ms. Davies gave you. Nowhere in here does it say in your report that Ms. Davies said Josh was punched in the face. The state's contention is that in order to rehabilitate Officer Martin's, because it is in his report on page 1, and I can bring it up for the court to show you, his report says, Jennifer, Ms. Davies, recognized the witness that was there and said to her, that guy, your friend, just hit him in the fucking face. That's also in his report. And it's quoted, or that guy, your friend, just hit him in the fucking face. That's a quote. Now, Mr. Shiro disagrees that that was a statement that Ms. Davies made. He thinks it's a statement the witness made. I have a squad video that shows that was a statement Ms. Davies made. I believe that the state can rehabilitate Officer Martins and show him that part, since the defense brought it up that his report did not contain a statement from Ms. Davies that her saying.
I understand the state's position. Mr. Shiro.
Judge, I object. First of all, we don't really have a context other than that. I'm sorry. She, being Ms. Davies, is talking to some other person. We don't know who. I understand that the state contends that that would be.
Stop it. I'm going to tell both of you right now, despite the representation that you're all going to get along, you're bickering like school children. And that is not happening in my courtroom. So you're going to limit that particularly when this jury is here, or I will call both of you up short. Am I clear?
Yes.
Am I clear?
Yes, sir.
Continue with your argument.
Thank you. So I don't think it's a rehabilitation. What I'd asked the officer about was his report regarding Ms. Davies' statement. And he read it and he didn't remember it. So I let him read it. And he said, yes, she doesn't say that in that statement. I don't think calling in further hearsay is somehow is allowed, because I asked the officer about his report regarding the statement that he obtained from Ms. Davies.
This all stems from the objection that I deemed to be tardy.
Right.
And the information is in the record. You attempted to impeach him based upon that information. You opened the door as to the police report. The state has a right to try to use it to rehabilitate. If you feel it isn't relevant or isn't her statement, those are questions you can ask this witness in further cross-examination. But for purposes of today, the court's going to allow the question to be asked because the report has been discussed regarding refreshing this witness's recollection as to what was in his report. I recognize you said in his written statement, but you used the report as the basis for refreshing his recollection regarding that written statement. I think it opens the doors to that report and the usability of it. And the hearsay aspect of it was already dealt with by me. So whatever objection you're interposing here is overruled. The state can use it. Is there anything else that the state feels I need to address before I bring the jury back?
No, Your Honor.
Defense.
No.
Thank you. Would you get him, whoever's calling? Is it bailiff? Thank you.
I fucking love this shit. Oh, Judge, lose your shit, Judge. Lose your shit, Judge. Lose your shit. I love that crap. Like, I know it's cringe, but I love it. Right, hang on. Let me go back. I think let me go back a little bit more. Here we go. They just arrived in. Ooh, I love it. Let's go. Here we go.
Please be seated. All right, ladies and gentlemen, we're continuing with the trial. We're redirected this witness. Ms. Zillaviv.
Officer Martins, Attorney Shiro just showed you a copy of your police report. Is that right?
Right.
And the police report you did in this case was 2 pages long?
Correct.
And he showed you the second page. Is that right?
Right.
Okay. Now, he asked you questions about if Ms. Davies ever said Mr. Davies got punched in the face, right? That was the question?
Correct.
Okay. I'm going to show you both pages of your report, and I'm going to point where I want to direct your attention. I'm going to have you read that, not out loud, and then I'm going to take the report back from you, okay?
Okay.
Worcester. Brenda, go park the car in Worcester, in Harvard Yard, Worcester.
Officer Martins, does that refresh your recollection on whether you wrote in your report, whether Ms. Davies said her husband Josh was punched in the face?
It does.
And what did your report say?
Ms. Davies stated that to another witness. She recognized the witness that was there and stated, that guy, this is in quotes, that guy, your friend, just punched him in the fucking face, end quote.
Now, when you got the written statement from Ms. Davies, where was she?
The written statement?
Yes.
In the hospital.
With her husband?
Yes.
About how long after this incident occurred did you get the written statement from her?
Probably a couple hours
Okay.
after.
Was Ms. Davies at the hospital that entire time?
Yes.
I have nothing further.
Any redirect on that limited scope?
No,
I'm sorry, recross on that limited
no,
scope.
no, thank you.
Thank you. May this witness be released?
Yes.
Any objection?
No.
All right, officer, you can step down, go about the rest of your day. State have its next witness.
Yes, the state will call Officer Luke Joswick.
Officer, would you come forward, please? If you go to the jury witness box behind the court reporter. Step up there, raise your right hand. You swear the testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God? I do. Have a seat. Direct your voice to that black bar with the red light and keep your voice up. Counsel, your witness.
Thank you, sir. Please state your name and spell it for the record.
My name is Luke Joswick, Luke L-U-K-E, Joswick Joswick.
How are you employed, sir?
I'm employed by the Village of Heartland as a police officer.
How long have you worked in law enforcement?
Total about 13 and a half years.
All with the Village of Heartland?
9.5 with the Village of Heartland.
All right. And you still work there today?
That's correct.
Okay. Directing your attention to the morning of June 18th of 2023. Did you work for the Heartland Police Department that morning?
I did.
What time did you start your shift?
I start my shift at 6 a.m.
And when you came on duty, were you asked to assist in an investigation that had carried over from the night before?
I was.
And what were you specifically asked to do?
I was asked to look for camera footage from Hometown Pharmacy on East Capitol Drive.
Okay. And you were aware that there had been a report of an incident at Tabby's Bar, correct?
That's correct.
Okay. And so someone asked you to go to the pharmacy and see if they had any video?
That's correct.
Okay. Did you do that?
I did.
And did you meet with anybody at the pharmacy?
Eventually, I contacted him by phone, the owner by phone first, because they weren't open. And he said that he would check the footage and see if there was anything there. And he called me and said that there was something. And so he wanted me to respond over.
Okay. And when you got there, were you able to observe whether or not there are any video cameras inside the pharmacy?
I was.
And could you describe for the jury where the camera was located?
The camera's a little bit back away from the front door, but it's facing the front door on East Capitol Drive.
And do you know where it was mounted?
It's mounted on the ceiling, approximately like 10 or 15 feet back from the window.
Okay. And were there any other surveillance cameras at that pharmacy?
There are, but none that would point in that direction.
Anything that would capture that front sidewalk area?
Only that front-facing one from inside the building.
Okay. Did you have an opportunity to view the video that the pharmacist showed you?
I did.
And did you believe that it contained information relevant to this investigation?
I did.
I'm going to ask Ms. Gussie to put up number 8, please, for the witness only.
All right, it's in the witness box.
Thank you. Sir, do you recognize, this is a still shot of a video, correct?
That's correct.
Do you recognize what we're viewing here?
I do recognize that.
How do you recognize it?
This is the video camera that I was looking at that morning with the pharmacist at Hometown Pharmacy.
And you've seen this recording before your testimony?
I have.
Do you believe it's a true and accurate representation of the events that evening?
I do.
Move for admission to number 8 and permission to publish, Your Honor.
Any objection?
No.
8 will be received. You may publish.
Okay, Officer Joswick, could you please orient the jury to what we're looking at here?
Again, this is the camera mounted on the ceiling facing north or towards East Capitol Drive inside the Hometown Pharmacy.
So that large object in the center of the screen is the front door to the pharmacy?
That is correct. That's the front door.
Okay. And on the sides of the doors, what's contained on the sides?
There's some windows on the sides of the door, and there's, I guess, general knickknacks that you would see at a pharmacy for sale.
Okay, like merchandise?
Yes.
Okay. And it appeared from this video that the pharmacy keeps their interior pretty well lit. Is that consistent with your experience?
That's correct.
And outside, is there any lighting outside the pharmacy to your recollection?
There are some streetlights, but I'm not sure where they would be located exactly.
Okay. And you understood that your department was investigating what was reported as a battery, correct?
That's correct.
And when you viewed the video, did you see anything that would be, again, consistent with what had been reported?
Yes, I did.
And I just want you to help the jury. We're going to play this video here in a minute, but before we do that, tell the jury what to look for, please.
Okay.
You can point as a touch screen. So if you actually touch the screen, I think an arrow will pop up. You can circle or draw lines or whatever is easiest for you.
The area of focus would be in this area, and things will move from right to left on the screen. That would be the area to look at.
And will you see people?
You will see 2 individuals.
And can you see any objects in this video with the people?
Yes, I can see one object.
Okay. And Tabby's bar is in which direction?
Tabby's bar would be on the right side over this way.
Okay. I'm sorry. Could you see any objects being held by any of the people in the video?
Yes, I can.
And what was that object?
It's a stool.
Okay. First, I'm going to ask the court to please preserve Exhibit 8A.
Any objection?
No.
8A will be preserved and received.
Okay. And then clear the screen, please, once that's done. Your Honor, this video is 22 seconds long. With the court's approval, I'm going to play it through once and then go back and have Officer Joswick describe what was seen in the video, to kind of break it down, instead of stopping and starting, stopping and starting.
Any objection?
Judge, I think we've agreed, I thought we had agreed that, the parties had agreed that we're not going to let witnesses say what the video shows. That's for the jury to see. I don't object to the state asking if they think they see something, but.
Right. No, I totally agree with that.
All right. So your general description, playing it through once and then asking questions, is not objected to and acceptable to me. So you can proceed to do that.
Thank you. All right. For the record, it's played through once in its entirety without any questions. And I'm going to ask Ms. Dussy to now back up and start it again, and then I will ask her to pause it as we go through. Stop. Maybe a little too quick, I know, trigger finger. Stop. Okay. Can you see any people in the screen at this time?
I can see one person in the screen right now.
And did you later learn the name of this person?
I did.
And what is the name of this person?
The person in the screen right now is Joshua Davies.
Okay. And can you see any other people in the screen right now?
Not right now.
Earlier, could you see a person?
I could.
We're interested in the time on the video.
Thank you, sir. It's 14 seconds. We paused at 14 seconds. Did you later learn the identity of the second person that was in the video?
I did.
And what name did you learn that person to be?
Kevin Sehmer.
Okay. Do you see Mr. Sehmer in the screenshot at this moment?
I cannot see him at this moment.
Okay. Can you see Mr. Davies?
I can.
Can you circle where he's located, please? And I'm going to ask the court to please preserve 8B.
Any objection?
No.
8B will be preserved and received.
Thank you. And now we'll continue to play. All the way through the end. Officer Joswick, you reported in your report that you could see a stool, and I think you just told this jury that you could see a stool in this video, correct?
That's correct.
Can you see it in this video?
If you look, can I touch the screen?
Well, yes.
Okay. If you look in this area, when Officer Martin's squad car arrives shortly after this, you can definitely see the stool with the lighting there. You can kind of just see it for a second. I've watched it many times, like on repeat. So
it's at a later point in this video.
Yes.
That you see that.
Yeah.
In the clip you just watched, were you able to see the stool?
Not right now.
Okay. So your testimony is that in a clip that's not in this portion, or I'm sorry, a recording that's not in this clip, you can see the stool.
That's correct. When the squad car lights illuminated.
Okay. And where did you see the stool in that clip?
It's right next to Joshua's, where he's laying.
Okay. All right, I'm going to look for that portion of the recording that you just referred to, but while they do that, I just want to ask you a separate question.
Can we clear the screen?
Yeah, you can clear that screen.
Thank you. Go ahead.
Did you or other members of the Hartwood Police Department attempt to obtain video from all the other businesses around the area?
We did.
Was this the best we could come up with?
It is.
Okay. As far as outside of Davies, correct?
That's correct.
And you're aware that there was video recovered from inside of Davies?
Yeah, I am aware of that.
Okay. Later in the day, on June 18th of 2023, did you have personal contact with Kevin Sehmer?
I did.
Were you able to observe his appearance?
I was.
And his approximate size?
I was.
In your opinion, what is the height of Kevin Sehmer?
I would guess approximately 6'1".
And do you have an estimate as to his weight?
I would guess around 250 pounds.
All right, those are all my questions. Thank you.
Cross.
I don't have any questions. Thank you.
Thank you. May this witness be released?
Yes.
Any objection?
No objection.
Thank you, officer. You can step down and go back the rest of your day, sir.
Thank you.
State have another witness?
Yes, the state calls James Armstrong.
All right.
No, it's okay. Probably, as long as they know what the number is, I can do it. It's okay. Yes.
Mr. Armstrong, would you come forward, please? Come to the witness stand, which is behind the court reporter, please. You want to set your material down? Just step up on that rise and raise your right hand. Do you swear the testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God?
I do.
Or have a seat. There's a black bar with a red light. Keep your voice directed there and your voice up. Counsel, your witness.
Thank you. Mr. Armstrong, can you please state the name for the record?
James Armstrong, A-R-M-S-T-R-O-N-G.
And how are you employed?
I'm a forensic imaging specialist with the Wisconsin State Crime Lab.
And what are your responsibilities as a forensic imaging specialist with the crime lab?
My responsibilities include photographing evidence for laying prints, footwear, and in addition to that, also forensic video analysis.
And you're at the crime lab in Milwaukee, Wisconsin, is that right?
That is correct.
And there's 2 other crime labs in the state of Wisconsin, in Madison and Wausau, right?
That is correct.
And prior to court today, did you provide a statement of your qualifications?
I did.
Okay, I'm going to show you Exhibit 9. I'm just going to show a paper copy. I have a copy for your honor if you would like it.
Have you provided defense?
Yes.
All right, thank you. I don't need it.
Thank you. Okay, Mr. Armstrong, it's showing you Exhibit 9. What is that?
That's my statement of qualifications.
How many pages is it?
3 pages.
And is that a fair and accurate copy of your statement of qualifications?
It is.
So I want to go through this a little bit more in depth. First of all, can you tell the jury about your educational background?
I have a bachelor's in photography from Milwaukee Institute of Art and Design.
And when did you receive that degree?
2002.
And what was your major?
In photography.
Sorry, you already said that. And I want to talk now about your professional experience. Can you tell the jury about your professional experience?
My professional experience includes working in commercial photography for 14 years, both as an in-house or staff photographer, along with being a freelance photographer.
And after you were, during freelance photography and working as a photographer, what kind of photographs would you do?
Typically, it would be mostly product photography, so shirts, hats, scale models, those types of items.
Okay, and did you transition into a different type of photography after that?
Yes, I was, after that time period, I was then hired by the State Crime Lab.
So when were you hired by the State Crime Lab?
I was hired in, in 2015
And what was your first position at the State Crime Lab?
as a forensic imaging specialist.
And so you've always been a forensic imaging specialist since 2015 at the Crime Lab.
Yes.
Did you have any other titles or duties at the Crime Lab in addition to forensic imaging specialist?
Yes, I'm also a member of the crime scene response team as a photographer and a team lead.
And what did you do as a crime scene response team leader and photographer?
Our job as a crime scene response team lead and photographer is to help requesting agencies process crime scenes.
Now I want to talk about your training as it relates to more forensic photography that you're now doing at the State Crime Lab. So first of all, where did you receive training for your position at the Crime Lab?
So for our position, we receive training both internally and externally. Internally, we have approximately one year training program focused on forensic imaging. And then externally, we receive training through it's called LIBA. It is an organization that provides forensic video analysis training, along with training through the software I use called AMP5.
And AMP5, just for the record, is spelled AMPED space FIVE, and FIVE is all capitalized.
That is correct.
Okay. And you said LIBA, again, what is LIBA?
LIBA is Law Enforcement and Emergency Services Video Association International.
And on page 2 of Exhibit 9, it actually details in depth your training at the Crime Lab in order to be a forensic imaging specialist. Is that true?
That is correct.
So your training for AMP5, what did you do in order for that training?
For that training is a training provided by the manufacturer, both for different modules of the software, along with a approximately 4-day course on the software itself.
And what is AMP5?
AMP5 is a forensic image and video enhancement program.
And are you certified in order to use the software program AMP5?
Yes, I've earned a certification from the manufacturer in the use of that software.
And ANT5 is that's something that is also used in the forensic imaging community routinely?
Yes.
And is it a software program that is reliable and accurate for the purpose of forensic imaging?
Yes.
And LEVA, again, what types of trainings did you do with that?
LEVA provides a 4-level training program. To advance to the next level, you need to complete an oral, written, and practical exam in order to be able to move forward to the next level. I've completed all 4 levels of training they offer.
And is LEVA, I guess, for all forensic imaging specialists all around the country?
Yes, it's an international organization that they provide training for people working within that field.
And is that organization something that is respected and relied on in the forensic imaging community?
Yes.
And do you have any professional affiliations that you're associated with?
Yes, I'm a member of LEVA, along with the IAI, the International Association of Identification.
And when did you become a member of LEVA?
I became a member of LEVA in 2017.
And are you still a member today?
Yes.
And the other membership that you talked about, how long have you been part of that?
I'm part of the IAI since 2019.
And have you ever testified as an expert in the category of forensic video analysis?
Yes, 4 times.
All in the state of Wisconsin, I presume?
Yes, all in the state of Wisconsin.
Now, did you get a forensic imaging request involving the 2 people involved were Josh Davies and Kevin Sehmer?
Yes.
And when that case came to you, was it ultimately assigned lab case number R23-1921?
Yes.
And kind of jumping ahead, but did you generate a report and review some videos and enhance them for this case?
Yes.
And the report you generated, you also provided that as well?
Yes, I did.
I'm going to show you Exhibit 10. And what is Exhibit 10?
Exhibit 10 is my report issued for this request.
And again, that's for R23-1921.
That is correct.
And is that a fair and accurate copy of your report?
It is.
And it's 2 pages, to be clear?
It is 2 pages.
I would move Exhibits 9 and 10 into evidence, Your Honor. I don't intend to publish them at this time.
Any objection? No. 9 and 10 will be received.
So let's first start, at least from this report. What evidence did you receive for this case?
I received digital I received digital files submitted electronically to the crime lab.
And first, let's talk about the first video. That would be, or actually the second video. Second video I'm going to talk about first. That was labeled Davies. Does that sound familiar?
Yes, it does.
And what kind of file was this?
This was a video file that I was requested to provide audio increase to it.
Only requested to enhance audio on this one.
Just the request simply was just to increase the volume of that video file.
Okay, so can you tell the jury how you do that?
We take the video file into Adobe Premiere and we increase the volume of that video file.
Okay, and Adobe Premiere, is this something you've been trained to use?
I have experience in using it, yes.
And is that program reliable and accurate in terms of the forensic imaging community?
It is used within the forensic imaging community.
And how exactly do you make the volume louder in Adobe Pro?
So in Adobe Premiere, what we do is utilize the effects panel and we increase that volume by a level that we determine to be, that we want it to have it be at.
Okay. Now, when you're increasing the volume, are you in any way changing the content of that audio?
No, we're not changing the content of the audio.
Okay. You did not enhance images on Tabby's video, is that true?
That is correct.
Okay. And now I'm going to bring up Exhibit 11.
In the witness box. It's in the witness box.
Thank you.
And do you have a video up on your screen now?
I do, yes.
And I think Ms. Gussie can show what the title is if she moves her. Exhibit 11, do you see it's R23-1921, another case number in Tabby's enhanced.
Correct.
Is this the video that you enhanced the audio on?
Yes,
And this was the video you then provided back to the police agency, is that true?
that is true.
And this looks like a fair and accurate copy of the video, is that right?
It does.
I would move exhibit 11 into evidence, and I've consulted with defense, and we're just gonna play the entire 4 minutes, Your Honor.
Any objection to the exhibit?
No.
Exhibit 11 will be received. You intend on publishing?
I do have a request to publish to the jury, and there is sound with it.
All right, any objection?
No.
You may publish.
And we're starting at 01, but we're playing the entire video. It's 4 minutes and 6 seconds.
Just remember, listen. Fuck you. That's a fucking. Hey, put him up there. Right, just fall him down. Right out there. Come on, motherfucker. Let's go. We'll get shut your fucking mouth. Right, that's a key word. Right. Please, okay, a little girl, little Karen. Like I said, walk there from the bridge, fall down, right out there. Both of them. Yes, this is in town. Kevin is not his license Harlan. Kevin doesn't put up with bullshit. Nothing. It's a pussy.
I needed a seat. Maybe you guys are actually really good drivers. I know John forever. 20 years. 20 years. Maybe you're taking this. Maybe today's
I'm serving on.
Maybe she's
Don't take it. What did you say?
Oh my God.
And the video is stopped. We can take that down now. And the next video that I want to talk about that's referenced in your report is hometown pharmacy video. Does that sound familiar?
Yes, it does.
Okay, so first of all, what kind of file format did you receive this hometown pharmacy video in?
I believe it was a .avr, which is a proprietary file format.
And with that file that you received, did you also receive the proprietary player?
I did, yes.
Okay. And what did you do to get the video out of the proprietary player?
I exported it as a .avi file.
And when you exported it into a .avi file, I guess generally, can you describe how you do that?
It was a function of the player itself, and we're essentially putting it in a wrapper so that the computer can understand how to play that video file back.
Okay. And when you exported the video from the proprietary player into the AVI file, did you change the content of that video in any way?
I did not.
And this video, the hometown pharmacy video, did it have sound?
I do not recall.
If I told you no, would that sound right?
I believe that would be correct.
Did you do anything with sound on the hometown pharmacy video?
I did not.
You only dealt with the video portion of it, is that right?
That is correct.
Okay, so after changing it into the AVI file, did you then enhance this video in certain ways?
I did.
Okay, so just generally, can you tell us the ways you enhanced it?
So for this particular request, we made the image, or we made the video brighter. We enlarged the video, and then we cropped in to the area of interest.
Were there any limitations on what you could do with this video file that's detailed in your report?
Yes, we have the lighting conditions. We have the reflections on the windows from the interior of where the camera is positioned. We have the distance between the person of interest and the camera. And again, the lighting conditions of that video file being bright on the inside and then dark on the outside.
Now, is it like CSI where you enhance a video and it's perfectly clear now?
No, making something bigger does not necessarily mean it's going to be clearer.
So if you had a blurry license plate from a traffic cam and you enhance it and on CSI it looks perfectly clear, is that how it really works in the world?
It does not.
So what software did you use in order to enhance the video the ways that you just described?
I use AMP5 for our processing of that video.
And that's the software you previously described that you were trained on in your testimony?
Yes.
Now, I think it might be easier to pull up the video so you can see which one I'm talking about first, and then I want to go through what you did with it. So I'm going to ask that Exhibit 12 be pulled up just on your screen.
Exhibits there.
Thank you. And Exhibit 12 is R23-1921 ACH01 enlarged 4 times. Is that right?
That's correct.
Okay. So what did you do with this video?
So for this video, we brightened the video to make it brighter, and then enlarged the video, and then cropped to the area of interest.
Okay. And on the screen, does that appear to be a fair and accurate depiction of the video that you enhanced in this case?
It is.
And I would move Exhibit 12 into evidence and ask to publish.
No. Exhibit 12 will be received. You may publish.
Okay, and Mr. Armstrong, this is a 15-second clip, correct?
Yes.
So I'm going to have it played for you and then maybe ask you a couple questions. And, okay, I'm now going to bring up exhibit number 13. I'm going to ask to take down the publication. I'm going to bring up exhibit number 13 and have it stop. Okay, exhibit 13 is R23-1921 CH01 enlarged 4 times, slowed by 50%. Is that what the title is?
That is correct.
Okay, so number one, how much was this video enhanced? Like how many times?
So this was, again, where we are brightening the video up. Then we are enlarging it, cropping it to the area of interest. And then for this particular video, we're slowing it down by 50%.
Did you do all of those things in AMP5?
Yes, I did.
Okay. And I forgot to ask you this for Exhibit 12, but did you change the content of Exhibit 12 in any way?
I did not.
And again, for Exhibit 13, slowed down, did you change the content of the video in any way?
I did not.
Okay. I would move Exhibit number 13 into evidence and request it published to the jury.
Any objection?
No.
13 be received. You may publish.
Okay, and ask that it be played for the jury. Okay, and that clip was 30 seconds long, correct?
Yes,
Because the original clip was 15 and you slowed it down by 50%, so times it's now 30 seconds.
that is correct.
I'm going to have the publication taken down to the jury. I'm going to bring up exhibit number 14. Pause it. Now, exhibit number 14 is entitled R23-1921 ACH01 difference enlarged 4 times. So tell the jury what you did with this video.
So for this particular video, we take all the frames of the video and merge it into a single image. Then we take that same video and overlay it. This will allow us to see the motion of within that area of interest. In addition to that, we also make it brighter. We also enlarged it and then cropped it to the area of interest.
Now, when the jury sees this, to me, it looks black. Is that right?
Yes.
On your screen, it looks black.
Yes.
So again, can you describe why it's black?
So the reason why it's black is that it's called absolute difference within M5. What we're doing is that we're looking at the pixel values, and the areas that don't move are going to be black because there's no difference there. But the areas that do move, there will be, everything will kind of be a little bit of a different color just due to the movement of the individuals through the frame.
So stationary items in the video are black or dark.
Yes.
Right? The items that move are going to be white or a brighter color. Is that accurate?
That is accurate.
And would this show motion for people and objects?
Yes, any changes in those values.
Okay, so if we see something black, that means it didn't move the entire time.
If we see things that are black, there's no difference in those pixel values.
Okay, but if we see something that's white, there's a difference in the pixel values because things are moving?
Correct.
Gotcha. Okay, and exhibit 13 on your screen, that looks like a fair and accurate copy. Sorry, 14 looks like a fair and accurate copy of the video you produced.
Yes.
I would move exhibit 14 into evidence and request to publish, Your Honor.
Any objection?
No.
14 be receiving my publish.
Okay, and we can play it. Okay, and that was 15 seconds, right, Mr. Armstrong?
That is correct.
Okay, I'm going to take it down from publication. I'm going to bring up exhibit number 15. And exhibit 15 is entitled R23-1921 ACH01 difference enlarged 4 times slowed down by 50%, right?
That is correct.
So again, on exhibit 15, we're seeing black and white again. Is that true?
That is true.
So for exhibit 15, you talked about the difference and how you did that. Is that the same in exhibit 15?
That is correct.
Okay. What is the difference between exhibit 14 and 15 then?
Difference is going to be that we now slow the video down by 50%.
Okay. And again, is this a fair and accurate copy of the video that you enhanced for this case?
Yes.
I would move exhibit 15 into evidence and request to publish.
Any objection?
No.
15 will be received. You may publish.
Okay. And we can hit play. Okay, and all the enhancements that you did, slowing down, increasing audio, this was all done consistent with your training and experience as a forensic imaging specialist with the State Crime Lab. Is that true?
Yes.
And you didn't modify the content of any of the videos in any way. Is that true?
That is true.
I have nothing further.
Thank you, counsel, please.
You have an eye for ladies? No, I do not. I do not have an eye for. Well, no, I do have an eye for ladies. They don't have an eye for me. Scribs, Wayne. Hope you're doing well, buddy. Speaking of music, I was the first child of teen parents. I grew up listening to everything. They always had the newest albums playing. There you go. I doing anything for You're 60, I think. Fuck that, Scrivs. She's got way to go for 60. She's 55, Scrivs. I'm Gen X. There you go. Right. I don't want to skip this. I think they're coming back pretty soon, so I don't really want to skip this bit. So I'll leave this play. Then we've got probably about 14 minutes, 15 minutes left of this. And then I'll switch to the day 2 video. I know, I still can't believe that you're friggin' 55, Amy. Fucking hell. Hey, have you all done it? Have you all done it? Have you all done this? Press the like, press the like, press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Like and subscribe, everyone. Let's fucking go. Still not bad. There's still a sidebar. I didn't. Also, Scott McGuinness. I didn't know that because I say Worcester, you say Worcester, Worcester, Worcester.
Yes.
I'm 82 as well. 82 years as well.
Are you going to, do you need to put in a different, or can we just work on these? You have to put one in, right?
Yes.
Oh, you got it in?
Yeah, this is the state's, that's all there.
That's the state, so you
Yeah.
just have to go through it.
And then just put it into the CMU thing.
Okay. All right, so what do I tell the judge? You ready to go and have it come up?
Mr. Chair, do you want us to switch screens?
Yes, please.
Right.
What the defense don't understand is that we hear every word. This is great. This hot mic situation is fantastic.
You ready? I'm going to just see that it works.
It doesn't actually, it doesn't work though to turn off.
Well, then I have to take a baseball bat to it. That's the next step.
Well, that's important.
Did it go off when I unplugged it?
You know, I didn't like
You
It's on.
have it now?
Yes, I have it working.
Okay, this is the end of Western civilization with all the technology. All right.
video. Is that correct?
Yes.
Now, what you did with 14 and 15, can you tell me, and I apologize, I don't really understand what you call it. What is it, what you did?
So this is called absolute difference.
Absolute difference?
Correct.
Okay. New hearing aids are not as good as I had hoped, but we'll deal with that later. Absolute difference. And an absolute difference, when I was looking at it, I was thinking of it as like a negative, but it's not that, is it?
It is not.
Okay. And you do something, and I'm so sorry, could you explain what it is that you're doing with regard to that?
Yes, with regards to absolute difference, what we can do within AMP5 is to see what difference in pixel values there are. And with regards to this particular exhibit, again, we're taking all the frames of the video, making it into a single image, and then overlaying the video on top of that single image and playing it through. Any changes in those pixel values will be represented in a lighter color.
Okay, and it's my understanding that some of what is causing it to be visible with some kind of color of some sort or lighter shade has to do with movement. Is that right?
Yes, so when we take all the frames of video and merge it into a single image, any movement is now is not there. Anything that stays stationary is there. So when we're having those changes of movement, that's what we're seeing by overlaying on top of that single image.
Okay, now, I'm not going to take credit for this, but somebody sitting next to me assisted me in trying to lighten it so that it was more visible in that format. And it appeared that by having a lighter, by lightening it, brightness, other things could be seen. Did you try to do that?
I only adjusted the gain or the brightness within the video as it's seen here.
Can it be made lighter, brighter?
It's certainly possible.
Okay, if I show you something, will you tell me if this continues to be the video, but just perhaps more clear? Is that okay?
Sure.
All right, so I'm gonna ask my assistant to start the process of what, and you're on 14?
15.
15, okay. So, tell me when you're ready. All right, so can you see what she's doing?
Mhm.
Can the jury see what she's doing? No.
I would ask that the jury not be allowed to see what she's doing. I think I have some objections to what an assistant is doing to modify a video even further than what Mr. Armstrong is. He didn't modify it this way. So I have concerns about foundation and what was done and how it was done by this assistant who seems to now be a witness.
If the questions are framed to this witness as to whether or not there can be alteration and whether that alteration was within acceptable, I guess, guidelines based upon his training and experience, and he affirms that, then that modification can occur, whether it's manipulated by an individual at defense table or not. So as to the issue of foundation, the court will sustain the objection, allowing for you to establish greater foundation for purposes of what you're attempting to do. And we'll see whether we can get this done in the time frame that I expect.
Can the witness see what she's doing?
Yes.
Okay, so, all right, so we won't do it with the jury seeing it until he is.
Okay, you're talking out loud. Let's get to questions.
Okay, sorry. All right, so I'm going to show you some raising the brightness on this, and you can see how it's being done. And go ahead and do that.
I'm going to first object if we can tell the witness what type of video player we're in right now.
Mm-hmm.
It's different. The video player we played it in is slightly different than the one they're playing it in.
So that's a foundational objection. The
Sure.
court will sustain that.
Are you familiar with VLC Media Player?
Yes, I am.
Is that a reputable company?
I can't speak to, with regards to that, I know him only simply as a video player.
Pardon me?
I only know it as a video player.
Okay.
Not as for using it as any type of enhancement or clarification.
Well, if you see what is being done using this VLC Media Player, will that allow you to determine whether you believe that the changes are not altering the video itself, but perhaps enhancing it?
I have never received any training on VLC player as using it as an enhancement tool.
Yeah, using his computer. That's, Judge, I'm not certain we're going to finish at 4:30 because we may have to deal with this more extensively than I had hoped.
Your witness available tomorrow?
Mr. Armstrong, are you available tomorrow morning?
I am, Your Honor.
All right, thank you. Ladies and gentlemen, we're going to break for the day. I'll ask you to retire to the jury room, receive instruction from Tom. Please sit down and discuss this.
Okay, let's go to day 2. Let's frigging go. Oh, thank you, Sarah. Yeah, Sarah, I have no idea how you do memberships and stuff. So Sarah's gonna help you out, DNS or Bev. Right, let's go to day 2, people. Hang on, let me get this up here. Bam, ba 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 bam. Ba 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 Right, hang on.
Entire 15 seconds, correct?
Oh, they go straight into it. No messing about. Okay, this is good. Da-da-da-da-da-da-da-da-da. Press the like, press the like, press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribed. Right, I think we are ready. If you're ready, guys, I'm ready. Let's frigging go on this. This is a good trial. I think it's okay, actually. Right. Let me just share screen. You are the one and only. Right. Everybody, let's go. Let's go. Let's go. Let's go. Let's go. I know it sucks staying there. I know. Right. I'm just going to put myself back up there. And hopefully everyone, if you've liked and subscribed, that is awesome. So YouTube, and also I should say this, just a reminder to everyone, not just me now, but I mean anybody you follow that you really like on YouTube, please make sure you still subscribe to them, because YouTube, I lost 20 subscribers overnight. So make sure you still subscribe. A lot of these guys had to resubscribe today, so you might YouTube are just getting rid of people. So double check your favorite YouTubers, make sure that you are subscribed to them just in case. Right, here we go. She's got her own channel. We're going to watch Judge Boy tomorrow. So, Amy, just to explain to you, we're watching this whole trial today. We're watching the whole trial. It's a 3-day trial. We're watching this all the way through, pretty much. So, yeah, strap in. Strap in. Strap it in, ladies. We're about to go. Hang on. Hey, Carol, thank you so much, Carol, for that photo. I love it. I love that. You got your El Chatty stuff on. I love it. Thank you, Carol. Thank you for that. That made me smile. Thank you so much. That's brilliant. DNS, thank you for becoming a member again. Thank you so much, my darling. Right, let's go then, people. Let me get this back up. The stream, that is. Shit. No, I loved it, Carol. I loved it. That made me smile, Carol. DNS, you're back. Guess who's back? Bev is back. Tell a friend. Hello, Young. How we doing, my darling? Hope you're well as well. Right, let's fucking go, people. Strap in. Let's go. Calm your tits, everyone. We are ready to go. Wisconsin, yes, Young. Another Wisconsin one. Day 2, here we go. We got Kevin Sehmer back on. This is, remember, cross-examination. So in the morning, here we go, people.
Entire 15 seconds, correct?
Due to the limitations of the video, I cannot make a determination with that.
Okay, now I'm going to show you Exhibit 13, which is the slowed version of that enhanced video, okay? And I'm going to ask that, I'm going to play it and ask that be published, Judge.
It's published.
Okay. Now, just so we haven't started it yet, don't start it. So this video will be 30 seconds in length because you've made it slower. Is that right?
That's correct.
Okay. And I may stop it at a point and ask you a question about it, okay?
Understood.
Go ahead and play. Okay. You would agree that the time, that latter part of the video, when the two of them, when you see what appears to be Mr. Davies coming, and then shortly thereafter, we see him moving forward. That event is only maybe 2 or 3 seconds. Would you agree? And I
Again,
realize we make this half speed, so.
we're, again, the length of time has been increased because I've slowed it down to comment on those interactions. Again, that was not part of my request for my opinion on that.
No, I understand, but you can tell us what the clock says. So if it said 4 seconds on this slow video, that would be 2 seconds.
That would be correct.
Okay, all right, thank you. And so, and then you use that other kind of recording, which was, I think, was it all slowed? Or we had one that was real time and one that was slowed, is that right?
That's correct.
And so we'd have the same circumstance. To the extent you can see things, it's a fairly short period of time when the people that are really close to each other. Is that right?
Again, as to the actions pertaining to that, I was not requested to provide an opinion on that.
Okay. All right. All right. Thank you. I have nothing further.
Okay, I've lost track. Was that recross or cross? That was cross. Redirect.
No, no redirect.
Thank you. May this witness be released?
Yes, Ron.
Any
Yes, thank you.
objection? All right, Mr. Armstrong, you can go about the rest of your day. Thank you.
He literally came back for like, what, 2 minutes of testimony. What a fucking waste of time that was. Oh, defense, come on. You're better than that, defense. Come on.
Step up there.
I know, Crystal, I know.
Swear the testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God. All right, have a seat. See that black bar right there, Mike? Voice so you can hear me, right? Let you pull in close. Move that mic closer to you on the tape. So we can hear you, all right? All right, counsel, your witness.
Thank you. Ms. Davies, can you first of all state your full name for the record?
Jennifer Davies.
And how do you spell your last name?
Davies.
Okay. Ms. Davies, can you tell us where do you live?
In Delafield.
What do you do for a living?
I'm a hairstylist.
Do you have a business?
Yes.
And what is it called?
Hair by Jen.
How long have you been a hairstylist?
23 years.
And were you married to anyone?
Yes.
And was that person Joshua Davies?
Yes.
Okay. When did you and Josh meet?
10 years ago.
So around 2014 or so?
Yeah, around there. Yes.
How long after you met did you get engaged?
2 days. Literally. That's when he asked.
And how long after that did you get married?
A year.
So you were married to Josh Davies from 2014 to 2023.
Mhm.
And just for the court reporter, you'll have to say yes or no.
Yes.
Okay, thank you. So back in 2023, how tall was Josh?
6 feet.
About 6 feet. Back in 2023, about how much did he weigh?
150 pounds.
Okay. Was he a real muscular guy?
He's very lean.
Very lean. He was a skinny guy.
Yes.
Where did Josh work during this time?
At Badgerland Landscaping.
How long did he work at Badgerland?
Off and on for I think 15 years.
And when you two were married back in 2023, where did you two reside?
In Delafield.
In Delafield. Do you have any children?
Yes, I have one.
You have one child. Okay. Did Josh have any kids?
He did. He had 2.
And who all lived with you and Josh at your residence in Delafield?
Just my son.
And I want to now fast forward a little bit to Saturday, June 17th of 2023. Do you remember this date?
Yes.
So first of all, during the day, what were you doing on Saturday?
I was working.
You were working at Hair by Jen.
Yes.
And how long were you working that day?
Until about 3 in the afternoon.
And when did
3?
Okay. When did you start?
9 o'clock in the morning.
So you had a full day of work.
Yes.
And do you know what Josh was doing that day?
I believe he was disc golfing.
Was he working?
No, he was not working.
Was there somebody he was disc golfing with?
With Bryan.
And what's Bryan's last name?
Richardson.
And about how long had Bryan and Josh been friends?
A very long time. Since high school, we grew up together.
After you had worked, after Josh was done disc golfing, did you guys agree to go to downtown Heartland for a concert or?
Yes.
Okay. So tell me a little bit about that. How did that all happen?
Well, first I got off of work and we went to Belfry for some food or snack. And then we went to Enders to get dinner with Bryan.
So about what time were you at Belfry?
4.
And was it just you and Josh, or Just you and Josh. Okay. And after that, when did you meet up with Bryan?
I believe around 6:37.
Did you all drive together to Enters?
Yes, we drove with Bryan.
So neither you or Josh were driving that night?
No.
And why did you go out to Enters or to downtown Heartland that night?
Bryan wanted to go out for the first time since his brother passed away, and it was important that we were there for him.
So you go to Enters at around 7 o'clock, and Enters is another bar or food place?
It was a restaurant. We went for dinner.
And what bar or place did you go next after getting done with Enters and eating?
I believe we just went straight to the concert.
And do you know what bar that concert was at?
It was Beer Snobs.
Okay, Beer Snobs. And where was the concert at Beer Snobs?
It was in a back area, I think a closed street.
On a closed street. So it was outside?
Yes.
Okay. And do you remember around what time you got to Beer Snobs and this concert?
I do not.
Sometime after 7 p.m.
Yes, yeah.
Okay. At any point during this night, did you make, or first of all, do you have a friend named Laura Burke?
Yes.
How do you know Laura Burke?
She's been a client of mine for a very long time.
Okay. And do you also see each other socially at times?
Yes.
Did you ever make plans to meet up with Laura Burke that night at Beer Snobs?
Yes, when I had done her hair previously that week, we both mentioned we were going to go and just said, if you do go, let me know.
And did you ever text with Laura Burke that night?
Yes.
And was that to meet up at this concert?
Yes.
Now, during this time frame that you were with Josh, at Belfry and then Enters and then the concert, was Josh drinking that night?
Yes.
Do you know how much he drank throughout the night?
No.
Do you remember what he was drinking?
Beer.
Drinking beer. Were you drinking that night?
Yes.
What were you drinking?
Seltzers.
So like White Claw or Truly or something like that?
Mm-hmm.
And that's a yes?
Yes.
Okay. Do you know how many drinks you had that night?
2.
2. What about Bryan? Did you see Bryan drinking that night?
No.
And while you were at this concert outside at the Beer Snobs, did you take any photos with you and Josh that night?
Yes.
I'm going to show you Exhibit 17. I'm going to just ask that it be shown to the witness right now.
It's in the witness box.
Thank you. And Ms. Davies, do you see Exhibit 17 on your screen?
Yes.
Can you tell us what Exhibit 17 is?
It's the last picture we took together.
And who's in the picture?
Josh and myself.
And in the background of this picture, it looks like you can see the band that was playing outside.
Yes.
So this is a fair and accurate picture of you and Josh on June 17th of 2023.
Yes, yes.
I would move Exhibit 17 into evidence and request to publish.
Any objection?
No.
17 will be received. You can publish.
Now, Josh was wearing a tank top that night. Looks like it's like gray, blue, maybe red.
White, yes, white, blue, red.
And does Josh have tattoos?
Yes.
Okay. And on both of his arms?
Yes.
Does he have a lot of tattoos on both of his arms?
Yes.
Okay. Do you have tattoos on his legs too?
Yep. Yes.
And we can take the photo down now, Judge. So while you're outside at this concert, and who were you mainly with at this concert outside?
The 3 of us, Bryan and Josh and myself.
Did you ever meet up with Laura Burke that night?
Yes.
And do you know when you did that?
Time-wise, 9 o'clock.
Okay.
Maybe?
So were you talking and was Laura with you the entire night?
No.
Did you ever really talk to anybody else other than Laura, Josh, and Bryan then, while outside?
I did not.
And at some point during the night, towards the end of the night, did you go to Tabby's Wine Bar?
Yes.
Can you tell us how that came about?
Laura texted me that she was there, and I said, I've never been to Tabby's. I don't know where it is. And she said, well, I'll come find you. at the concert. And so she came and found me, and I said, well, I would like some wine. And so she took me back to Tabby's.
And
Because we were about to leave the concert area anyways.
okay. And when Laura came out, you saw the wine. Was the concert done outside?
I believe so.
But it was towards the end of the night.
Yes.
So about what time did you see Laura and talk about the wine bar?
I don't know the time.
Okay. So did you then go with Laura to Tabby's wine bar?
Yes.
Who else came with you?
At first, it was only her and I, and then Josh and Bryan followed.
And do you remember how you got to Tabby's wine bar from the concert and Beer Snobs?
Yes, we walked to the back door.
And go in the front door of Tabby's?
No, at the time I'd never been there, so no, I didn't realize I was walking in the back door either.
Are you familiar with the downtown Heartland area?
Not really.
Had you been to Tabby's wine bar before?
No.
Had you been to Beer Snobs before?
Years and years ago.
But you're just generally not exactly familiar with the layout?
No.
Okay. Now, you go into Tabby's wine bar. Who walks in first from that back door?
Laura?
Okay. And were you with Laura when you walked in?
Yes.
Were Josh and Bryan walking in with you at the same time, or were
They
they
were shortly behind.
Shortly behind, okay. So Josh and Bryan are walking together and you and Laura are walking together.
Yes.
Now, when you got into Tabby's wine bar, were there a lot of people in there?
No.
Yeah, and this is towards the end of the night?
Yes.
Okay. Did Laura see anybody she knew?
Yes.
Okay. And where was this person in the wine bar?
Towards the front of the bar.
And did you go and meet with him?
Yes.
Okay. Do you remember who that person was?
Yes. Kevin introduced himself as the owner.
Okay. So his name was Kevin.
Okay, yes,
Yes.
thank you.
And tell me about that initial interaction when you first meet Kevin.
We just introduced ourselves, and again, he mentioned that he was the owner. And I said, oh, nice to meet you.
Okay. The owner of Tabby's wine bar?
Yes.
And when you were introduced, were Josh and Bryan also near you?
No.
No. Okay. How much later did Josh and Bryan come in?
A minute.
Minute. Not a long time period, right? Okay. So was it then you five kind of congregated together towards the front of Tabby's?
Yes.
So Josh, Bryan, you, Laura, and Kevin.
Yes.
Was Kevin bigger than Josh?
Yes.
Okay. Could you tell about how much he weighed just by looking at him, or no?
Very large man.
And had you ever met this Kevin before that night?
No.
Do you recall seeing Kevin out when you were by the concert at Beer Snobs?
No.
To your knowledge, did Josh ever meet Kevin before this night?
No.
Were you and Josh together the entire night?
Yes.
So tell me about your initial interaction with Kevin when you're at the front of Tabby's, and it's you five at the front of Tabby's.
I just remember immediately when the boys walked in, him kind of talking very loudly about their tattoos negatively.
Whose tattoos?
Josh's specifically.
Okay, and what do you recall Kevin saying to Josh about the tattoos?
That he ruined the body God gave him and that he was going to go to hell.
Do you recall if Josh responded to that statement?
Well, oh, sorry. Kevin also said, you know what God says about tattoos? And Josh joked and said, get more.
Okay. And then Kevin responded with
what I had said previously about going to hell.
Okay. And you were marking up God's work.
Yes.
Did Josh say anything back to Kevin after that?
I think I said something to Kevin and like, you know, well, I have tattoos and you're not talking to me like that.
Okay. Did you show him your tattoos? Yes. Okay. And after that initial interaction, did Kevin say anything else about these tattoos with Josh?
I can't remember.
Okay. What did Josh do in response to Kevin talking about these tattoos?
He walked to the other side of the table to avoid more conflict.
Judge, I don't object that the latter portion is
her testifying about somebody else's opinion.
It's her opinion as to what he did. Overruled. Next question.
Okay, so then Josh kind of separated himself, is that right?
Yes.
After that happened, after Josh separated himself, tell me what happens next.
I showed Laura my tattoo because I had added a little bit since I had seen her last, or I didn't show her when I saw her last, but she hadn't seen it. And all of a sudden, then after a minute, we hear more foul language of Kevin screaming over to Josh.
Okay, so do you recall what that foul language was?
Yes.
Okay, so to the best of your recollection, can you tell us what Kevin said to Josh?
I believe he called him a motherfucker and a pussy.
Okay. Did Josh respond?
I can't remember.
Okay. Where was Kevin when he was saying these things to Josh?
At first, he was on the other side of the table, and then he proceeded to go around and get in Josh's face.
Kevin went around.
Kevin went around.
Did Josh move from where he was standing?
No.
Do you recall what Kevin said to Josh when he moved around and was standing right by Josh?
Not specifically.
Okay. Do you recall if it was swear words?
Swear words.
Swear words. You just don't recall the specific quote. Okay. Now, after Kevin did this, went over by Josh and kind of got in his face, did you do anything?
I went over to Josh and just to kind of just make sure that it didn't escalate any farther, and Josh was fine. So,
did Josh stay there after Kevin got in his face, or what happened next?
that's when I asked Josh and Bryan to just go outside because we were going to leave anyways. So I said, let's just go. We don't need to entertain this.
Why did you ask Josh and Bryan to leave?
We were leaving anyways, and I just thought this isn't going to go anywhere good.
So how do Josh and Bryan leave? Which
They go out
door
the
did
front
they?
door. The front door.
I'm sorry, Judge, that was my fault. Which door did they go out of?
The front door.
Not the door you came in?
No.
And after they leave, did you stay inside the bar?
Yes, I stayed inside because, yes,
Who was all inside still out of the group of 5 of you?
Laura and Kevin.
Laura, Kevin, and you?
Yes.
Why did you stay inside and not leave with Josh?
I came back after I walked them to the door because I said to him, because I believed he was the owner, that, I don't know why you're talking to my husband like that. I have tattoos and you're not speaking to me that way. And he said, don't take it personal.
And after that conversation, do you know about how long you were inside when it was just you, Laura, and Kevin?
20 seconds, 30 seconds.
Other than that initial conversation, were you 3 talking about anything else?
I don't know how it came up, but I did say that I had known Laura for 20 years.
Okay. Did Kevin ever try to hug you during this time?
I believe he hugged Laura.
Hugged Laura, okay. Did Josh ever come back into the wine bar?
Yes, he came back to ask me to leave.
So about how long were you in the wine bar before Josh kind of came back in?
30 seconds.
And did he come all the way to where you were?
No, he stayed at the door.
Stayed at the door. Do you recall exactly what he said when he stood at the door?
I believe he said, why are you still talking to that asshole? Let's go. And I said, okay.
Was he saying that to Kevin?
He's talking to me.
Okay. After Josh said that, what happened?
Kevin immediately charged past myself and Laura to run outside.
Did you try to stop Kevin?
He ran past me so fast.
Okay. Do you ever remember being at the door and Kevin pushing you out of the way?
Judge, I object, it's legal.
Sustained.
Do you recall Kevin going past you at all?
Yes.
Do you recall him pushing you at all?
Aggressively.
Judge, same objection.
I'm sorry, there was no question. I heard aggressively, which was in response to the previous question.
She asked another question.
Was there another question?
Yes.
I heard, do you recall? And I didn't hear a question.
Well, I forgot my question now, so
The reporter read the last question back, please.
She said, do you remember him pushing you? And she said aggressive.
Overruled. Next question.
And now, you have seen the video from inside Tabby's wine bar, is that true?
Yes.
Judge, I'm gonna now pull up, this has already been admitted into evidence as Exhibit 11. And I'm gonna ask to play this video with Ms. Davies.
Just the witness.
It's already been admitted, so I'd ask that it also be published. The jury has already seen it.
Thank you. Madam Clerk, could you put on the screens for publication and switch the computer over to the district attorney?
Okay. And I believe that's on the screen for everybody now. Ms. Davies, so do you see on the screen the Tabby's video, Exhibit 11 now?
Yes.
Now, before I start playing it, and you can circle and kind of draw on this touch screen, I'm going to have you identify some of the people here. So can you circle where you are in this video? Okay. Can you circle where Josh is?
So just before you, that you're going to wind up with a bunch of circles.
I could do.
It's not going to be clear given the fact that there are other individuals. Can you ask the witness to use letters?
Mark,
yes.
I can. Can we clear the screen?
Yep.
Okay, can you mark with a letter J where you are?
Let's try that again. Put a screen, clear the screen. Molly. Thank you. Let's try that again. There you go.
And can you mark with the letter J-O where Josh is? And can you mark with the letter B where Bryan is? And can you mark with the letter K where the person you know as Kevin is? Okay. Now, do you see Laura in this frame right now?
No.
Okay. And I would ask that this be preserved as 11A.
We have 11A. Any objection?
No.
11A will be preserved and received.
And now I'll ask to clear the screen. And now I'm gonna play this video for you, Ms. Davies, and I'm gonna ask that you watch it. I may stop it at times as well. And if you could pause it, and I've paused it at 20 seconds, Your Honor. Ms. Davies, do you see Laura here now?
Yes.
Can you mark with an L where Laura is? Okay. And I would request to preserve this as 11B, Your Honor.
Any objection?
No.
11B will be preserved and received. You want the screen cleared?
Yes, Your Honor. And now I'm continuing Exhibit 11 at 20 seconds.
I'm gonna get more. Just cover less than one. Fuck you. That's the fucking. Hey, you wanna go out there? The rank's falling down right out there. Come on, motherfucker, let's go. No. Okay, shut your fucking mouth. Right, that's a key word. Please, just ain't a little girl, little Karen. Like I said, go out there, rank's falling down right out there. Hold it. Yeah, this is the Kevin is not his license. gotta go put up with bullshit. Nothing. It's a pussy.
I need a receipt. Maybe you guys are actually really good friends. I've known John forever. 20 years. 20 years. Maybe today's
I'm serving now.
Maybe she's better.
Don't take it personal. What did you say?
Now the video ended. Ms. Davies, you were able to watch that, right? That's a fair and accurate depiction of what happened that night, right?
Yes.
So I just want to talk a little bit about some of the things in here. At the end, after you are by that door, did you scream?
After I walked out, it happened so fast and he just ran out, and when I screamed, it was because he had punched Josh. Because I was standing right next to Josh.
And I'm going to get to that part, but we also saw towards the end of this video, you come back in. Did you see that?
Yes.
Do you recall what you said or why you came back in?
I came back in and said, the owner just punched my husband.
And you set your drink down, it looks like. Is that true?
Yes.
Now, I previously asked you if you tried to stop Kevin from going outside. In the video, does that refresh your recollection at all if you tried to stop him?
Yes.
So did you try to stop him?
Yes.
And how did you try to do that?
I tried to get in, stay in front of him and not let him out.
Ms. Davies, how tall are you?
5'2".
I'm not going to ask how much you weigh, but do you weigh less than
Yes.
275 pounds?
Yes.
I now want to talk about what happened outside. So after we see Kevin go out the door, do you recall where Josh was outside?
Yes, Josh was at the other end towards the pharmacy.
Was he on the sidewalk or the street?
The sidewalk.
And do you recall where Bryan was?
Standing next to Josh.
After Kevin goes outside, did you also go outside and observe what happened?
Yes.
So can you tell me, what did you observe happen after Kevin goes outside?
I watched as Kevin charged towards Josh. Josh picked up a stool and chucked it at Kevin to defend himself.
What stool did he pick up?
A stool from Davies.
And you said that, and at that time when Josh picked up the stool, what was Kevin doing?
Charging at him.
And when you say charging, can you maybe describe that a little bit more?
Running at him.
And how was Josh holding the stool?
Like this.
So it looks like you held up both of your hands in front of your face. Is that true?
Yes.
Did you see Kevin with the stool above his head?
It was Josh.
Sorry, Josh. Did you see Josh with the stool above his head?
No.
You saw it kind of in front of his face and torso?
Like this.
Judge, I'll object.
Sorry, I withdraw the question.
Bleeding.
I agree.
Question withdrawn. Next question.
Thank you. from when Kevin went outside to Kevin charging at Josh and Josh picking up the stool, how many seconds is that, if you can tell us?
2.
Okay. Then you said that Josh threw the stool at Kevin?
Mhm.
Is that a yes?
Yes.
Okay, what happened next?
Kevin ran past the stool and punched Josh.
Did the stool hit Kevin?
I don't believe so.
Did the stool land somewhere on the sidewalk?
Yes.
Now, you said that you observed Kevin punch Josh, right?
Yes.
Can you tell us how Kevin punched Josh?
With his right hand.
Do you remember if it was a fist or an open hand?
A fist.
Where on Josh's body did Kevin hit Josh?
In the temple, which is right here.
Do you know which temple of Josh's? Which side?
His left.
And after you observed Kevin punch Josh, what happened to Josh?
Just fell.
Fell to the ground.
Fell to the ground.
Did you see Josh hit his head again?
When he fell.
What did he hit it on?
The cement. Sidewalk.
When you observed that happen, where were you?
Standing right next to him.
And when you say him, who do you
Josh.
Know? Josh. Did you observe Josh brace his fall at all?
No.
He just fell?
Mm-hmm.
Yes.
After he was hit, yes.
He fell.
Yes.
Did you observe Josh trip over a stool?
No.
Did you observe Josh swing at Kevin?
No.
Did you observe Bryan with a stool outside?
No.
Did you observe Bryan throw any sort of stool at Kevin?
No.
After Kevin punched Josh and Josh fell, where did Kevin go?
He ran past me.
Did he say anything?
Yes.
What did Kevin say?
He said, I'm getting the fuck out of here.
When Josh fell to the ground, and did you see Josh on the ground after this?
Yes.
Was he awake?
No.
Was he moving?
No.
Did you see any blood on his head?
No, I don't remember.
Okay. I'm now going to bring up Exhibit 15. It's actually, I'm going to ask to pull up Exhibit 15. It's already been admitted into evidence, so I'd ask to publish it for the jury right away.
All right, go ahead.
I'm going to ask you to pause it. Ms. Davies, have you also seen these videos from Hometown Pharmacy?
Yes.
And you've watched this one that's kind of in black and white? Yes. So I'm going to play this video and stop it so I can have you describe, based on your memory, who we're seeing in this video, okay?
Yes.
So it's starting at 00 on Exhibit 15. Okay, stop.
You see Josh backing up.
Okay, so actually, can you play just one more thing? Okay, do you see where Josh is in this video?
Yes.
Can you circle where Josh is? Okay. In this still, do you see where Kevin is?
Yes.
Where's Kevin? Can you circle where he is? Okay. I'll ask to preserve this as 15A.
Any objection?
No.
15A will be preserved and received.
And I'm going to ask that then the screen be cleared. And then if you can continue playing. Okay. we stopped it at 20 seconds. Do you see Kevin in this video?
Yes.
Can you circle where he is? Do you know where Josh is now?
Yes.
Where's Josh?
On the ground.
And can you see him in this video clearly right now?
No.
Ask that it be preserved as 15B.
Any objection?
No.
15B will be preserved and received.
Ask to clear it. And play it from 20 seconds. And I'm going to play this again now, Miss Davies, because you kind of described some other things. So I'm going to go back to the beginning and to 0. And we can hit play again. Stop. At this point, what is happening in this video?
I believe Josh threw the stool and continued to walk back away from Kevin.
Was Kevin walking forwards?
Yes.
And we see two people kind of moving across the screen, right?
Yes.
And Josh is the one walking backwards, you just said?
Yes.
And Kevin's the one going forward at him.
Yes.
Want to orient us to the video time?
And this is at 10 seconds on exhibit 15. Okay, can you continue to play? Stop. Did you see something fall in this video?
Judge, I'm going to object to her testifying to what she's seen. If she is recalling regarding her, what she remembers, that's one thing, but her asking this witness to say, what is it that you're seeing? The jury can see what we can all see.
Well, I can't see much
I
on this
can't
version of the video, number one. Number two, this witness can testify about what she observed, experienced, and what occurred. What she can't do is interpret a video, which is a video of absolute something that was modified by the expert as to what is occurring. So the court is going to sustain the objection. If you have questions specifically to this witness about what happened, ask them. Let her testify.
During this video, where were you standing? If you could describe in the picture, in the video.
I was right here, about there.
And I asked that that be preserved as 15C.
You want to describe what she marked?
Well, can you describe what?
No. She's drawn a circle. You didn't ask her to draw a circle. I'll preserve it. It'll have a circle on it for your record. This is not my record. This is your record and your record. So be more precise when you're using these videos in terms of timing and what you're asking to have manipulated. Otherwise, if there's ever an appeal, the Court of Appeals is just going to get a transcript that says, preserve the record. And they're going to get an exhibit that has a circle on it. They have no idea because you haven't asked the witness to describe it. So I'm done with stage assistance here. You go ahead and make your record.
At 16 seconds, what did you just circle on the screen for us?
I circled where I was, outside.
And would you say that you circled in the middle of the screen?
Yes.
I would ask that 15C be preserved.
Any objection? No. 15C will be preserved and received.
We can take that down. After Kevin walked away, did he walk by you?
Yes.
And how did he walk by you?
Very close.
Very close. Did he push you in any way?
No.
He didn't touch you?
I don't remember.
After Joshua was hit, what happened next?
Kevin ran past me and then I jumped, or I fell to the floor by Josh to be by him.
Okay. And you also went back into Tabby's wine bar, we saw?
Oh, yes. Mm-hmm.
Okay.
To go get help.
So you went back in to get help? What did you ask? How did you do that?
I said, the owner just punched my husband and I believe, well, the bartender was there and then I walked back out.
Okay. And once you walked back out, how did police eventually arrive?
They were already there.
They were already there, okay. And was Josh still on the sidewalk?
Yes.
After the police got there, did you tell the officer what happened?
Yes, I proceeded to say that the owner punched my husband.
And did the ambulance also arrive?
Yes.
And while Josh is on the ground and before the ambulance gets there, was Josh awake?
No.
Was Josh talking to you?
No.
Were you trying to talk to Josh?
Yes.
And the ambulance took Josh away, right?
Yes.
What hospital did you go to?
Aurora Summit.
Did you ride in the ambulance with Josh?
Yes.
Can you tell us how long Josh was in the hospital after this happened?
Over a month.
Did he have any surgeries during that time frame?
Yes.
You know how many surgeries he had?
He had 3.
While in the hospital for that little over a month, did Josh wake up?
He became alert, but not for weeks.
Were you able to talk to Josh again?
Very little.
Okay. Was he ever able to tell you or police what happened that night?
No.
Did Josh recover from his injuries?
No.
Now, at the hospital when you initially arrived, were you asked to give a written statement?
Yes.
Tell me, you were at the hospital. About how long after did this incident occur were you making this written statement?
I don't remember.
Do you remember what your state of mind was when you were making the written statement?
I was very upset and shaking.
Were you focused in the written statement on the details of exactly what happened?
Objection. Leave. Sustain. Next question.
I have no further questions.
Cross.
And I'm sorry about your husband's death. You and your husband went, and in some of the time with Bryan, to 3 different places. I think Belfries, is that one of them?
Yes, just
Is that
Josh.
a bar or a restaurant?
A restaurant.
Okay. And again, I apologize. Do you think you got there about what time?
4.
Before? Okay. And was your husband drinking then, ma'am?
I don't remember.
Okay. And then you went about, it would appear about 3 hours later to Enders, I believe you called it?
Yes.
And ma'am, do you not have any recollection whether in that 3 hours when you and your husband were at Belfries, whether he was drinking? And I mean alcohol, not Coke.
Yes. He had yes, before we left.
Okay. You said before you left Belfries.
Before we left to go to Enders.
Okay. So in those 3 hours, do you have any sense of how many beers he had?
No.
Did he have any hard liquor also?
No.
Do you know that he had at least one
One.
beer?
Yes.
Okay. And you think, and were you eating there?
At Enders or
Yes.
Belfry?
No, I'm sorry, ma'am. And if I'm not being clear, correct me. At Belfries, your recollections that he had a single beer or possibly more?
I don't remember if he drank at Belfry. I just know that we ate because I was hungry after work.
Okay. So then, while you were eating at Belfries, you then went to Enders at about 7, as I understand.
Yes.
And did he drink at Enders?
Yes.
Okay. Do you know how long you were at Enders before you left there?
No.
I mean, was it more than an hour, more than 2 hours?
Probably an hour. We ate.
I'm sorry?
We had dinner. So
Okay. Did you not eat at Belfries?
we did.
Okay. Did you have dinner there?
We just snacked.
Okay.
At Belfries at that time, they just had their snack menu.
Okay. And then at Enders, you had, the 2 of you or the 3 of you had dinner, is that
Yes.
right? Okay. Did your husband drink at Enders?
Yes.
Do you know how much?
No.
Could it have been several?
I don't think we were there that long.
Okay. So when you left Enders, you aren't able to give the jury any sense of how many beers your husband had had from the time you entered Belfry's and the time you left Enders?
No, I don't remember.
Okay. And you had been drinking, but not very much, I understand.
Yes.
Correct. How many, did you have anything to drink at Belfry's?
No.
Did you have something to drink at Enders?
Yes.
What did you drink, ma'am?
I had a glass of wine.
Glass of wine?
Yes.
Okay. And then when you left Enders at about what time do you think?
I don't remember.
Okay. You then went to the concert, is that right?
Yes.
And this was outside, as I understand.
Yes.
Is that true?
Bear with me, hang on. I just had a glitch there. 2 seconds. And we'll be back. Here we go.
And were they serving beer, wine, alcohol at the concert? And you're going to have to, and I understand this is difficult, I do, but I also don't have as great a hearing as I would like. So if you could just please, a little bit, speak up. And maybe just if you move towards the mic, it would help. Thank you, appreciate that. So how did one get beer or wine or liquor at the concert?
They had booths set up
Okay.
with
And
beer,
go ahead.
with beer and seltzers, I believe.
Those hard seltzers?
Yes.
Okay. And do you know how many beers that your husband had at the concert?
No.
Did you recall seeing him going to get beer or seltzer or whatever?
Yes.
Do you have any sense of how many times he did that?
No.
Okay. Did you have something to drink while at the concert?
Yes.
Another wine or something different?
I had 2 seltzers.
Oh, 2 seltzers?
Yes.
Okay. And then you stayed there about how long before you went to some other place?
A few hours.
You said 2 hours?
About.
Okay. So you think you went to Tabby's next?
Yes.
Okay. And as I understand it, you were there, among other things, was to meet Laura, correct?
Can you repeat the question?
Sure. You went to Tabby's, among other reasons, to see Laura, correct?
That was the only reason.
That was the only reason, okay. And you had gotten some text saying that either that she was there or meet me there or something to that effect. Is that right?
Yes.
Okay. All right. So, and it was first you went in alone, is that right?
With Laura.
With Laura. So did you meet her outside the bar?
She came and got me because I didn't know where Tabby's was.
Right. And then the two of you walked to Tabby's.
Yes.
You entered through the back door, I understand.
Yes.
Sorry. And then, I don't recall, did you get anything to drink when you were at Tabby's?
No.
Do you know if your husband did when he arrived?
No, he did not.
Okay. And as I understand, you were with your husband the whole night, is that right?
Yes.
And then at some point, there was this dispute, argument about tattoos, is that right?
Yes.
And I think, correct me if I'm wrong, I think you may have heard your husband say something to Mr. Sehmer that he must be a good Catholic boy or something like that?
No,
No, you didn't recall that, or it wasn't said?
I don't believe it was said, or I didn't hear it.
Okay. And then did you hear Mr. Sehmer say something to the effect that he's Lutheran?
No,
You didn't hear that, or he didn't say it?
I don't remember.
And then at some point, your husband, I'm sorry, moves around kind of behind you and moves off to your right and to Mr. Sehmer's left. Is that right?
Yes.
Okay. And in the earlier conversations, your husband was to your left and kind of moved towards where Mr. Sehmer was standing. Is that correct?
He moved to my right because I was facing Kevin. Kevin was in front of me.
Right. And
So Josh moved to this side.
to your right.
Yes.
But I mean, before that, before he moved around you, he would have been to your left. Is that right?
Yes.
Okay. And they were having some discussion and your husband was showing him some tattoos, is that right?
Yes,
Okay. And then your husband moved around to your right, to that
yes,
little table right there. And he being your husband was doing some shaking with his hand thing.
he was pulling out his chew.
Oh.
His chew,
No, I know what chew is.
Oh.
So what was he doing with the chew, with the,
shaking it.
okay,
I guess he always did that. I don't chew, so I don't know what that does to it, but
okay, all right. So then you kind of talked your husband into him and his friend leaving, is that right?
yes,
And you kind of let him out a little bit, is that right?
yes,
Okay, and then you came back in and you were now kind of standing next to Laura Burke, is that right?
yes,
And then the three of you were having a discussion with Mr. Sehmer, is that right?
yes.
And that seemed friendly, was it not at that point?
No, it was not friendly. I
Okay,
mean, I was very upset for him talking to my husband that way.
sure.
And that's what I was saying to him. I said, that was my husband. I can't believe you talked to him like that.
Why did you keep talking to my client?
I was under the impression that he was the owner. And since I had never been to that establishment, I just wanted to, I don't know. I mean, I don't know.
Okay, fair enough. You don't know. And Laura was talking to him?
Yes,
And at some point, the two of you, that is you and Laura, were kind of standing next to each other, and Mr. Sehmer kind of goes around and seems to kind of hug Laura while you guys are standing next to each
Yes.
other? Okay. And that seemed friendly, did it not?
I don't know.
Well, it wasn't hostile.
I guess,
Am I right?
I don't remember. Like what? I don't remember that. I mean, yeah, because the hug isn't hostile.
Okay. And then at some point, your husband came back and we saw him kind of open what would be the front door. And he yelled something about using that A word. And you heard that, correct?
Yes,
And obviously Mr. Sehmer heard it, correct?
yes.
I mean, it wasn't spoken softly. He was kind of yelling it, wasn't he?
It was loud.
Okay, so I'm right. He
The
was
bar
yelling.
was loud, yes.
And then Mr. Sehmer said something and yelled something like, what did you say? And then
Yes,
quickly left the
yes,
tabbies.
yes,
And you were in front of him?
yes,
And I think Laura may have been behind him a bit. Is that
Yes.
right?
yes.
Okay. And then you went outside. And when you got outside, as when you left, your husband was where?
By the pharmacy on the
Okay.
sidewalk.
So he was further, I think that's west, further west of where you and now Mr. Sehmer were, correct?
Yes,
So if I'm seeing these videos, and I'm thinking more about the ones where we could see it, the enhanced color ones, your husband, if he was by the pharmacy, must have moved towards Mr. Sehmer. Is that right?
no,
No? Okay. So, but Mr. Sehmer is moving towards your husband?
yes,
Now, I'm going to, I'm sorry, you then, you say you were on the sidewalk?
yes.
Where relative to your husband?
Next to him,
So you got ahead of Mr. Sehmer.
it happened in 3 seconds. I was right behind Mr. Sehmer. So yes, I was right next to Josh.
Well, I'm trying to understand. You are behind Mr. Sehmer now, not in front of him. Is that right?
Yes,
And your husband is in front of Mr. Sehmer, correct?
yes,
So you were behind Mr. Sehmer and not really by next to your husband, correct?
I would say I caught up. I mean, I was standing right next to Josh. It's just 3 seconds.
Ma'am, there are, I think, at least 2 tables and a number of stools that are right in front of Tabby's, are there not?
I don't know. I'd never been to Tabby's before.
Well, I understand. Did you like run through tables and chairs to get next to your husband?
I ran past them.
On the outside towards the road?
Yes, the tables are along the building.
Right. So, but when you circled yourself in that one darker video, you had yourself like next to the wall almost, apparently. Is that true?
I don't know what I was standing by.
Okay, so when you circled where you thought you were in that darker video, you don't really know if that was accurate, do you?
I was right next to Josh when he was punched. So wherever that was is where I was.
I understand that. So you said because I was next to him, I'm just gonna put myself in a circle against the wall of the pharmacy, or is that right?
Yes.
So you then scooted around Mr. Sehmer, somehow got apparently behind your husband and then to the side of him?
I was never behind my husband. I was behind Kevin, and then I was right next to Josh.
How did you get there to be next to Josh?
I walked.
Okay, I thought you indicated earlier, ma'am, and I'm sorry, I thought you indicated that my client was like running.
We were running. I
You weren't
ran.
walking, you were running too.
Yes.
And that's how you got wherever you got.
Yes.
And was your husband walking or running or standing?
He was walking backwards.
Okay, well, at some point in the video, he's moving forward, do you agree?
Yes.
Towards Mr. Sehmer.
Yes. That's when he had the stool.
Right. And then after he moved towards Mr. Sehmer with the stool in by his face, being Josh's face, is when he lunges at Mr. Sehmer, is that right?
He chucked the stool and continued to walk backwards away.
Well, but in the video, when he's lunging forward, he's not moving backwards, he's
I'm
moving
going to
forward.
object as to the characterization of the lunging in the video.
Mrs. Cross, you can ask the questions. The question is really about the position of the witness. It has some redundancy to it.
Thank you.
But the court's going to overrule the objection. I don't know if there was an answer. Was there an answer to that question, Madam Reporter? Could you read the question back, please?
In the video, he's not moving forwards, or he's not moving backwards, he's moving forward.
Is that accurate, ma'am? Pardon me?
Yes.
Now, I understand that obviously your husband was injured and had to go to the hospital, is that right?
Yes.
And you were obviously very concerned because according to your testimony, you believed that you had seen my client strike your husband, is that right?
Yes.
And according to your testimony, you saw my client strike your husband, is that right?
Yes.
And that's why, according to you, as a witness, you believed he had fallen down. Is that right?
Yes.
Did you say yes, ma'am?
Yes.
Answered yes.
Okay, thank you. It's me, ma'am, it's not you. Now, you gave a statement to law enforcement in writing, correct?
Yes.
And this was while you were at the hospital waiting for your husband to be taken care of and et cetera, correct?
Yes.
And my guess is that part of that time you would be waiting as medical personnel are doing things medical personnel need to do. Is that right?
Yes.
And you're not, whenever they were doing x-rays or whatever they were doing to your husband, you're not going to be with him at that point because they're taking care of him. Is that right?
Yes.
So I need to, what number are we on? 18?
Oh, yeah, that's right. Are you doing it?
I don't know if you can get any number you like. You can do whatever numbers you want.
Right.
118?
Yeah, I don't know what the tattoo. I don't know what the tattoos are for. It's not quite as clear cut, I don't think, as what we may have thought.
We are going to be asking the assistance of your clerk regarding the Elmo, which is, I think, set up and ready to go.
You're going to have the witness identify an exhibit?
Yes,
You're going to have the witness identify an exhibit before it's published to the jury?
I will.
The Elmo is tied to the jury box, Madam Clerk? Thank you.
May I vote?
Just a minute. Ladies and gentlemen, we're going to take a break. When you return to the jury room, please do not discuss this case. I'll have you back here in a few minutes.
How
All right, please be seated, ladies and gentlemen. We're continuing with cross-examination. Mr. Shiro.
Thank you, Judge. Ma'am, I'm going to be showing you an exhibit in a moment, but if I may, I'd like just to follow up on a question I'd asked you earlier. So you indicated that you had started in front of Mr. Sehmer and then somehow, or you were behind him, and then you got in front of him by going out towards the road, I gather. Is that correct?
I never got in front of Mr. Sehmer. I just caught up to him when he stopped to punch Josh.
I'm sorry?
I never caught up. I caught up to him. I never got in front of him.
Okay. I thought, and maybe I'm wrong, I thought you indicated that you were standing next to your husband when he was struck.
I was.
And I thought you indicated to the jury that you were towards the buildings, that is Tabby's. And
That's where we were standing.
Tabby's and the pharmacy, is that right?
Yes.
Okay. And initially, your husband was moving backwards, and then you somehow got around him to be on his right side?
When he was struck, he was to my left and Kevin was in front of me.
Right. You were on his right side.
Yes.
Mr. Your husband. I'm sorry.
Yes.
Okay. And then you had indicated in that one, I call it the dark video, that you would put yourself, you drew a circle around yourself. Is that right?
About the vicinity of where I was standing.
Yeah. And I thought, I thought Mr. Armstrong indicated that using that video, you would see movement. That's how it registers things. And did you see yourself moving in that video?
I don't remember.
Okay. So, but, so you were right next to your husband when he was struck. Is that right?
Objection asked and answered.
Sustained.
Okay. When your husband was struck, did you catch him?
No.
Were you able to touch him at all as he fell?
No. It happened so fast.
Well, I understand, but you were standing next to him when it happened fast. And in the videos, it appears that he's moving to his right, isn't he?
Objection vague. Who is he?
Sustained.
Your husband was moving right in the videos. Isn't that true?
After he was struck?
Yes.
Yes.
And you were right there, correct?
Yes.
He would have kind of bumped into you or landed on you almost. Isn't that true?
Objection vague. Asked and answered.
Argumentative. Sustained.
Do you agree that had you been standing right next to him when he started moving to the right, you would have been able to catch him? Isn't that
It
true?
was so unexpected. No one would have expected a man to punch your husband. I wasn't prepared.
But you were, according to your testimony, watching Mr.
Yes.
Sehmer, right?
Yes, and he ran past me after.
I understand that. But when he struck your husband, you were looking at him. Is that right?
Yes.
Him being Mr. Sehmer.
Yes.
Okay. Now I'm gonna show you something, okay? And then we're gonna put it on this Elmo, okay? But I will put it on the Elmo visible to everybody. when the judge
Counsel,
tells
just
me I
proceed.
can.
Just either approach the witness or do what you're going to do.
Okay.
The technology is on in the witness box.
And I'm showing you what is marked as Exhibit 101. Do you recognize that document?
Yes.
And can you tell the jury what that document is?
It was my statement.
Okay, it's a written statement, is that correct?
Yes.
And Judge, may I publish this while I ask questions of the witness?
You're asking for it to be admitted?
Yes.
Is there any objection?
No, Your Honor.
Is it 101?
101, Judge.
101 will be received and you may publish.
All right, thank you.
We are upside down.
It's upside down. And I need to go. All right, ma'am, that is the written statement you wrote at the hospital, is that right?
Yes.
Okay. Now you indicate in there that the man you knew as Kevin ran, then screaming at my husband about tattoos, is that right?
Yes.
And you said, my husband defended himself and picked up a chair or stool to defend himself from the crazy person who went after him. Is that right?
Yes.
Okay. Now, and then you finish by hearing Mr. Sehmer say, I'm effing out of here. Is that right?
Yes.
Okay. Now, what you didn't say in that statement is that Mr. Sehmer punched your husband. Isn't that true?
Yes.
You didn't, ma'am, in that statement say that your husband threw a stool at him, correct?
I'm sorry, what did you say?
Yes, ma'am. You didn't in your statement say that your husband threw a stool at him, correct?
I said he picked up a chair or stool to defend himself.
I understand, but you don't say that he, being your husband, threw the stool at my client.
No. I was very rattled.
Ma'am, I am certain you were rattled.
Let's get a question.
But you also were asked to provide a statement while you were in the hospital, rattled, to explain what you saw that evening. Isn't that true?
Yes.
And since, according to your testimony, your husband hit his head on the cement as a result of being punched, can you explain to this jury why you didn't think that fact was something that you thought necessary to put into your statement?
To be honest, I had no idea it was this serious. I had never written a statement before. I didn't realize that I had to be that specific. I could barely write. I was shaking. So I didn't know it was ever going to be needed. I didn't know this was going to happen.
Well, you knew your husband was in the hospital.
I had no idea the injuries.
Let me just finish, if I may, ma'am. You did realize that your husband was seriously injured, correct?
Honestly, no. I didn't know at the time that I thought he just got punched and he would just wake up.
Well, except that you weren't able to wake him up. Isn't that true, ma'am?
No.
No, it isn't true?
No, I was not able to wake him up.
And he never was able to communicate, correct?
Correct.
You had good reason to believe that whatever injury he had was serious. Isn't that true?
I wish I would have. I didn't know. I honestly didn't know that it was going to be this bad.
Okay.
I thought he was going to wake up and we were going to go home.
Well, I understand, but you weren't asked to talk about his health care. You were asked to talk about what happened. Isn't that true?
In the statement?
Yes.
Yes.
Okay. And you also didn't say that he defended himself apparently by what? Throwing the stool at him?
Yes,
Him being Mr. Sehmer?
Josh threw a stool,
Okay. And where was Mr. Sehmer relative to your husband when that happened?
running at him
How far away?
on the
was he?
sidewalk, just a few feet.
Okay. And were you next to your husband when he threw the stool?
I was kind of in the middle of him. Or no, I was behind Mr. Sehmer.
Okay. You were still behind, you were behind Mr. Sehmer or Sehmer when your husband threw the stool?
I don't remember.
And do you have any sense of how far away Mr. Sehmer was from your husband when he threw the stool?
Just a few feet.
Where did it hit him? If it hit him at all?
It didn't hit him.
Where did it go?
To the side.
Okay. Did it end up laying next to your husband after he fell down?
I don't know. I don't remember.
Okay. All right. You went into Tabby's after he had fallen to the cement, is that right?
Yes.
Okay. And you weren't, strike that, after your husband went to the ground, how long was it before you went back in? Any sense?
I don't remember.
Okay.
Seconds?
Okay. And when you went back in, Mr. Sehmer wasn't there, is that right?
No, he was not there.
And you had indicated, did you believe that throwing the stool at Mr. Sehmer was the defense?
Objection.
Of what it was that Mr. Sehmer was doing?
He was trying to my husband was trying to keep him away.
Well, he could have kept going the other direction, could he?
It ran away?
Yeah,
That's not what happened.
but he could have done that.
I don't know if that would have been the solution. I don't think Kevin would have allowed him to run away.
Does your husband, is he not fleet of foot or something that he couldn't move away from this larger, heavier guy?
Yes, he can run.
Okay. But instead he did something different, right?
Mhm.
Yes?
Yes.
And what he did was to actually move towards Mr. Sehmer. Isn't that true?
When he threw the stool.
Or when he held the stool, correct?
Held the stool?
All right. I have nothing further. Thank you.
Redirect.
I have nothing, Your Honor.
Amy, you can step down. Take the exhibit down, please.
Yeah.
State have an additional witness?
Ms. Davies can be released from her subpoena.
Yes. No objection?
No.
Yes, state calls Laura Burke.
All right.
Oh, thank you.
Ms. Burke, would you come forward, please? You come to the witness stand, which is behind the court reporter. Burke, you just step up on that rise and raise your right hand. Do you swear the testimony you're about to give is the truth, the whole truth, nothing but the truth to help you God? Okay, have a seat. Get comfortable. There's a black bar with a red light. Do you see that?
Yes.
That's the microphone.
Okay.
I need you to pull your chair up close and to speak with your voice elevated so we can hear you, all right?
Yes.
This is your witness.
Thank you, Judge. First of all, Ms. Burke, can you state your full name for the record?
Laura Bell Burke.
How do you spell your last name?
B-U-R-K-E.
And can you tell us where you live?
I live in Heartland.
How long have you lived in Heartland?
Going into my third year.
And what do you do for a living?
I'm in real estate development.
And do you know Jen Davies?
Yes.
How do you know Jen Davies?
We've been friends close to 20 years when she started doing my hair when I first moved to the area.
So she was your hairdresser?
Yes.
And is she still your hairdresser?
Yes.
Okay. And do you know who Jen is married to?
Yes.
Who was she married to?
Josh Davies.
And how long have you known Josh?
I guess probably about 8 years ago when I met Josh for the first time.
And I want to direct your attention to Saturday, June 17th, 2023. Do you recall this night?
Yes.
And first of all, did you go out to the bars or a concert in Heartland that night?
Yes.
And tell me, where did you go?
I started at Beer Snobs and then later went to Tabby's.
What was going on at Beer Snobs or in downtown Heartland that night?
It was a concert that Beer Snobs was hosting, and it was an outdoor concert in the street area. And so it was a fun kind of festival.
And did you make plans to meet with anybody that night?
Yes.
And who did you make plans to meet with that night?
Jen.
Do you know if Jen was coming with anybody?
I knew that her and Josh were coming together.
So you had plans to meet with them at the concert?
Yes.
Now, do you recall about what time you got to the concert at Beer Snobs?
It was probably around 7:30, I'm guessing.
Was it light out or dark out?
It was still light out.
And when you got there around that time, did you see Jen and Josh right away?
No, I did not.
Did you see other people you knew?
It was crowded and I did not see anyone that I knew.
So what did you do?
I was looking for my friends.
And while looking for them, did you talk with anybody else?
Yes.
Okay. Who did you talk to that night?
I ran into Kevin Sehmer and his friends.
Okay, first of all, the person that you know as Kevin Sehmer, do you see him in court today?
Yes.
And can you tell me where he's seated, generally what he's wearing?
The far left gentleman in the suit and tie.
Does he have glasses on or no glasses?
Glasses.
I would ask that the record reflect identification of the defendant, Your Honor.
Any objection?
No, sir, thank you.
Identifications established. Next question, please.
Have you, prior to this night on June 17, 2023, ever met Kevin Sehmer?
No.
And I think you said this, but was Kevin Sehmer with anybody?
He was with two friends, as I recall.
Do you remember either of those friends' names?
One friend was Tom, and I don't remember the other person's name.
Okay, so tell me about your conversation with Kevin during this first time that you knew him.
It was crowded, and Kevin and his friends were standing in a little tree well area right outside on the Beer Snobs patio. So I was looking for my friends, and we just started chatting. It was just like an easy approach. You know, I'm looking for my friends, and we stood and talked for a few minutes.
Okay. And what did you talk about?
We were talking about, you know, I think through the conversation, he lived in Brookfield, and we were chatting like, who do you know, kind of thing. It's a small community, so we were visiting about that. It came up that I was single, and his friend Tom that was with him was just divorcing, and so that became the topic of conversation, whether he and I should meet.
And when you say whether he and I should meet, who is he?
Tom, whether Tom and I should meet.
And was Kevin trying to facilitate that?
Yes.
Okay. Did you talk with Tom that night?
Yes, he was in that conversation too. There were just other conversations going on at the same time. So Kevin and I were, you know, it was kind of loud. So we were talking more closely. So even though Tom's presence was right there, he wasn't necessarily a part of this conversation.
During this night, did you ever give your phone number to Kevin or Tom?
No. Kevin gave me his phone number.
Sorry, I apologize. Can you tell me about that?
After we had been talking for, I don't know, maybe 10, 15 minutes, and I was still looking for my friend. So I was moving on, and he said, let's keep in touch. I would really like for you to meet Tom. He's a great guy. I forgot my phone at home. I don't have my phone with me. Here, take my number. And I pulled up my contacts, and he put his phone number in my phone.
When you say he put his
Kevin.
phone, and I know this is a little weird, but so nobody gets yelled at. Wait for my question fully.
Thank you. Okay.
And then answer. Okay. So when you say he put his number in my phone, who is he?
Kevin.
After you have this initial conversation with Kevin and Tom, did you eventually see Jen and Josh?
Yes, I later would find them.
Okay. And so were you with Jen and Josh the entire night?
Because it was such a large venue, it wasn't the entire night, but we would be together, and then we'd see other people, and then we'd kind of reconvene again. And I had another friend that was there with a few people also. So I was kind of going back and forth between groups of friends that I knew.
And were you drinking anything that night?
Not at that point.
And let's break that down a little. So when you're outside at Beer Snobs, Did you drink anything?
No,
And when I say drink, you didn't drink any alcohol.
no.
And when you met up with Jen and Josh eventually during this night, was that outside?
Yes.
And were Jen and Josh with anybody else?
I don't know who they were with. It was, a big crowded area, so different friends were saying hello. I don't know who was like with them necessarily, but there were a lot of people around that were friends. So there was visiting going on. I don't know who was all together, but I'm sorry. I did know that Josh had a friend with him that they had come together from what I understood.
Okay. During this night, did you ever see Kevin Sehmer drinking?
Yes.
What do you recall, first of all, what type of alcohol do you recall him drinking?
When I first ran into Kevin and met him, it was kind of a joke that he had a girly drink that was a pink, kind of a sea breeze, vodka and cranberry. So I think I teased him about that a little bit, a girly drink.
Okay. Do you recall about how much Kevin was drinking that night?
I wasn't with him entirely, but every time I saw him that night, he had a drink in his hand.
So at least one drink you know of.
Yes.
At some point, do you decide to go to Tabby's Wine Bar?
Yes.
Okay. And is this in the same general vicinity as Beer Snobs?
Yes.
And you're familiar with the Heartland area, right?
Yes.
So when do you go to Tabby's Wine, or when do you decide to do this?
I think it was a little before 10. So the drink choices at the festival were seltzer drinks and things that beer, and I wasn't drinking that. So I think it was around 10. I walked over to Tabby's by myself and got a glass of wine.
And did you stay at Tabby's?
For a few minutes.
And after you were there and you got your glass of wine, what did you do?
They allow in Heartland that you can carry your drink from a bar when there's a festival going on. So it was in a plastic container, and I walked back out the door and rejoined my friends, Jen and Josh.
And when you rejoined your friends, Jen and Josh, what happened next?
Jen said, "Where did you get that wine?" And I said, "Over at Tabby's," because she was aware they weren't serving wine at the festival either. And she said, "Oh, that looks good." And I said, "Well, come on, let's go get one." So we walked back over to Tabby's.
And who all walked over to Tabby's?
Jen and I walked together first, and we were visiting and talking, and Josh and his friend were a few feet behind us.
And how did you go in the front door of Tabby's?
The back door.
And once you walked into Tabby's now the second time, did you see anybody in the bar that you knew?
Yeah, I saw Kevin.
And where was Kevin?
He was towards what I describe as towards the front of the bar. There's some round tables towards the front area, and he was standing there by himself.
And did you go over by Kevin?
Yeah, I think we waved coming in the back door, and hey, and that type of thing.
Okay. And who else went over by Kevin?
Well, Jen and I were together, and I think Josh and his friend were just sort of following us.
So did you all five of you come together in the same general
Yes.
area at
Yes.
Tabby's?
Yes.
And what was the initial interaction with Kevin and you, Jen, Josh, and Bryan?
I think I did some just introductions, because Kevin knew from earlier that evening when I first met him that I was looking for my friends, and I had actually described my friends, like, have you seen my friends, and described their appearance. I said, oh, here they are. This is my friends that I was telling you about earlier in the night.
So everybody introduced themselves then? That's a yes?
Yes.
And what happened next?
Jen and I were talking, and it seemed very quickly on that the guys were kind of standing all together, and Jen and I were nearby, and I just started hearing kind of some bad language and name calling, and some talk about tattoos, and it caught our attention.
Who was saying the bad language?
Kevin.
Did you hear Josh or Bryan say any bad language during this initial interaction?
I did not.
And you mentioned you heard something about tattoos. Who said that?
I really don't know. I really didn't follow the voice of who said. We just heard something about tattoos, and the tone was aggravated.
And so whose tone was aggravated?
I don't know that I identified the voice at that time. I just remember how I reacted to it.
How did you react?
I tried to kind of calm down the atmosphere, and and so I knew that that Jen had a tattoo, and I said, here, let me see your tattoo. I was trying to just change the direction of what I was hearing in the background of this aggravated tone.
Do you recall what Kevin's demeanor was like during this?
He came across just kind of hostile, which was surprising because he had been friendly earlier in the evening, but that had been several hours earlier.
Would you say he was friendly with you?
Earlier, yes.
Okay. Do you know who he was directing this hostile attitude towards?
Well, he was standing, Josh and Josh's friend were standing near him, so that's who the conversation was amongst.
Okay. Now, did you guys continue, the five of you continue to talk?
Yes.
Okay, so tell me, after this initial interaction, what happens next?
I became uncomfortable with the tone, and I felt like Kevin needed to go back to his friends that were just back at the festival, but which in my mind at the time was, well, his friends are right outside the back door of Tabby's. I felt like I could move Kevin in that direction to get him out the back door to kind of get him moving along.
Do you recall any other conversation between Kevin and Josh, Bryan, Jen, and you prior to you kind of thinking, okay, I'm going to have Kevin go back by his friends?
I think there was some chit chat, small talk. Again, just trying to diffuse the situation that, when I heard the voices, it was the word that caught my attention was Kevin was calling, I guess, I didn't know who it was directed to, but he was talking to Josh and his friend, and he used the pussy word, which I thought was very aggressive with people you don't know. So I was like, oh, where's this coming from? So I wanted to diffuse the situation.
And so you talked about how you kind of wanted to get Kevin back towards his friends. So how were you doing that?
He had a drink that was sitting on the table, and I kept picking up his drink and kind of like pulling him towards where the back door would have been to kind of like get him to come with me. And I'm sure my words followed that same, line of thought.
The drink, was that an alcoholic drink to your knowledge?
It looked like the other drinks he had been drinking that night, like a sea breeze. It was a pink drink in a big glass.
And as you tried to walk Kevin away, where were Jen, Josh, and then Josh's friend?
Still in the area where we were standing, where we had been standing in sort of that front portion of Tabby's by the circle tables.
Okay. During this time, did you see Josh did you ever observe Josh go back and try to get in Kevin's face during this time?
No.
Did you ever see Kevin, while you're in Tabby's, get in Josh's face?
I don't think it was something that I noticed at the time, but I since have seen it on the video.
And you say you're kind of asking Kevin to go back towards his friends. Did he do that?
I don't think I asked him to. I was just trying to get him there. That's in my mind. I was like, he needs to join his friends. I kind of went into my mother mode and was trying to diffuse the situation and remove him from the friends that I was there with.
And I apologize.
Okay.
Did he ever do that? Go back by his friends at this point?
No.
So what happens after that?
I just tried several times to do that. And then I think it was all still brewing, like this hostile attitude. And I know Jen and I kept looking at each other like, what in the world is happening? It was just this explosion that happened. And we were like, where did this come from? It was very unusual behavior for, what I've ever encountered. And
let me stop you. When you say this hostile behavior, who are you talking about?
Kevin had this very aggressive, hostile attitude that was unprovoked in my view of what was happening.
So you and Jen are kind of looking at each other. Do Josh and Bryan ever leave?
Yes.
Can you tell me about that?
They walked out the front door, and I think it was like, like where we were going to go next, like were they going to go home? It was just kind of, okay, we were going to continue the evening, and they went out the front door, and I was trying to get Kevin out the back door.
And after Josh and Bryan left, who was still in the bar together?
Jen and I were standing there, and Kevin was there in that area too, right where we were standing.
So what happened with you three in the bar at this point?
From what I recall, Jen and I were just in like, what just happened? We were looking at each other like, oh my goodness. And then she was going to go with Josh and his friend, and I was going to get Kevin over to rejoin his friends out the back door. So like going in two separate directions. And then I felt in my mind that was diffusing this situation that was brewing.
But for a time period where you, Jen, and Kevin standing in the bar together talking.
Yes, but it was really Jen and I, and he was there too. So it wasn't just general chit chat. It
Okay,
was.
let's stop. Let's get a question and an answer.
Oh,
We're going
sorry.
on with narrative here. It's elongated. It's redundant. Let's move.
So do you recall Josh or Bryan ever coming back into Tabby's?
Yes.
How did that happen?
I just saw Josh stick his head in the door, and it was like a, come on, Jen. Like they had been waiting for Jen outside the door, and we were seemingly unaware because we hadn't really communicated that.
And did Kevin react to that at all?
Yes.
What happened?
He lunged to the door.
Did you do anything to try to stop Kevin?
I grabbed his shirt tail.
Did that do anything?
No.
Okay. And did Kevin go outside then?
Yes.
I'm now going to bring up exhibit. Have you seen the Tabby's Wine Bar video from inside?
Yes.
Okay. And I'm going to pull up now exhibit 16 just on your screen.
In the witness box.
And now do you see a video on your screen, exhibit 16?
Yes.
Is this inside Tabby's Wine Bar?
Yes.
Do you recognize that being Tabby's?
Yes.
And is that a fair and accurate picture of how it looked?
Yes.
On June? Remember, just wait for my question to come out. Is that a fair and accurate picture of how it looked on June 17th of 2023?
Yes.
I would move exhibit 16 into evidence and request to publish.
Any objection?
No.
16 will be received. You may publish.
Okay, and we are starting exhibit 16 at 00. I apologize, it's paused at 20 seconds. And we're starting exhibit 16 at 20 seconds again.
Yeah, look at you. Thank you. So much fun. Right, Jen. Yeah, you know what I'm doing? What to say about that food?
Right, stopped now, exhibit 16, it was 5 minutes and 2 seconds. That was a fair and accurate depiction of the initial events
Yes.
that night in Tabby's. Is that true?
Yes.
Okay, I'm now going to pull up exhibit 11, which has already been admitted, so I'd ask that it be published to the jury.
All right, proceed.
And pause. I'm starting exhibit 11 at the beginning 00.
Just remember, listen. Fuck you. Yeah, that's a fucking. Hey, put him out there. Right, just fall him down. Right out there. Come on, motherfucker. Let's go. No. Well, then shut your fucking mouth. Right, that's a key word. Right. That's the place he's just being a little girl. Little Karen. Like I said, go out there, fall him down. Right out there. Oh, yeah, this is the Tom. Kevin is not the place in Tom. Kevin doesn't put up with bullshit. How's it? It's a pussy.
I needed a seat. Maybe you guys are actually really good drivers. I've been trying forever. 20 years. 20 years. Yes. Maybe you're taking it. Maybe today's up.
I'm serving on.
Maybe today's up.
Don't take it. What did you say?
watching it at Exhibit 11 at 3 minutes and 34 seconds. So were you able to watch that, Ms. Burke?
Yes.
That was a fair and accurate depiction of that night?
Yes.
At the end here, we saw you walking out the back door, right?
Yes.
Did you ever come back inside of Tabby's?
No.
Now, I want to talk about after Kevin walks out the door, okay? I saw in this video that you stayed inside. Is that true?
Yes.
Did you go outside onto the sidewalk?
No, not until later.
Okay. But when Josh and Kevin are outside, were you outside or inside?
No, I was inside.
So did you observe what happened outside between Josh and Kevin while inside Tabby's?
Part of it.
And what do you recall?
I was looking for help. I did a quick assessment of the restaurant, like, was there anyone who could spring into action and help the situation? And no one was even seemingly aware that this was happening. And as I glanced out the window, I saw Josh outside the window.
And what did you see Josh doing?
I saw, by the time I saw him, he had a metal stool that was part of the bistro set, like a stool was over his head. I didn't see him lift it, I just saw it over his head.
And for the record, you just lifted your arms above your head. Is that true?
Yes.
Okay. Did you see Kevin?
Not from the vantage point that I had.
So did you saw Josh with the stool. Did you ever see Kevin again from the window?
No.
Did you see Josh do anything with the stool?
No.
Did you hear what anybody was saying?
I didn't hear words, but I heard Jen scream.
What did Jen just scream or did she say anything?
I heard a scream.
Did you ever overhear someone say he has a chair?
I didn't pick up on that at the time.
After you walked out, where did you go?
I was running to find his friends, Kevin's friends.
And did you find them?
Yes.
Okay, who did you find?
His friend Tom.
And what did you do after you found Tom?
I quickly described the situation that was unfolding at Tabby's and said, you need to come get your friend.
And okay, where was Tom?
He was near the concert that was happening out back had ended. He had a friend that was in the band. And so he was standing there while they were tearing down to speak to his friend.
So did you come back to Tabby's with Tom?
Yes.
When you came back to Tabby's with Tom, where were you now? Inside or outside Tabby's?
Outside. We walked along the front sidewalk and approached from the front of Tabby's.
Did you go by Hometown Pharmacy then?
Yes.
What did you see?
I saw Jen just telling me that what she had just witnessed, and I saw Josh laying on the ground unconscious.
Okay. And did you see Kevin?
No.
Did you or Tom go look for Kevin?
I said, where's the guy that hit him? And Jen said he ran off.
Okay, did you go and try to find
Yes.
him? Did Tom try to find him?
Yes.
Where did you go look?
Well, Kevin had been the driver for their group that evening, so we went towards where the car was parked.
And do you know where that was?
I don't know the name of the street. I'm sorry, it's the same street I think that the American Legion is on. I don't know what that street name is.
When you went to the area, did you see the car?
I didn't. I wouldn't have known the vehicle or where it was parked exactly, but based on what Tom was saying, he said the car's gone.
Jeff, here's.
Yes, the question was, did you see the car? The answer is she didn't know what the car was.
Correct. I'll move on.
Next question.
Did you ever see Kevin again that night?
No.
And did you give a statement to police eventually?
Yes.
Did you leave Tabby's and Beer Snobs and all of that?
I live very near there, so it's all in the same area. So eventually I went home and an officer came to my home to get a statement.
Okay. Did you, now you stated previously that Kevin put his number in your phone, is
Yes.
that right?
Yes.
Did you ever give that number to police?
Yes.
I have nothing else.
Thank you. Cross.
Thank you. You did in fact, that evening, well, probably late, maybe early morning, gave a statement to law enforcement?
I did.
Okay. And if I showed that to you, would you recognize it?
Of course.
Right, and just interrupt, can we take the state screen down from publication? Thank you.
Thank you. So first, I'm going to show this to you, Matt, if I may. Mark this exhibit 102.
Attorney Shiro, can I just see that for just 1 second?
Oh. Let's take a look. I'm showing you one of Dewey's 2 pages, ma'am. Is this a statement that you gave to law enforcement that morning?
Yes.
I'm gonna publish this for a moment. I'm gonna ask you to keep that.
Okay.
Should I move 102 into evidence?
Any objection? Any objection?
Sorry, no.
102 will be received.
There's, I'm gonna publish it, and I don't have the extra copy, so, and I'm gonna ask you something about this, if I may.
You're going to publish it on the screen?
Yes.
She'll be able to see it on the screen.
Okay, perfect.
Any objection to publication?
No.
102 can be published.
Do we have a number for this one?
102.
Okay, ma'am, it indicates a number of things about what happened that night. Is that correct?
Yes.
And obviously, this was given the same night of the event. Is that correct?
Yes, I think it was early morning.
Yeah.
After the
Okay.
event.
And so your recollection of events would be clearer because it's close in time to the event. Would you agree?
It had just occurred.
So you recalled what you had seen?
Oh, I knew what I had seen, of course.
Okay. So when when Kevin and Jennifer left Tabby's out the front door after Josh had reappeared, you looked out the window to see what was happening. Is that correct?
I glanced out the window because there was activity out there. I was still in the situation, even though I was inside and they were outside. I was still part of what was happening. And I had just been holding on to Kevin's shirt tail to stop him from going out the door.
Right, ma'am. I just
So,
asked if you were watching.
Of course. I mean, it was a lot of motion. So I was standing there and yes, I was observing what was in my view.
Okay. Now, just prior to Kevin and Jennifer leaving, Josh had come in and yelled something. Is that right?
He came to collect Jen, is what I observed.
Did you hear him yelling anything?
He stuck his head in the door and said, "Come on, Jen." That's, mhm,
Oh, sorry, I didn't mean to cut you off.
that's okay. He stuck his head in the door and said, "Come on, Jen." And I think he was collecting Jen because they were going.
Okay,
I
stop.
asked you just
Stop.
what you
Just
said.
answer the question.
Okay.
Thank you. Did he, being Josh, say something to the effect of, why are you still talking with that?
I just saw it on the
expert
video.
Let the question finish. Mr. Shiro, finish your question.
just prior, or when Joshua re-entered the doorway, he yelled something to Jennifer, is that right?
He spoke it, so I wouldn't use the word yell. He said, "Come on, Jen."
Well, there was loud music playing, correct?
There was music. I wouldn't define it as loud.
There was music playing, was
Mhm.
there not? Yes?
Yes.
Okay. And did he say something to the effect of, are you still talking to that? And then he uses a profanity. Did you hear that?
I didn't hear it at the time, but I have since heard it on the video that you just played.
Did that refresh your recollection?
No, I didn't hear that at the time.
Okay. So it indicates your statement now, ma'am, I'm going back to 102. You indicate that you, quote, "I saw through the window that Josh had a chair raised above his head to hit Kevin as he approached." Is that what you saw?
That was my statement.
Is that what you saw?
That is what I interpreted seeing when I looked out the window. Yes.
what you saw,
Yes.
correct?
I'm not being argumentative. I'm telling, I just don't want you to put words in my mouth. So I saw a chair, and I just gave my testimony. What I saw was a chair over a stool over Josh's head.
He was holding it,
Yes,
correct?
yes.
As if he was going to hit Kevin, correct?
I perceived it to be a defensive, like as Kevin was approaching him, that he was defending himself is how I interpreted it at the time.
Well, what you saw was that he being Josh, had the stool above his head as if he was going to strike Kevin. Is that true?
As Kevin approached him. So that was my statement, as Kevin approached him.
Right. As Kevin approached, you thought, looked as if he was about to strike Kevin, correct?
I didn't see any hit. I just saw a defensive move of having something over your head. So if someone's approaching you, that I assumed that would have been the next thing, but I didn't see any motion or movement moving forward at the time. That wasn't what I observed.
I understand, ma'am. What I'm asking is whether your impression from what you actually saw was that Josh was about to strike Kevin as Kevin approached Josh.
Objection, asked and answered.
Yeah, I think I
Just a
answered.
minute. Sustained.
You also indicated to law enforcement that night or that early morning that I overheard someone say, I think you put in quotes, he has a chair, or quote, he's going to hit him with a chair, end quote. That's what you heard, isn't it?
Someone from inside Tabby's, that again, as I was kind of looking around the restaurant, like,
Yeah, the question
I'm sorry,
is a yes or no.
I don't
You want to
recall
hear the
that.
question again?
Yes, sir, certainly.
Would you restate the question, Madam Reporter?
You indicated to law enforcement you overheard or you heard someone say he has a chair or he's going to hit him with a chair. That's what you heard.
So if that's what I put in my statement, I just didn't remember that after this much time has passed.
Does that refresh your recollection?
It does not.
Okay, but you don't deny that at the time of when you made that statement, that's what you recalled, correct?
I wrote, yes, I mean, I gave truthful responses when I was giving my statement at the time. I just don't remember it.
Okay. Did you see Bryan when you looked out the window?
No,
Did you see Jennifer when you looked out the window?
no,
Did you see, you were able to see Josh for a period of time, or while you were looking?
yes.
And you didn't see Kevin, correct?
From the angle I had, I could not see anyone but Josh.
Okay. And you couldn't see anybody other than Josh, is that true?
Yes.
Okay. All right, thank you. I have nothing further.
Redirect,
No, Your Honor.
this be released?
Yes, Your
Any
Honor.
objection?
No.
All right, ma'am, you can go about the rest of your day.
Thank you.
You have another witness?
Yes, Judge.
Yes, the statement called Bryan Richardson.
Oh, right, yeah, that can't go up there. I don't-
Hello. 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 Is this too loud? Turn your volumes down. Can you all hear me? I don't want to speak too loud yet. Hello? Oh, right. Is this too loud? I'm trying to be, because last time I did it was too loud. So I'm trying to whisper. Okay, I'm whispering. All right, hang on. Let me check something then. Hang on. Right, how's this? How is this? Is that better? People, can you hear me now? Is my volume a lot better now? As in, I'm speaking normally now. Is that better? Because I've turned the boost down. So I'm speaking normally now. If I turn the boost back on, it means I can't speak to you. So, okay, I've learned my lesson. That means I have, every time I want to speak, I've got to take the stream off. Fine. Right, just a test. This is just a test. Is it louder now? Is it louder now? Is this too loud? Is this too loud now? 1, 2, 3. 1, 2, 3. Still fine. Fuck, I put the boost back on. Okay, I'll take the boost off. Fine. I'll just right. Anyway, I put the boost back on now. Right. Just to let you all know, my plan is to stream all the way through. We're on day 2 at the minute, and I'm gonna stream all the way through. So yeah, it's not that you hear me, everyone. It's because last time I did this, I blasted everyone's eardrums. So I put the boost off now again. I put the boost off again now, so normal. So what I'll do whenever I want to speak, I will be like, I'll pull the stream down and be like, I'll give you a couple of seconds to put your volumes down. So the plan is we're carrying on now. I'm just giving it 2 seconds, just giving it a minute. We got about 40 minutes left of day 2. Well, it's day 2 morning. Then we're going to watch day 2 afternoon, and then day 3, and then closings. So we are probably. Bear with me. I'll check. We've got about 3. Three, 2, 4, 5. About 5 hours, maybe a little bit, 5.5. 5.5 hours of stream left. So 9, 10, 11, 12, 1, 2. So that should be about 2, 3 o'clock my time. So we'll keep going. We're going. And also, just to let you know, please don't go looking, but there is a verdict as well. So we're going to play the verdict and everything. So it's all going to be done tonight. Is the night when to become one. James, it's fine. Watch on replay. I'm just doing it all in one, and then tomorrow we got Judge Boyd back on. We're back on that one. So, Dumpster, what's Dumpster saying? Dumpster, we need to close captions for Dumpster, he says. The judge is to the point. I like the judge. Let's rock and roll. Right, let's go. Let's fucking go, everyone. Before we go, let me just do this. Press the like, press the like, press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Like and subscribe, everyone. Let's fucking go.
Yes. The last one was 102.
Mr. Richardson, would you come forward, please? Come to the witness box behind the court reporter. Sure, just step up on that platform. Raise your right hand. Do you swear the testimony you're about to give is the truth, whole truth, nothing but the truth, so help you God? I do. All right, have a seat. That black bar with the red light is a microphone. Keep your voice directed there and your voice up, all right? You understand? Yep. Thank you. All right, counsel.
All right, thank you. Good afternoon, sir. Well, not quite afternoon. Good morning. Could you please state your name and spell your first and last name for the court reporter?
Bryan Richardson, Bryan, Richardson, Rschardson.
How old are you, Brian?
38.
And what kind of work do you do?
I work in a metal factory.
Did you know Josh Davies?
I did.
How did you know Josh?
Through my brother, and then we became friends.
Do you remember about how long you had been friends with Josh?
Just a minute. That microphone is, thank you. Go ahead.
For about 10 years, probably.
Okay. And did you and Josh have any common interests?
Yes, we disc golf.
And would you do that frequently?
Yeah, probably 3 or 4 times a week.
Now, is that mostly summertime or are you really hardy?
Both.
Okay.
Mostly summer though.
Okay. And have you ever been convicted of a crime before, sir?
3.
3 times?
Yep.
Okay. Directing your attention to the date of June 17th of 2023. Do you remember what you did during the day on that day?
I believe I disc golfed after work.
So you worked that day?
I did.
Do you remember what time you worked until?
2 o'clock.
Okay. And do you remember who you played disc golf with?
Josh.
Okay. And about how long does it take? I don't even know to complete a round.
45 minutes to an hour, probably.
Oh, so much faster than real golf.
Yeah.
Okay. And did you meet Josh there or did you drive together? Do you remember?
I picked him up.
Okay. And do you remember if Josh was drinking alcohol while you were disc golfing?
Probably.
Is that something he would commonly do?
When we're out, he'd have 1 or 2.
Okay. What would he drink?
Spotted cow.
So beer?
Yep.
Anything harder than that, liquor?
No.
Did you ever know him to drink anything more than beer?
Not really. Whenever I saw him, it was just beer.
Okay. And so you think that afternoon when you were out disc golfing, you maybe had 1 or 2 beers?
Yep.
Did you stay together after disc golf?
I dropped him off and then we met back up later.
Okay. Can you tell me where you met up later?
I picked him up at his house.
Was he alone?
Him and Jennifer,
Who's Jennifer?
his wife.
And you know, to the best of your recollection, Brian, about what time of day this was?
6:30ish.
Okay. And why did you pick up Josh and Jennifer at that time?
Because we were going to downtown Heartland to the festival, Snobfest.
Yeah, and so you agreed you're going to go together, the 3 of you?
Yes,
And you were driving?
I was the ride, so I picked him up.
Okay. Did you go right to Beer Snobs?
No, we went to eat first.
Where's that?
We went into Beer Snobs and they were full, so we went down to Enters.
And Enters is a restaurant,
It's a restaurant slash bar on Cottonwood Avenue.
and it's very close to Beer Snobs,
Yeah, we
right?
walked there.
Okay. So when you got to the downtown Heartland area, did you park somewhere?
Yes.
Where did you park?
At the old Stop and Go gas station.
Okay, so for the people that aren't familiar with this area, we've been hearing a lot about the pharmacy and
Yep.
Tabby's on Capitol Drive, right?
Yes.
You know those locations?
Yes.
Where is the old Stop and Go in relation to that?
If you're looking at the front of the pharmacy, it's just to the right of it.
Okay. So you were able to park your car in there?
Yes.
And then the 3 of you on foot went to Beer Snobs? Too crowded, so you walked to Enters?
Yes.
Which is how much further?
Quarter of a block.
Okay, real close.
Real close.
All right. Did the 3 of you eat dinner at Enters?
Yes.
Do you know if Josh was drinking during this time?
I don't remember.
Were you drinking alcohol?
I had one.
Where?
When we were at dinner.
Okay. Did you have any earlier in the day when you were disc golfing?
No.
So you had one what?
I drank a Miller Lite.
And you don't remember if Josh was drinking during dinner?
If he was, he might have. I don't remember.
Okay, nothing stands out in your mind. Okay. And what happened after dinner?
We went down and kind of went to check out Beer Snobs. Kind of hung out and listened to the music. Just kind of had a good time.
Okay. And was it crowded, did you say?
It was pretty busy.
Okay. During the time that you were at Beer Snobs listening to the band, did you see Josh drinking alcohol?
Yeah, he was drinking.
Do you remember what?
I don't remember what he even had there.
Okay. Do you remember how many drinks he had?
I have no clue.
Okay. How about Jen? Was she drinking?
Yeah, I mean, yeah, they had whatever they had. I don't even know what, like I said, I don't know what was there.
Okay. Were you drinking?
No,
Did you ever go to the bar and buy a drink?
no,
So you have no idea what they were even serving?
no.
Okay.
I mean, I was with them, but I don't know exactly.
Not really paying attention to that?
Mm.
Okay. Did you stay at Beer Snobs all night?
No, we walked down, they were trying to find wine and nobody knew where wine was until later. And then we walked down to Tabby's.
Okay. So you say they were trying to find wine. Who are you referring to?
Jen and her friend, well, Jen was trying to find wine and we didn't know where it was. And then when we met up with her friend, she said that she knew a place. So we walked down.
What was Jen's friend's name?
Laura,
Had you ever met Laura before this night?
I have not.
Okay. And so this was your first time meeting Laura?
Yes,
Okay. And so Laura suggested she knew a place to get a glass of wine.
yes.
And what was that location?
Tabby's Wine Bar.
Okay. At some point, do you all travel over to Tabby's?
Yes,
And how far is it from Beer Snobs to Tabby's?
we walked there. So it was, I don't know, a minute or two.
1 minute walk, right?
Yep,
Okay. And do you remember all four of you went?
yes.
And where did you go in Tabby's? Did you go in the front door or the back door?
The back door, they have like a patio you can go up and sit on.
Okay. And were you expecting to meet anybody over there?
No.
Okay.
We just walked in. They were looking for wine.
Okay. And it was your understanding the girls wanted a glass of wine?
Yes.
So that's why you went there?
Yes.
Okay. What happens when you get inside Tabby's?
The girls walked in first. We walked in behind them. And then we were introduced to one of the customers that was there already.
Okay.
Never met him before.
And what was the name you were told?
Kevin,
Kevin. Okay. Is Kevin present in this courtroom here? Can you identify him, please?
sitting right there.
Okay, I'm sorry. So you pointed, but for the record that we have to make with the court reporter, can you please describe his appearance, what he looks like and what he's wearing?
Older male, white hair, bald with a beard.
And glasses?
And glasses.
Okay. I'd ask the record to reflect identification, please.
Any objection?
No, sir, thank you.
Identification established. Next question.
So you're also meeting Kevin for the first time?
Yes.
And do you recall if he spoke to you directly?
Not to me.
Do you recall who he was speaking to?
He was talking to Josh about tattoos.
What do you remember Kevin saying?
He said, do you know what they say about tattoos? You're going to hell for ruining God's work.
Was that early in the conversation?
That was right after Jen, his wife, introduced him as her husband.
Those are the first words Kevin spoke.
First words that I remember him saying were to Josh.
Okay. What was Josh's reaction?
Kind of joking around about it, saying how he wanted more, because I mean, that was kind of his thing.
Okay.
About tattoos.
Did you speak to Kevin?
I did not.
Did Kevin speak directly to you at any point?
I don't believe so.
Okay. Do you have tattoos on your person?
I do.
Where?
My legs and then on my arms, you can't see them because my shirt's covered up.
Okay. And that night, did you have a t-shirt covering your tattoos on your arm?
Maybe the bottom of my sleeves, but my legs I had shorts on so you could see my tattoos.
The ones on your legs?
Yes.
Okay. But to your knowledge, this conversation of these words from Mr. Sehmer were directed at Josh?
Yes.
Okay. And when Josh made the remark, I'm going to get more or something like that, you said, your impression is that Josh was joking around.
Yeah.
Why do you say that?
Because he was kind of a joking guy. It wasn't, I mean, that's what he liked. He liked his tattoos. He always wanted more.
Did you hear Josh's words to be aggressive in tone?
No, it was kind of like, oh, I'm just going to get more.
Okay. At this stage, this is still right at the very beginning when you're first meeting
Yep.
Kevin. Did you hear Josh curse at Kevin?
No,
Did you hear Kevin curse at Josh?
I know he got heated. I don't remember any specific like swear words or curse words.
Okay. And after a while, let me ask it this way. You and Josh are standing there talking to Kevin. Do you
Yes.
remember what Laura and Jen were doing?
They were sitting next to us and we kind of all were talking. Kevin was kind of on the other side of Jen and Laura from where we were.
At some point, do you and Josh move?
Yes, we went outside eventually.
I'm sorry, that was a bad question. From the time you initially met Kevin and you're standing there talking to him, did you move somewhere in the bar?
Oh yeah, so originally we were closer to Kevin, then we walked to the other side of where Jen and Laura were.
Okay. And so at that point, would you say Jen and Laura were between you and Kevin?
Yes.
And Josh and Kevin?
Yes.
Okay. And to this point, have you said anything directly to Kevin Sehmer?
No, and I don't think I did the whole night.
And did you hear Josh saying anything further at that point?
Besides getting more, that's pretty much the only thing I remember him saying.
Okay. when you and Josh get around on the other side of the girls and you're standing at the tables, were you and he talking?
Yeah, I was talking to him, kind of saying we should just go outside
Why did you say that?
because he made a comment about just going outside and practice stumbling, and just kind of seemed like it was getting to the point where I didn't want it to be.
Who's he in that sense?
Kevin.
Kevin. So Kevin was saying those things?
Yes.
You remember that?
Yes.
How did you interpret his words?
Judge, I object, it's irrelevant.
Overruled. You can answer.
I've never met him, so I don't know if he was kidding around, if he was serious. I didn't want to get it to that point. That's why I was trying to get, I was like, we should just go outside and, just kind of leave the situation.
Okay, you said that to Josh?
Yeah, I was, when I was right next to him.
Okay. You testified earlier, you don't recall ever saying anything directly to Kevin Sehmer that whole night.
Yes.
Is that right?
Yes.
Do you ever remember Kevin saying anything directly to you?
No, he pointed, but I don't know who it was at.
Okay. What do you remember about the point?
He was talking to Josh, and then he looked over. I was right next to Jen, so I wasn't sure who was pointed at, me or her.
Okay.
I don't remember much of what it was about, what was said.
Okay.
All I know is he pointed at, I couldn't even tell you who it was at.
Okay. Was he saying anything when he was pointing?
He said something, but I don't remember what it was.
What was the tone of his voice?
He seemed like he was still upset of whatever happened with the tattoos and just kind of went from there.
Do you remember any profanity used by Mr. Sehmer at this point?
Yes. I don't know exactly what it was, but he was really loud and kind of aimed towards Josh.
Do you remember him saying anything insulting or derogatory?
Calling him Karen, or actually calling him Karen.
What does that mean?
Judge, I object.
What's your objection?
The objection is he has no way of knowing what somebody means by something.
Sustained.
What did you understand that to mean in your mind, sir?
Same objection.
Overruled.
It's kind of a, I don't know exactly how to say it. Meaning somebody who is kind of like opposed to everything, kind of. I don't really know how to explain what people mean by that.
Okay.
Next question.
When he was saying these things, was he joking, in your opinion?
To me, no.
Okay.
He was still really loud and kind of in Josh's face at this point.
Okay. And throughout this, we're talking about Kevin Sehmer?
Yes.
Not Josh?
No.
Okay. Did you ever hear Josh make any derogatory statements about Kevin Sehmer, like you're a girl, you're a sissy, anything like that?
No, I don't.
Did you hear Kevin Sehmer say things like that?
Not off the top of my head, I don't remember.
Okay. Now, you said at some point you went outside.
Yes.
Tell me about that, please.
So we walked outside, and outside the door, you can go to the right side, there's a river you can sit over, and then it's a sidewalk to the Capitol Drive.
Okay.
I went and sat over the river on the benches, and then Josh kind of went off to the left side.
Okay, I'm going to ask Ms. Guzzi to put up number 2, please, in exhibit, and show you on the screen, okay? And could you zoom in just a little bit? Just get rid of that white border. Thank you. Okay.
It's in the witness box.
All right, Your Honor, this has been previously admitted. I'm going to request permission to publish.
This is exhibit
2.
2. You may publish.
So, Mr. Richardson, do you recognize what's shown in this picture?
Yes.
What do you see?
The front of Tabby's and the pharmacy.
Okay, and you were just describing for us, this photograph apparently was taken during daylight hours, correct?
Yes.
And this was nighttime hours when this was all unfolding?
Yes,
But other than that, is this a true representation of the layout?
it is.
Okay. So you were just describing for us, when you exited the bar, did you go out alone?
No, Josh and I left.
Okay. You were describing where you went when you
Yes.
got outside. Could you please, if you touch the screen, I believe an arrow will come up. Touch the screen in the area where you went and stood. Okay. And did Josh go with you?
Josh went and stood over to the right side of this picture.
All right. So if I don't want to have 2 arrows on the picture. So currently you see an arrow
Yep.
in the area where you say you were standing, right?
I was sitting down.
There's benches there, aren't there?
Yes.
Okay, and there's a little overlook of the Burke River?
Yes.
Okay, that's what that railing's for.
Yep.
And the ground actually is like an embankment down to the river from there, right?
Yes.
Okay. So you're standing where that arrow is. Are you able to show us on this photo where you saw Josh go?
Yes.
Okay, so we don't have two arrows. I'm going to ask you to draw the number 1 where Josh was standing. Okay, and that's near the front door to the hometown pharmacy.
Yes.
Okay, and so were you two speaking out there?
No, I couldn't even see him because there's a little wall on the back of where I was sitting.
Yeah. All right, and you're just out there waiting.
Yep.
What did you think was going to happen next?
I didn't think anything was gonna happen. I thought Jen was gonna come out and we were gonna leave.
Okay, and you and Bryan, I'm sorry, you and Josh are not speaking to each
No.
other. Are there other people out in this area?
At this point, it was just us two.
Okay. What do you remember? Well, strike that. First, may I preserve this as, I think we've used some of these before, so we might have like
2.
B or
B as in boy.
B boy. Okay, please preserve this as 2B.
Any objection?
No.
2B will be preserved and received.
Okay, so after you're in this position here, what do you remember happening next, Bryan?
I remember Kevin coming through the door. And at this point, I was standing up. He came running through the door and kind of just ambushed almost.
Okay, so you saw him exit Taps?
Yes.
Did you see where Josh was at that point?
Yes.
Where was Josh?
He was in this kind of the same. He kind of moved forward, but he was in the same vicinity.
Okay. Did you see Jen?
She was still inside the door.
Okay. And were you able to see Laura at this point?
I was not.
Okay. You said you had stood up,
Yes.
and were you still behind that little half wall there?
I was walking towards the front door so I could see what was going on.
Okay. And when Mr. Sehmer came out, what did you see next?
I was kind of towards his back, so I just saw him running towards Josh.
Did you see him do anything
Yeah, I saw him punch Josh.
prior to that? Right when he came out the door, did you see him do anything?
No, I saw him running towards Josh.
Did you see a stool?
Outside their stools. I don't remember ever seeing anybody with one.
Okay. No one.
I don't believe so.
Okay. Do you remember seeing a stool in motion?
No.
Overruled. The answer stands. Next question.
You don't remember that?
I do not. There was one on the ground by Josh, but I don't know who had it or how it got there.
Okay. Do you remember when you said Kevin kind of had his back towards you,
Yes.
right?
Yep.
And where did you see him go?
Towards where Josh was.
And what was Josh doing at this point?
Kind of backpedaling.
Okay. You remember seeing that?
Yes.
All right. And what did you see Kevin do?
Kind of, he just kept going towards him and then kind of just, they kind of looked at each other and then Kevin punched him.
Did you ever have a stool?
I did not.
Did you ever raise a stool above your head?
I did not.
Did you ever threaten anybody with a stool?
I did not.
Did you see Josh with a stool?
I don't remember anybody being with a stool.
Did you ever see Josh swing a stool?
No.
Am I understanding correctly? You remember Kevin just coming out and punching Josh on the side of the head?
Yeah, he.
Sustained.
Trying to get to my next point.
I understand, but you've added information to the question for the witness. You need to ask the witness what he observed, and he needs to testify.
So after you see Kevin advancing towards Josh and Josh backpedaling, what did you see next?
Kevin kept coming at Josh and then punched him in the face and Josh hit the ground.
Did you see anything in between that?
No.
Okay. Did you see Kevin actually make contact?
Yes.
Where?
On Josh's left side
Okay. And did you see how Kevin made contact with Josh?
with his fist.
Are you able to demonstrate for the jury what you saw?
Yeah, he punched him.
Okay. So for the record, you used your right arm,
Right
correct?
hand, left side of the face.
And you had your fist curled in a,
Yep.
I'm sorry, your hands curled into a fist, right?
Yes.
And you made a jabbing or a punching motion?
Yes.
Okay, and that's what you remember seeing?
Yes.
And you remember seeing him make contact with the side of Josh's head?
Yes.
What happened next?
He fell to the ground and hit his head.
Who?
Josh.
Did you see Josh brace himself in any way?
No.
Did you see him try and catch his fall?
No.
Did you see Jen try and catch him?
I don't even know if Jen was outside by that point.
Okay. Do you remember seeing Jen?
When I think she might have still been in the door. After it all happened, she ran out.
Okay. Do you remember where Jen was?
Judge, I object.
Overruled.
I mean, time, Judge.
Excuse me?
The question is vague as to time. I don't know if you said when Jen was, when.
You want to rephrase your question?
Sure. I want you to rely on your memory to the best that you can. Where do you remember seeing Jen, if anywhere, at the time Josh was punched?
Inside the door of Tabby's.
Where were you?
I was outside.
Okay. Are you near the door? Are you down the sidewalk?
I'm outside the door, more closer to the road, west towards the pharmacy, but not from where I was sitting. I was in front of Tabby's.
Okay.
Did you say less or left? When you said less towards the pharmacy
Oh,
or left towards the pharmacy?
Left when I'm coming out of the door. I was left. Yes.
Thank you. Go ahead.
Are you able to approximate for us how much time passed between when Kevin came out the door and when you saw the punch being thrown?
15 to 20 seconds, maybe.
And are you able to estimate for us the amount of time that passed between Kevin striking Josh in the head and Josh falling to the ground?
A second or two.
Was there any intervening factor between Kevin punching Josh in the head and Josh going to the ground?
No, he fell right away.
At any point when you were outside and Kevin comes out the door, did you say anything to Kevin Sehmer?
No,
You're still telling us that you don't remember ever speaking a word to this man.
I don't think I said.
This has been asked and answered.
Overruled. The answer stands. Next question.
Did you hear Kevin Sehmer say anything outside?
I don't think there were any words outside that I remember.
Okay, you don't remember Josh saying anything either?
No.
No words at all?
Mm-mm.
No? Is that a no?
No. Sorry.
Thank you.
Just one second. Nothing else. Thank you, Judge.
You guys see counsel, please?
Bench.
You want it published?
Yeah, it might be easier, Judge.
Thank you. All right, go ahead.
All right, thank you. Can you zoom in just a touch? Judge, I've asked the state to zoom in a bit. Okay. Can you see it, sir?
Yes. Yes.
Okay. Now, I can't really touch it and make anything, but I understand where you were sitting after you left Tabby's with Josh, is that you sat, what would be to the left, our left as we're looking at it, right as you exited Tabby's, is that right?
Yes.
And there is apparently a bench there, is
Yes.
that right? Okay, and that would be further in than the building itself, correct?
Yes.
So when you're sitting, or if you were standing at that bench, are you able to see, like, for example, that black car that we see to the right there? Would you be able to see that while you were standing there or no?
When I was sitting down, I couldn't see it. It's kind of tucked back behind a little bit from where that car is.
Okay. In order to see what was going on in front of Tabby, would you have had to move?
Yes.
You'd have to move towards the road.
Yes.
Can you give me a sense of how far you'd have to move?
4 or 5 feet, maybe.
Okay, all right, thank you. I don't need that anymore, thank you. Okay, so you were with Josh almost or much of the day, is that right?
Ever since, yeah, well, most of the day after 2 o'clock.
Okay. You have gotten off work and presumably he had also, correct?
Yes.
Okay. And were you pretty much, with the exception of bathroom breaks or things like that, you would have been with him the whole time, wouldn't you?
Yes, since pretty much 2 o'clock. Well, when he got off work, probably 4:30 or something like that.
Okay, and first you went to play disc golf?
Yes.
Okay. Did you and Josh and Jen ever go to some restaurant or bar before you went to Elders?
Enters.
Enters, I'm sorry?
Yeah, we went to Beer Snobs and they were full, so we went down the street to Enters.
Was there a place called Belfry that you went to?
No, that's in a different town.
It's in a what?
It's in a different town.
Okay, so from playing disc golf and then going to get him or get Jen, you were with him.
Yes.
First at after the disc golf, first at the beer snobs, which was not open or was too full, to Enders where you ate and drank. Is that
Yes.
right?
Yes.
Now, do you have any sense of how much alcohol, and by that I mean a beer, a drink, or a glass of wine, or a glass, or one of those cans of seltzer, the alcohol seltzers, how many he had?
All night?
Yeah, from the time you were with them until the time you last saw him.
Not offhand. I couldn't tell you a number.
Pardon me?
I couldn't tell you a number, but I mean, he had a few.
Well, a few typically means 3 or 4. Are you talking about significantly more than that? Sir?
Well, I mean, if he had 1 or 2 under disc golfing, and then if he had another, let's say 3 or 4 when we were out in, 4 hours later.
Did he being Josh appear intoxicated by the time you went to Tabby's?
To me, no. He was still coherent, still walking around, still talking to people, just enjoying the night.
Okay, and you know him pretty well, so you would have been in a position to know whether he appeared to be intoxicated. Is that true?
Yes.
All right. And then, so you and Josh Leap, correct? The Tabbies.
Yes.
And was that your idea or somebody else's idea or a combination?
It was a combination of both.
Both being you and Josh, or you and Josh and some other person?
Jen and I.
Okay. And then you went over at the stool, or not the stool, the bench that you spoke of, and Josh went over towards the area of the pharmacy, correct?
Yes.
Okay. And then at some point, did you see Kevin leave?
When he came out of the door of Tabby's, I was kind of standing up at that point. So he kind of ran by me to get out to where Josh was.
Okay. So you were in a position to see what happened at that point, correct?
Yes. Yes.
Okay. And you didn't see, for example, Josh picking up a stool over his head.
That I don't remember.
Well, would you have remembered?
If I would have seen it, yes.
Okay. And instead, you didn't see either Josh holding a stool over his head or Josh throwing a stool or anything like that.
I did not.
And you've been his friend a long time.
Yes.
And this was obviously a sad event for you.
Yes.
Now, you have been convicted of a crime, correct?
Yes.
How many times?
3.
So you didn't see Josh either throw a stool or raise a stool over his head, correct?
That I didn't see anything.
And you would have been able to see it based upon where you were, correct?
At the time that Kevin passed me, I was behind him, so I don't know what happened. So I was going out to where the area was, but I wasn't out in front, so I didn't know if anybody had a stool. I didn't see one.
Well, what I'm asking is if you saw Josh with a stool.
No.
And you were in a position to see that from where you were.
Yes.
Okay. And you didn't see him swing a stool at anybody?
No.
Okay. Did you hear anybody yell something about he's going to hit him or anything like that?
No.
You sure?
Yes.
Okay. And you didn't see Josh. Let me start over. You saw Josh backing up, you say?
Yeah, he was kind of backpedaling away from where the front door was.
Okay. Well, he was already pretty far away from the front door when you saw him, right?
So when he came out of the door,
he being Mr. Sehmer?
Yeah, when Mr. Sehmer was already when he was coming out of the door, Josh was kind of backpedaling away from the door because Josh came to the front door to see where his wife was because we wanted to leave. And then at that point, when he was backing up, that's when Kevin came running out of the door.
When Josh went to the front door, did you hear him yell something?
I did not hear anything.
Weren't you pretty close to him?
Yeah, but he was yelling into the building and I was on the outside of the building.
Okay, was he yelling?
Well, he yelled, but I'm assuming it was to say, let's go, let's leave, because we were about to go home.
Well, what did you hear him say, if anything?
I didn't hear anything, that's what I'm saying.
Okay, all right. But when he opened the door, he was still standing on the sidewalk, wasn't he? Or kind of
he had his head tucked in the door, so whatever he said inside, I didn't hear it.
Okay, so in any event, he being Josh started moving away from the door.
Yes.
Okay, and then at some point, Mr. Sehmer and Josh are close to each other, apparently, correct?
Yes.
And did you see Josh make any movement towards Mr. Sehmer?
No, he was backing up away from him when he was coming out of the door.
Yeah, I'm not at that stage. I'm now
Okay.
asking you about when they came close to each other. Did you see Josh lunge towards Mr. Sehmer?
No.
Did you see at the time they came close together, that is Mr. Sehmer and Josh?
Outside.
Outside.
Thank you.
Thank you, Judge. Appreciate that. Outside, did you see Josh lunge towards Mr. Sehmer in any manner?
I did not.
And you didn't see him swing on a stool?
I did not.
You didn't see him even have a stool?
I don't remember a stool.
And again, because we've asked, I'm going to try to be done with this, but you have told us and are telling us, this jury, that you were in a position to see what those two were doing at that point, correct?
Yes.
You must have, because you said you saw him get punched.
I was,
correct?
yes, I was outside and I saw him get hit.
And you saw what Josh did moments before he got hit, then, correct?
Yeah, he didn't do much. I mean, just, he was backing up and then he kind of like was just standing there and then he got hit.
Okay, all right. And you said you didn't see any stool moving or anything, but you saw a stool on the ground next to
There was a
Josh?
stool on the ground. I don't know how it got there. I don't remember if somebody threw it, if somebody used it, all I know is it was there.
But you didn't see anybody
I did
do
not, and I don't know if that was when I was still on the back side of the wall.
No, I'm talking about when you were there, so I'm not asking when you couldn't see it. I'm saying when you were watching, did you see anything happen with that stool? Or any stool?
No, I didn't see anyone with a stool, but it could have happened when I was sitting down when Kevin came out of the door. I don't know if it was used at that point, but once I got up, I did not see it.
And you saw Mr. Sehmer leave, correct?
Yes.
And you saw him moving towards Josh,
Yes.
and you could see what they were doing.
But I saw his backside when he was moving towards Josh.
Well, I understand you saw his back, but you could see more than just his back, correct?
I mean, he's a bigger guy. I didn't
Well,
see.
he's not a balloon. I mean, he's a person, correct?
Yes.
And you've indicated you could see what happened.
I saw him go towards him, but I don't know if he had anything. I didn't see anything.
But you were able to see if Josh had something in his hand.
Yeah, he was facing me.
And you would see it if he had had a stool over his head.
Yes, I would.
Okay, all right. I have nothing further.
Any redirect?
No, sir, thank you.
All right, may this witness be released?
Yes, please.
Yes.
All right, so you can step down and go about the rest of your day. Ladies and gentlemen.
Okay, so we're back. No redirect, no recross, everything right. So let me get the next afternoon session ready. That's surprising. I thought he might. 3 witnesses, 3 different. Nothing's ever easy, is it? Nothing's ever easy. Right, let's get to the afternoon session. Right. Right, here we go. I will stream it now. Right, are we ready? This is day 2 afternoon, after lunch. About 2 hours here, so. And then we'll go to day 3, so. Right, here we go.
Is a case, is there anything the state needs to address before you bring the jury in?
No, sir.
Anything from the defense?
Yes, Judge, if I may. As of yesterday, I had believed that the state would be done by noon. And so I had my expert, Ron Henson, see if he could reschedule, and he did. He was supposed to testify in Dubuque yesterday afternoon, but they changed it. They said, you can come here, and then he is going to be giving his testimony.
Counsel
first thing.
approach.
Oh, yeah.
Ms. Apper. Are they ready? Bring them in.
my next witness in?
Sure.
I got it, thank you.
Jury's just coming in.
All right.
All right, please be seated, everyone. We're continuing with the trial. State's next witness.
Thank you, Your Honor. The state will call John LAport.
Mr. Is it LAport?
Yes.
Yes, come forward, sir. Witness box is behind the court reporter. Just make your way there. Just step up on the eyes and raise your right hand. You swear that the testimony you're about to give us the truth, the whole truth, nothing but the truth, so help you God? Okay. Black bar where the red light is a microphone. Keep your voice up and directed there. All right, sir? All right, counsel, your witness.
Good afternoon, sir.
Hello,
Please state your name and spell it for the court reporter.
my name is John LAport. It's JONLA capital PORTE.
Sir, how are you currently employed?
I'm retired now.
And what kind of work did you do?
I was a computer consultant,
Okay.
local area networks mostly.
And do you have any side jobs that you used to work?
I still play music. I'm a musician.
Okay. And where do you typically play?
Usually upscale bars and restaurants and private parties, wine bars.
Okay. Have you ever played at a location known as Tabby's Wine Bar in Heartland?
Yes, I actually play there frequently.
Still today?
I still do, yes.
And how often would you say you're at Tabby's?
Probably about once a month.
Okay. And were you there last year on June 17th of 2023?
Yes, I was.
And prior to that, had you been there many times before to
Yes.
perform? Okay. And you know the layout of the facility?
Yes, I do.
Okay. And you recall that there was an incident that occurred at Tabby's on the night of June 17th of 2023, correct?
Yes, I do.
And do you remember what time you stopped playing?
It was a little bit after 10. I think it was 10:07.
Okay. And you were done for the evening then?
Correct.
So what did you do after you finished your performance?
As usual, I started packing everything up, put everything in cases, and then eventually I go get my car. I park that usually right in front of the door, so I can just bring things right out and load it into the car.
Okay. And during this time, when you're packing things up, did something draw your attention inside the bar?
Yes, most of the people were gone at that point. There were some people that were coming in through the back entrance of Tabby's from a party at Beer Snobs. They had a street party going on with a band playing, and I could hear the band playing in between my songs because they were pretty loud.
Okay.
And they quit shortly, about the same time I did, probably around 10 o'clock or so. So they were done. So there were people coming in from that party into Tabby's from the back.
And at some point, did something different draw your attention?
Absolutely. Right in front of me, there were 3 tables where a lot of my friends had been sitting during the evening. Like I said, they were all gone at that point.
Okay.
The table furthest from me, there was a large gentleman standing there with a light colored shirt and light colored hair. And the table closest to me then, there were 2 other gentlemen standing there. I mean, I saw people coming in and stuff, but it wasn't until the larger gentleman started yelling at the other 2. And
That's what drew your attention.
that's what drew my attention.
Did you know any of these men prior to this incident?
No, I did not.
Now, as you testify, do you know their names or have at least a first name for these people?
I do, because I've seen articles in the newspaper.
Okay. Do you know the name of the larger man that you were just describing for us?
Kevin Sehmer,
Okay. And of the other 2 men that you described, do you know any names for those individuals?
Josh Davies,
Okay. And the third man, did you ever learn his name?
I think it's Bryan.
Okay.
I didn't know his last name.
So if we could, going forward, to keep your testimony easy to understand, let's use those names, okay? Okay. And the person you knew as Kevin, is he present in this courtroom here today?
Yes, he is.
And can you point out where he's seated and what he's wearing?
He's sitting on the end of the table over there.
Okay. And that's the man that you now know to have first name of Kevin.
Correct.
And you just described for us, you overheard him yelling at the other men.
Correct.
Tell us what you heard.
Couldn't hear a lot because it was kind of loud, but I did hear him saying something about, do you want to take this outside? Do you want a piece of me? The 2 guys standing there, Josh and Bryan,
Yes.
were kind of looking at him dumbfounded, not saying much of anything.
So you didn't hear them reply in kind?
No, I didn't.
Did you hear them ever raise their voice
No.
or
Like I
ever
said,
curse?
Pardon?
Did you hear Josh or Bryan curse in any way?
No, I did not. Like I said, it was difficult to hear all the words.
Did you hear Kevin Sehmer cursing or using profanity?
Yes, I did. He was much louder than the other two, so I could actually hear some of his words.
Okay. And your impression was that Josh and Bryan were dumbfounded, you said? Did they?
What?
I'm so sorry, I didn't mean to interrupt. I object to her asking what they thought.
That's what his impression was.
His impression.
Overruled. Next question.
Did you see them, Josh and Bryan, physically approach Mr. Sehmer?
No, they stood at the end of the table there, and he was on the other end.
Okay. Did you see Mr. Sehmer approach Josh and Bryan?
At one point, he came around the side of the table, but then he went back, and
Did you see what he did when he got around the side?
he looked like he was pointing at them.
Okay. Do you remember any words that were spoken during this time?
No, I did not.
Okay. And what do you remember next?
As I said, I was packing up my things. I'm going out to the car. I come back in and grab a couple other things, go back out. I remember Josh and his friend Bryan walking out of the front door and walking down in front of Tabby's, and there's a pharmacy right next to that. So they're about a half a block from me. And
Okay.
the two of them were standing there talking.
Okay.
I couldn't hear them. They're too far away to hear what they were saying, but they're just standing there talking.
Okay. Did you see Kevin Sehmer at this point?
No,
Okay.
no, he was still inside. Shortly after that, then
Hang on, let me ask you a question. Did you see Josh and Bryan with any women?
inside there were.
Okay.
I guess it was a wife and a friend or a girlfriend or girlfriends or something.
But
Yeah, there
that's
were
just
two
what-
ladies with them.
Okay. Did you know that at the time? The relationship between
I didn't know
Josh-
the relationship. I just guessed that it was, either a wife or a girlfriend with them. And
Okay. And so when you saw Josh and Bryan standing out on the sidewalk, did you see the ladies out there at that point?
no, they weren't. They were just out there by themselves.
And Mr. Sehmer was inside still?
Correct.
Okay. What do you remember next, sir?
Then I remember Josh walking back into Tabby's in the front door, and I'm right here with my car,
Okay.
and the door's right here. And I thought, why is he going back in there? They obviously aren't getting along real well. And then I thought, well, maybe he's going back in to get the girls or something.
Okay. Did you see where he went, how far he went?
He went in the front door. He wasn't in there very long at all, seconds maybe.
Okay.
I don't think he was in there more than 30 seconds when I saw him come back out and walk back over to his friend, and he was standing over there with him.
Did you hear Josh say anything when he went back into Tabby's for that 1 or 2
No, I did
seconds?
not.
Okay. Could you hear anybody saying anything? at
No.
that point?
I didn't hear
Okay.
anybody say
Have to wait, sir. Have to wait for the question to be finished before
Sorry.
you answer, all right? Go ahead.
And you were by your car when you were making this observation? Okay.
And my car was right outside the front door there.
Okay. And you just told us that Josh then returned to the sidewalk where Bryan was.
Correct.
What do you remember next?
Seconds after that, I saw Kevin come out the front door, walked past the front of Tabby's. In front of Tabby's, there were some high top tables and some shorter metal bar stools.
Okay.
He grabbed one of the bar stools.
Who did?
Kevin did.
Okay.
As he walked past the front of it, walking towards the other two men standing, but still same spot, half a block away in front of the pharmacy.
You saw him grab one of the stools.
Grab one of the stools.
And did you see Mr. Sehmer do anything with the stool?
He threw it, but I don't know if he's actually trying to throw it at him. I saw it hit the curb and bounce off into the street.
Okay. Did you later retrieve that stool?
Yes, I did.
And where was it when you picked it up?
In the street, and I put it back in front of Tabby's.
Okay. Those stools are always out there.
Yes, they're always out there. Correct.
Okay. And so you said you saw Kevin Sehmer throw the stool, but do you know if it hit anybody or anything?
Just the curb as far as I know.
Okay. What do you remember next?
Next, I remember he had walked all the way down there, and he was right in front of the two guys and pretty close to them. And Josh just took like one step forward, and I saw Kevin hit him. It looked like either with his fist or with a forearm smash kind of. And then I saw Josh fall flat back on his head
Okay.
and was laying there on the concrete.
Did you see Josh with a stool at any time?
No,
Did you see Josh with a stool above his head?
no. The only stool I ever saw was the one that I picked up and put back.
And that was the one that you saw being thrown by Kevin Sehmer.
Correct.
Did you see Josh ever make a swinging motion?
No,
Did you see Josh throw any punches?
no,
How many punches total did you see?
just one
From who?
from Kevin.
And did you see it strike anybody or anything?
Saw it strike Josh.
Where?
It was hard to tell because Kevin's pretty big. and probably either, right in the front or in his face.
Okay. And did you see what happened with Josh right after that?
Right after that, I saw him coming back towards me, and he went down the street on the south, towards the south on the sidewalk.
Meaning Kevin?
Kevin did, yes.
Okay. I'm sorry, because maybe it wasn't very clear. What happened to Josh after you saw Kevin?
Josh fell straight back onto the concrete, and his head obviously hit the concrete.
Did you see that?
I saw it kind of look like it bounced.
Yeah.
I saw
Like a
his
whiplash?
friend standing right next to him there, Bryan.
Folks, you're talking over each other.
I apologize.
Yeah, I'm sorry, go ahead.
So you saw Josh drop and hit his head.
Correct.
What part of his head, do you remember?
Back of his head. It's like he fell completely straight back.
Okay. And you saw the head bounce off the pavement?
Just object, it's been asked and answered.
Overruled. He answered. Just answer Stan's next question.
Did Josh, when he was in that motion of dropping, did you see him put his arms back to try and brace his fall in any way?
He looked like he just went straight back.
Okay. And then Kevin did what?
Kevin walked south on the sidewalk and disappeared down the street.
Okay. Did you hear Kevin say anything during this incident out on the sidewalk?
No, I did not.
Did you hear Josh say anything during this incident out on the sidewalk?
No, they were too far away to hear what they were saying.
Did you hear Bryan say anything out on the sidewalk?
No.
Did you, were you drinking alcohol that night, sir?
I don't drink at all.
Okay. All right, thank you, sir. Those were my questions.
Cross.
Thank you, Judge. Mr. LaPorte, I understand that you had been at Tabby's for some period of time that evening,
Correct.
and you were finishing at about what time? If you
10:07.
recall.
10:07.
7. Okay. And I think the video, I can see you packing up your board, your keyboard. Is that right?
Yes, I have keyboards.
Okay. And then you, at some point, you're hearing this argument, disturbance in Tabby's. Is that right?
Correct.
It's kind of while you're packing up. Is that
Yes.
right? And then you went outside and you loaded your car. Is that right?
Correct.
And did you ever, after you loaded your car, did you ever have to move the car? I don't mean forever, because it's obviously not still there,
No.
but you left it there until when? Relative.
I was loading it until the paramedics.
Please.
Let me start.
You have to wait until the question is finished before you begin your answer. And you have to wait until his answer is done before you begin your question. Because we're getting into a conversation here, and that's going to make this lady's work impossible. All right? You want to re-ask the question?
I will, thank you.
Thank
sir.
you.
You indicated that your car was in front of Tabby's when you were loading it up. Is
Correct.
that true?
Correct.
And I know at some point you indicated that you later, after the incident outside, picked up a stool from the road. Is that correct?
Correct.
Now, did you ever move your car from being directly in front of Tabby's to any other location that evening or that night?
Not until I left for the evening.
Okay. And did you leave before law enforcement came?
No.
Okay, so law enforcement had already come.
Correct.
Okay. And so when law enforcement came, your car should have still been right in front of Tabby's. Is that right?
Yes.
Okay. You have a blue car?
Yes.
Okay. Hatchback?
Correct.
When you lift that hatchback, does the light go on?
Yes.
Okay. So as I understand it, you saw Josh and his friend leave Tabby's and go about a half a block away in the direction of the pharmacy. Is that true?
Correct.
And they remained there talking to each other until at some point later, Josh returned to the front door of Tabby's. Is that true?
Correct.
Do you have any sense of how long it was before Josh went to or returned to that front door?
Not more than 5 minutes.
Okay. And you were still by your car, so you saw him open the door and say something, correct?
I saw him open the door.
And is that all you didn't hear anything?
I did not hear you
Okay.
say anything.
And was that because there was too much noise or you just couldn't hear anything?
Just wasn't hearing any.
Okay. And then Josh leaves and goes back to where he was with Bryan earlier, correct?
Correct.
About a half a block away.
Correct.
And it was sufficiently far away that you couldn't really hear what they were saying. Is that true?
Correct.
And then a period of time later, you see Mr. Sehmer leave, correct? Leave Tabby's.
Yes.
He exits Tabby's.
Correct.
And he goes towards them.
Correct.
And he encounters them about a half a block away.
Where they were standing. Correct.
Okay. And sometime prior to Mr. Sehmer getting there, excuse me, getting to them, he had either pushed or kicked or knocked over somehow a stool. Is that right?
No.
Okay, it's not right. Did you see him throw a stool?
Yes.
Okay. And he threw it towards the street?
He threw it towards where they were standing, and he hit the street.
Did he throw it a half a block in the air?
No, he was getting close. He was walking with it to them.
Okay.
He had picked it up as he went past Tabby's.
Okay. And at some point, as he's walking past Tabby's, you say he threw the stool.
Correct. He picked it up as he walked past Tabby's, continued walking towards them, and threw it while he was walking.
And you believe, I think, it didn't hit anybody, correct?
Correct. I don't think it did.
Is that true?
Correct.
And you didn't see, for example, Josh pick up the stool?
No.
Okay. And so you're still, I presume, while watching this, you're somewhere near the front of, you're still near your car?
Yes.
Okay. In front of the front door of Tabby's?
Yeah, my car is like 10 feet from the front door.
Okay. And you didn't see Josh holding a stool in his hand?
No.
You didn't see Josh holding a stool over his head?
No.
Did you see any other people other than Josh and Bryan in the area where Josh encountered Mr. Sehmer?
No.
Okay. And how far away from Josh was Mr. Sehmer when Josh was struck?
3 feet, 4 feet, maybe.
Okay. And you indicated, I think, that at some point, just prior to being struck, if I'm right, you saw Josh move towards Mr. Sehmer. Is that true?
Correct.
Okay. And then he was struck, is that right?
Correct.
And there was nobody next to him, correct?
His friend Bryan was standing next to him.
Well, when I mean next, I mean like, was he within, a foot or so of him?
I'd say Bryan was like 2 feet from up, maybe. They were still standing there talking. And it's like he just took one step forward. You got to remember that Kevin had walked all the way down there with a bar stool and was moving pretty fast. So he was kind of in motion up to Bryan, and then Bryan just took one step, half a step towards
him or away from him?
Yeah, probably towards him.
Okay, so he wasn't backing away or anything?
Didn't look like it.
Got a lot of he's and hims.
Oh, I am so sorry. I meant Josh wasn't moving backwards, according to what you saw.
Did not look like he was moving backwards.
Looked like he moved forward shortly before the fight, or the punch.
Yeah, about a half a step or so.
Okay. All right. And he fell straight backwards.
Correct.
Okay. All right. Thank you. I have nothing further.
Any redirect?
Nothing, thank you.
All right, may this witness be released?
Yes.
Any objection?
No, sir.
All right, sir, you can go about the rest of your day.
Thank you.
Can I see counsel, please?
Yes, please.
Just come up here. Sit your material down. And just raise your right hand. Do you swear that the testimony you're about to give is the truth, the whole truth, nothing but the truth, so.
I do.
All right, have a seat. All right, counsel, your witness.
Thank you. Ma'am, could you please say your name and spell it for the court reporter?
Lynda, Lynda, Bidirzycka, Biedrzycki.
How are you employed?
I'm the medical examiner for Waukesha County.
How long have you had that job?
I think it's about 28 years and 2 parts.
Okay. You were here, left for a while, and then returned?
Yes.
Okay. And what are your duties as a medical examiner?
Well, the state statute says we need to investigate, medical examiners need to investigate deaths in certain categories. and that investigation can include performing exams and autopsies. So I'm in charge of investigating the deaths, and I personally perform autopsies.
What is your educational background, please?
Well, I have a degree in biology, and then I went to medical school at the Medical College of Wisconsin. Then I did a year of internal medicine, and then I changed to pathology, and I trained in pathology at the Medical College, the University of California, San Diego, and at William Beaumont Hospital. I did a fellowship in forensic pathology, which is the specialty that does the medical examiner work in Detroit, Wayne County, Michigan. And I did a fellowship in cardiovascular pathology in Boston at Brigham and Women's Hospital.
All of this summarized in your curriculum vitae.
Yes.
All right, I'd like to put up just for the witness, Exhibit 21, please. Do you have it, Doctor?
Yes.
Okay, and it appears on the right side of the screen. I can see this is a 7-page document. Is that correct?
Oops, I don't draw, it's on a scroll. Okay, yeah. Yep.
Okay, and we just scrolled through that very quickly, but you recognize this as your curriculum vitae.
Yes.
This is a document you created,
Yes.
and it summarizes all your professional training and experiences,
Yes.
correct? Okay. What is the field of pathology?
Well, pathology is the study of disease, and that includes everything. Part of it is laboratory medicine, any urine or blood sample, any biopsy or tissue taken, that comes to a pathologist, and we interpret that. Microbiology, blood banking, toxicology, clinical chemistry, cytology, it all falls under pathology in the medical sense of pathology.
Are you board certified in any way?
I'm board certified in clinical pathology, which is the laboratory part, and anatomic pathology, which is the tissue examination part, including autopsy, and forensic pathology, which is where pathology intersects with legal matters and is the investigation often of traumatic and non-natural deaths.
And are you licensed to practice medicine in the state of Wisconsin?
I am.
Have you ever testified in court before?
Yes.
About how many times?
A few hundred times.
Okay. Have you ever testified in a case where the cause of death was believed to be related to a head injury?
Yes.
Can you estimate how many times you've done that?
Well, probably dozens of times.
Okay. And were you asked to perform an autopsy on a person by the name of Joshua Davies?
I did perform an autopsy on Mr. Davies, yes.
And did you create a report to document your findings?
Yes, we create something called an autopsy protocol, which is a document stating all my observations at the time of autopsy.
All right. I believe I failed to request admission of Exhibit 21. I'm not seeking publication.
Any objection?
No, sir.
Exhibit 21 will be received.
And then please display for the witness only number 22. Do you recognize Exhibit 22, Doctor?
Yes, this is the autopsy protocol on Mr. Davies.
Again, this is a document that you authored.
Yes.
Okay. And does it contain your observations and findings from the autopsy?
It does.
Okay. Move to admit 22, please.
Any objection?
No.
22 will be received.
Please go back to page 1. And if you know these things off the top of your head, fine. Otherwise, I'm going to ask you to please refer to page 1 of Exhibit 22 and tell us the dates of the autopsy for Mr. Davies.
Well, I did his external exam first, which was on July 12th of 2023, and the internal exam of the autopsy after on July 13th.
Do you know the date of death for Mr. Davies?
I believe it was July 12th.
Okay. So that same day?
Yes.
You did your external and the next day the internal?
Yes.
Okay. Did you document Mr. Davies' age at the time of his death?
39 years old.
And it might be in maybe the next page or the page after. Did you document the height and weight for Joshua Davies?
Yes, I'll need to look at this to refresh my memory.
All right, I believe it's on page 2.
Yes.
Okay.
73.5 inches tall and 130 pounds when I saw him.
Okay. And you know that Mr. Davies was in the hospital or hospitalized for quite a period of time prior to his death, correct?
Yes.
And so his weight of 130 pounds at the time of autopsy, is that the same as his weight a month earlier on June 17th of 2023?
Well, I noticed when I reviewed the medical records that according to the bed scale, when he was admitted to the hospital, his weight was 159 pounds.
Okay. Is that unusual for him to have suffered such a weight loss in that period of time?
Well, this is almost 30 pounds would be a big weight loss. And I also am wondering about bed scales in terms of did he have medical devices or anything on him when he was in the bed scale, rather than when I weigh somebody, they're free of any devices or clothing.
Sure. But these give us a good general indication of his weight at the time he was admitted to the hospital and then at autopsy?
Yes.
Okay. Did you, were you able to determine a cause and manner of death for Mr. Davies?
Yes.
Can you please explain those terms to the jury?
The cause of death is the injury or disease that starts the process and is continuous until the time of death. Because sometimes an injury occurs on day 1, but death doesn't occur till day 5. But so that's why we say it that way. The manner of death is the circumstances under which death occurs. Manners of death would be homicide, suicide, accident, natural, or undetermined, when there's evidence that weighs on 2 other causes of death, or you simply don't have enough information, say a skeletonized body with no soft tissue and their circumstances don't reveal a story. So then that would be undetermined.
What type of information do you need in order to determine cause and manner of death?
Well, cause of death is a medical opinion. It's basically my diagnosis. So I need a foundation to make that opinion. So I look for in disease and injury in the cases that come to me to form an opinion as to cause of death.
And what about manner?
Manner of death, you look at the cause because some causes would exclude some manners, for example, possibly. But you look at the disease and injury, but you also look at the context and the circumstances.
Okay. And was your autopsy that you performed on Mr. Davies instrumental to your conclusions in this case?
Oh, yes.
And did you rely on anything else aside from the autopsy?
I did know the circumstances. They were the circumstances of how these head injuries that Mr. Davies sustained were consistent among multiple histories that I read. So the medical record, the EMTs, witness statements, police reports, they all reflected how this head injury occurred.
Okay. And if you could please go to page 2, back to page 2 of Exhibit 22. Ask you about your documented findings at autopsy, please. So did you observe any injuries to Mr. Davies?
Yes.
And those are documented on page, well, it's listed as page 1, but that's because there's a cover sheet, right?
Correct.
Okay. So what's on 22 at the top, it says page 1, there's your findings.
Yes.
Okay. Please describe your findings for the jury.
Okay. The first category is craniocerebral injuries, which means injuries to the bone, the cranium, and the cerebrum or the brain. And those included an occipital skull fracture. The occiput is the back of your head, and his fracture was on the left. And if you, I mean, you don't have to do this now, but if you found the point of your skull that was kind of protuberant, the occipital protuberance, and you drew a line down toward the base of your ear, that's where his fracture was, left occipital. He had a subdural hematoma. That is blood that collects between, if this is the skull in my hand and this is the brain, it's blood that collects between that those two entities, so it can't compress the brain. So there'd be blood in that space. Next are cerebral contusions, which are bruises to your brain itself, to the gray and white matter. They actually are hemorrhagic and bruised from contact with the inside of the skull. Intraparenchymal hemorrhage, which means hemorrhage on the inside of the brain. So I'm gonna use my hands again. If my cerebrum is here, left and right cortex, and inside, there are structures where my thumb is. There was hemorrhage deep in the brain besides the contusions that would be on the surface of the brain. And then he had secondary cerebral edema. So your brain swells as a sequelae of the injury. So not only does he have bleeding in the brain and over the brain, but then his brain says, this is really a problem for me. And then the brain tissue itself just swells.
So if I can ask a few questions that probably will not sound too artful. You described the skull fracture back left side of the head.
Yes.
Do you have an opinion as to what may have caused that injury?
Falling to the ground.
Okay. And the subdermal hematoma, do we have blood between the brain and the skull?
No, not at all.
So that's very unusual that you would find blood in that location.
It's an injury. It's abnormal. Yeah.
Okay. The contusions to the brain you described, and then you described, I believe in item D, deep hemorrhage. Correct?
Yes, correct.
Do you have an opinion as to what would cause injury to the deep portions of the brain?
We'll call it shearing forces. So now the anatomy I described and why I wanted to tell you where the fracture was. So there was also a hematoma over the back left part of the scalp. So that was the contact point. But the contusions were in the front of the brain, frontal and temporal. That's contracule If you've ever heard that word, it means that the head, it's a result of a moving head striking an object. So the head, back of the head hits the ground, but because the brain is in fluid inside the skull, it's almost like a yolk of the egg inside the shell. The skull hits the ground first before the brain does. And so the inside of the skull hits the brain opposite of the point of impact. So if the impact's in the back, the contusions are in the front. And if the impact's on the left, you might have contusions on the right. So it's because of the brain, it's characteristic of a moving head injury versus somebody being hit with a bat in a stationary skull. So the energy that also occurs that's transmitted through the brain, it's referred to as a shearing force. And the hemorrhages that were deep in Mr. Davies' brain were in an area called the basal ganglia, which is again deep, where I showed where my thumbs would be. And these nuclei have a different composition than the white matter surrounding them. So it's a point of where shear forces may be seen more commonly because of the difference in the tissue deep there. So as the energy goes from the back of the brain to the front through this moving injury, it shears internal structures as well. So that's why he had bruises on the outside of the cortex hitting the inside of the skull, be it internal injuries from the forces that caused differential movement between the structures of the brain. Does that make sense? Okay.
Do you have an opinion as to the amount of force that would be necessary to cause this type of injury?
It's quite significant, particularly because it's not common to have these deep shearing injuries. And also the back of the skull is not the thinnest part of the skull. It's maybe not the thickest, but it's not the thinnest. So there's considerable force in order to cause a fracture in that area.
Okay. Finally, item E, the cerebral edema, is that swelling of the brain?
It's swelling of the brain.
Okay, and that's a bad thing too.
Yes.
Why?
The brain is contained in the skull. So if you have swelling, it's forced through apertures. You can get forcing of the brain through the bottom of the skull going to the spinal cord. You can get forcing of the brain from the right side to the left side. And that causes injury to that portion of the brain that's basically squished into another compartment.
Was there any medical intervention or treatment that was possible for any of these 5 injuries?
They did drain the subdural hematoma, and they did remove actually a large part of the left side of his skull called the craniectomy. And they froze that piece of skull to get replaced later. But by removing the piece of skull that allows the brain to swell out rather than push the other side in or down, and the draining of the blood, the subdural blood also causes pressure on the brain. That's why it's bad, because it's supposed, the space should be empty. So when it's filled, it causes pressure. So they drained the blood, they removed that piece of bone. Then they went in and they put another drain in to try to drain the deep hematoma. Those were the first 2 operations. And then later in his hospital course, there was a reaccumulation of that blood and they drained it again.
Okay. We heard testimony earlier from his wife that Josh was hospitalized for about a month, and that during that time, he became somewhat alert, I do believe is the terminology she uses. Would that surprise you?
No.
But never was like fully conscious or able to speak or things like that. Is that consistent with your opinion?
Yes.
Okay. So let's continue with your findings then, please, back from the autopsy. So paragraph 2, please.
He also, as a consequence of the hospitalization, and he also had a breathing tube several times, he developed bronchopneumonia. It's a pretty common complication of prolonged hospitalization.
Okay. Item 3.
He had a left psoas hematoma. The psoas is your deep muscle along your spine, deep in your core, that allows you to like lift your legs. It's a very important core muscle. And right in the middle of the muscle, so the muscle is like this, right in the middle of it, there was a hematoma.
Do you have any opinion as to what may have caused an injury like that?
I think the force of landing on that left side of his body.
Okay. And then finally, your 4th finding.
He had what I call the myxomatous mitral valve. That's a natural disease. His valve in the left ventricle, called the mitral valve, had a spongy quality, and microscopically it was thickened with a substance that would normally not be there in that amount.
That was in his heart?
In his heart.
Okay. What did you conclude as to cause of death, please?
Complications of craniocerebral injuries.
Did the heart problem kill him?
No.
Okay. And you detailed for us very thoroughly these injuries that you observed and explained them to us, but can you just explain that ultimate conclusion? What killed Mr. Davies?
Terrible brain injury. Yeah.
Okay. Were you able to make a determination as to manner of death?
Well, manner of death was homicide.
Judge, excuse me, I'm objecting to this,
You're objecting to what, sir?
to her testimony regarding the manner of death. since it's based upon review of police reports and et cetera, according to her earlier testimony.
This feels like it's going to need some argument.
Well, we may be able to do it at a sidebar, but yes, I would like to respond.
Let's try to sidebar first.
Okay.
Again, or do you want to repeat it? Because I thought we heard an answer and then there was an objection after the answer. You want the reporter to read it back?
I would just ask it again, Judge. and
Okay,
pick up where I
perfect.
left off.
Go ahead.
So, Doctor, did you form an opinion as to the manner of death for Joshua Davies?
Yes,
And what was your conclusion?
that it's a homicide
And what did you base that on?
because it was an act of another, intentional act of another that caused the injury that led to his death.
Okay. And that's a medical determination by you at this point, it's not a
It's-
legal.
No, I'm sorry. That was a confusing answer. It is a medical opinion, not a legal opinion.
Okay. Would you say, in your opinion, Doctor, that the injuries suffered by Joshua Davies, you've already testified, would have required significant force, in your opinion?
Yes,
Would you say it would be consistent with Mr. Davies tripping over an object?
no,
Why not?
not enough acceleration. Force and injuries are caused by force. Velocity is the main determinant of force, as well as, I mean, you could have less velocity with a more vulnerable site. But as I said, that's not a very thin part of the bone. And there was all this shearing force that traveled through the brain to cause the deep hemorrhage. So those are indicators of significant force from acceleration. If you just trip, you really don't get that amount of force.
Thank you, Doctor. Those are all my questions.
Thank you, Cross.
Thank you. Doctor, you had a chance to review the medical records, is that correct?
Yes.
Now, Doctor, I'm going to show you what's been marked as exhibits 1, 7, and 108 that have been shown to the state already, Judge. Oh, I'm sorry.
Oh, these other ones.
You want
Yeah.
107?
Okay, thank you.
Well, we can do one at a time. Or you're going to show them physically?
Yes, I'm going to show you.
All right, go ahead. Get so used to the TV that I think everything's coming up there.
Doctor, I'd like you to just take a moment to look at those. I don't think it'll take you long, because I'm going to ask you about a specific item of information on that.
Okay.
All right. The hospital did a blood test on Mr. Davies when he was admitted, is that correct?
They did a lot of them.
And one of the tests they determined is on exhibits 107 and 108, which shows that his alcohol level was 0.267.
Here it's 267, which would be,
267.
yeah. right.
Okay. And we don't know if that's whole blood or serum, do we?
No,
Okay. If it were whole blood, then 267 is 267, correct?
correct.
That's a very high alcohol level, is it?
It
not?
is.
Okay. Now, if it were hemoglobin, I think you believe that then it would be 2.4. Does that sound right?
No, if it was serum,
Serum, I'm sorry.
yes. If the test was done on serum, the equivalent blood alcohol, because blood alcohol, as we speak about it for drunk driving and such, refers to whole blood. So if it's serum, the conversion would make it lower.
I think 2.4.
Yes,
Is that right?
yes,
That's also a high level.
yes.
Okay. So we know that this young man had hit some concrete. Everybody appears to agree with that. Is that right?
That's my understanding.
Okay. Now, and you indicated that tripping wouldn't typically show that much force, correct?
Correct.
Now, however, what if the person who fell in part because he was trying to swing a heavy object like a metal stool, and that was blocked, as that person had kind of, in this case, the deceased had kind of gone airborne trying to hit somebody. Would that increase the velocity of his fall?
I think the hypothetical would depend on the resistance met by the stool or whatever because it would be the transmission of the force through Joshua's body that would still be necessary and in an accelerated fashion to cause the fall.
Right. Newton's third law of motion, correct?
Oh, I don't remember if that's it, but
So if somebody is moving with a lot of force and then it meets an object that's moving force away, that's going to transfer that velocity into the person.
Well, it can and it can't. I mean, if you think about car crashes, it really depends on, the collision. Sometimes one side gives, sometimes the other side gives. A hard force meeting a hard force. So we're getting into more physics than I think I could possibly give you a single answer to.
Okay, all right. But you understand that the issue of velocity, how that can get transferred to, in this case, Mr. Davies, could depend upon how exactly what he was doing and what force it meant when he did it, correct?
Well, yes.
Okay. Now, would you agree that a person who has either a blood alcohol level of 267 or 24 would be intoxicated?
I would say yes.
I mean, you are probably aware from your work that the legal alcohol limit for drivers is 0.08, correct?
Yes.
This is well over that, correct?
Yes.
It's almost 3 times, correct?
Yes.
And that would affect their coordination, correct?
Yes.
And their ability to operate in space, I mean, physically, correct?
Yes. Correct.
And they would have a harder time doing physical acts than somebody who didn't have such a high BAC.
That's true.
And so the likelihood that a person with an elevated BAC level is more likely to have less ability to both control themselves and, if they're falling, to control their ability to break the fall, for example.
That's true.
That's true? All right. I have nothing further. Thank you.
Thank you. Any redirect?
Yes, just briefly following up on that. Does tolerance play a role in that?
Yes.
Can you describe further?
Well, again, just thinking back on my experience, they say that people would die at a 0.40 alcohol. And I have patients that have come to me from hospital that have walked into the hospital at over a 0.4. Okay, so there are people that develop tolerances. Also, that metabolism is a different story. But yes, there are people that can tolerate more alcohol than others.
Thank you. Oh, sorry. Therefore, if a person can handle the alcohol better than another, does that, can they therefore control their movements and their balance and things like that better?
For any individual, you can't really say for sure what level of impairment any particular blood alcohol would be. That's individual. But in general, we know alcohol causes these certain things.
Thank you.
Any recross on that limited scope?
Yes. So when you talk about tolerance, you mean somebody who drinks a lot. Is that what you mean?
Yes, they become tolerant.
Okay. And to be able to have high BACs, like you were speaking of with that one of your patients, those are people who are drinking not small amounts, but a large amount of alcohol every day.
That's true.
All right. Thank you. I have nothing further.
Will this witness be released?
Yes.
Yes.
Leave the exhibits here.
Oh, thank you, and I appreciate that.
Council approach, please.
Are they still up there? Yeah. Okay. So I was going to move in.
Just a minute, just a minute. You want to set your material down? Just raise your right hand. Do you swear that the testimony you're about to provide is the truth, the whole truth, nothing but the truth, help you God? I will. Have a seat. That black bar with the red light is a microphone. Keep your voice up and directed towards that. Mr. Sherrill, this is your witness.
Thank you, sir. Sir, I wasn't listening because I was talking to counsel. Did you state your name?
I did not.
Did you state your name and spell it?
Yes, Ronald Henson, Ronald Henson.
Okay. And what do you do for a living, sir?
I'm an independent consultant in drug and alcohol related matters. I work for insurance companies, employers, civil law firms, and also criminal law firms.
Okay. And I'm going to ask you about your background in education. Okay. So the first thing I'm going to do is bring you exhibits 104 and 105, which are part of your CV. Okay. And an addendum to your CV. With your permission, Judge.
Please approach.
Looking at your CV page or exhibit 104, how many pages is that?
It is, should be 20. There's actually another. So this is 22 pages.
Okay. There's an addendum to your CV.
There is an addendum.
That's exhibit what?
105.
How many pages is that?
And that is 6 pages.
Okay. if I may, and you can reference your CV if you need it, but I'm going to ask you first about your education. Can you tell me all about your post-high school education?
Sure. Post-high school, from the vocations, I'm a graduate of Illinois State Police Academy with also additional advanced coursework, training with regards to drugs and alcohol. From academia, I have 4 college degrees. I have an associate degree in sociology and psychology with studies in drugs and alcohol. I have a Bachelor of Science degree from the University of Illinois. It was in their criminal justice program, and I received additional training in drugs and alcohol, physiology, and pharmacology through that program. I have a master's degree of public administration from Governor State University. It's a state school in Illinois. And my thesis was driving under the influence, processes and procedures for law enforcement, specifically to Illinois law enforcement. I have a PhD degree from Walden University in Minneapolis, Minnesota. My residency was performed at Indiana University. My subject matter dealt with drug and alcohol testing in the workplace. So it was in the management program and decision sciences, since I was dealing with employees and employers, but it was regarding drug and alcohol testing in the workplace.
Have you written any articles or books regarding anything related to drug and alcohol testing or the effect of drugs and alcohol?
Yes, I have multiple book chapters, as well as a college textbook chapter. I've been the reoccurring author for the Illinois Institute for Continuing Legal Education on chemical testing. That started in 1995, 96 timeframe, and I just submitted the galley proofs for the publication to be updated this fall of 2024. I've published in Understanding Scientific Evidence by Thomson Reuters. That was published a few years ago. I published a college textbook chapter regarding alcohol production, physiology, and pharmacology. And that textbook was used by Illinois State University because I frequently appeared as a guest lecturer in relationship to that chapter, as well as I'm not sure what other universities use that chapter, but that was published by Kendall Hunt Publishing out of Dubuque, Iowa. And there are at least a couple others.
Okay. Have you done any teaching?
I have.
Where have you taught and what subjects?
Starting in 1986, I started teaching at the University of Illinois at the Police Academy, the Police Training Institute, in drugs and alcohol, breath, blood, urine testing, and the methods of collection of evidence, the methodology of testing, the results, alcohol extrapolation, which is anti looking forward, and then also retrograde is looking backwards. And
Can I just stop you for a second? What do you mean by that?
If I were to dose somebody, if you said I need to get somebody to a 0.10, I would take their gender into account. I would take their body weight into account. I would take into account when they last ate, and I would utilize a calculation to program them to drink a certain amount of alcohol that would get them to that 0.10. I've dosed over 1,000 people and always been within plus or minus 0.01 of my calculations. Looking backwards in time, where we have a time where a person is peaked in blood alcohol concentration and they're now on the downward slope. Sometimes questions come up as to what were they at some time earlier in their drinking process. And so then you could look at oxidization rates or metabolism rates for the alcohol that the body goes through, and be able to make that calculation as well. So I think here in Wisconsin, they use what's called the Hens chart, and the Hens chart is based on Woodmark's formula.
Okay, so I interrupted you. You were talking about other teaching you did?
Sure. So I taught starting in 1986 and 1988. I was put in charge of the teaching program at the University of Illinois for law enforcement with regards to the drug and alcohol, biological specimen collection, testing, training law enforcement. I also trained people from the medical profession with regards to the forensic side versus the clinical side of blood alcohol, urine alcohol evidence. That continued till the mid 1990s. And then early 2000s, I started my own drug and alcohol testing laboratory, and that's still in existence today. I sold it after about 3 years, but I remain as a consultant all the way to today. And it's an operation in Peoria, Illinois. I have also been a professor at Iowa Wesleyan College in redundant, but it's in Iowa. And then I've also taught online and was Dean of Online Instruction for Aspen University as well. So that's, in a nutshell, as best I can, my teaching experience.
Why don't you tell us, or please tell the jury about your employment history?
Employment history, I started out as a police cadet in 1979, so about 45 years ago, roughly. Became a police officer in the suburbs of Chicago in 1980. Continued in that process. I served as a police officer and investigator. I worked with the drug and narcotic unit for a period of time and was also their lead person with regards to alcohol investigations. That continued until 1986. Then when I went to the police academy and started teaching full-time at the police academy. I'll let you ask another question.
Okay.
I'm not sure where to stop.
So since, did you stop teaching at the academy, correct?
Stopped teaching at the academy in the mid-1990s. I was embarking on my PhD degree.
Okay.
I had an opportunity to work for the federal government as an independent consultant on research studies. And then I also had some local consulting contracts with police agencies as well. Embarked on my PhD studies, started a laboratory, and then taught as a professor. And then I had to leave that because it was difficult with getting into, I was getting phone calls regarding consulting in various cases. And then I started appearing on courts. And it was great in the summertime when I was off, but during the academic year, it was difficult to coordinate teaching and being in the courtroom. So I had to give up my professor position, and that's why I went to the online teaching.
Okay, and you own a company now?
Yes, Barron Consulting and LabWorks is my company.
And what does it do?
It does various things. Sometimes we'll conduct independent research with regards to breath alcohol testing with certain machines. We have about 11 different breath test devices. Sometimes I review evidence, forensic evidence, biological evidence, such as blood testing, urine testing, collection of samples. Sometimes I coordinate independent testing of those samples in some cases just documenting what you observe. Sometimes the urine has leaked out in the bag, or there's compromisation with the blood tubes. So it's just simply documenting and identifying what those observations are and tendering a report. And then review various cases involved in company policies, as far as policies of employees regarding drugs and alcohol. Even consulted with the sheriff's department because of the issues of medical marijuana and how that affects their sheriff's department employees. And so it was working with both the union side and then also obviously the sheriff and his management team to come together how to deal with that from their employee standpoint. I was able to gain the contract in Peoria for Sam's Club, Walmart, Caterpillar, the United States Coast Guard. So there's a multitude of different employers that I've been involved with over the years regarding drugs and alcohol, regarding their policy aspects. And then insurance companies, in life insurance issues when they find perhaps drugs in the post-mortem samples and determining whether it was illegal use or if it was beyond therapeutic use and whether or not they would pay out the life insurance. So that's when they may hire me directly and to evaluate that so I can share with them and say, yes, it identified amphetamine and methamphetamine. However, the individual had a prescription for Adderall for ADHD. Well, that particular medication will show up as amphetamine and methamphetamine, not the illegal methamphetamine that one is smoking and using. So those are some examples.
So have you testified as an expert in the past?
Oh, yes.
How many times?
At this juncture, certainly well more than 500 times, maybe more than 1,000.
And in how many different states?
About 30 different states from Alaska to the East Coast.
Have you testified in the state of Wisconsin?
I have.
How many occasions?
Probably at least 35 or 40 cases.
Have you ever testified in this county?
I have.
Okay. And what were the subjects of your testimony? I don't mean details of it. What kinds of things were you asked to testify about?
Anywhere from breath alcohol testing to blood alcohol concentration levels, standardized field sobriety testing, behavioral manifestations, things that may affect reliability testing, or give clarification as to here's what the testing does tell us, but here's what the testing doesn't tell us, or the observations tell us. For example, the odor of alcohol. Yes, that is noteworthy, but based upon the odor alone, you can't tell how much a person has consumed or what they consumed, whether it was vodka or beer, but you have the odor. So that's a case where it's a clarification.
Have you, whom have you testified for in your business?
I've testified on behalf of insurance companies, employers, civil law firms, about 50% for the plaintiff and 50% for defendant. In criminal cases, when I worked for the government, it was more than 90% for the government. Since leaving government, it's 90% or slightly more for defense, because the state has budgets of people like me already on the payroll, so there's no need unless it's a unique case.
All right, counsel, let's move this along.
Thank you. Do you have any expertise with regard to determining the effects of alcohol consumption?
Yes,
Okay. And have you testified about that in the past?
I have.
Okay. Judge, I'm offering Dr. Henson as an expert in this field.
Well, it no longer requires the court to certify his credentialing, so I will decline the invitation. You can ask your next question, please.
Okay. So did you have an opportunity to review some materials in conjunction with your testimony in this case?
I did.
Okay. What materials did you review?
There were in the large scope. There were two different videos, but there was a breakdown of the video segments. But the videos from inside a bar establishment, and then a surveillance video from a retail store of some type that showed a portion of an outside area, and the medical records, which was I think it was a little over like 233 pages.
Okay. And in looking at the medical records, did you note a blood alcohol level that was obtained from Mr. Davies on the day he was taken to the hospital?
Yes.
Okay. And what results did they obtain?
They identified 0.267.
Okay. Now, can you tell us whether or not you were able to determine by looking at the records whether this was whole blood or serum?
No, they did not. They did not break that out. However, it was later identified that it was serum.
Okay. And so do you have to modify the result or change the result based upon it being serum?
Yes, hospitals typically analyze serum or plasma, which is an extraction or a divisor from whole blood. And so therefore a calculation has to be performed to make an equivalent of a whole blood. I use an average of 1.18, which is considered an average conservative value. I think there are some that use 1.16 as well. 1.18 gives a close approximation to that average.
So if I told you that the medical examiner, when looking at that, came to the 267 serum, came to a 0.24 result, do you have any problem with that?
No, it sounds like they probably used 16% or 17%, and I used 18%, so more conservative. My number comes out to 0.22, so it's a slight lower using that 1.18 conversion.
Okay, so between 0.22 or 0.24, would you expect anything significantly different between somebody with a 2.4 as opposed to a 2.2?
No, no, you wouldn't.
Okay, using either one of those numbers, what are the kinds of symptoms or that one would find in somebody with that level of blood in their alcohol in their blood?
Sure, it certainly would have gross motor skill impairment, fine motor skill impairment, comprehension would be affected, reactionary time would also be slowed and impacted, as far as also the response, which is arguably closely related to the reaction, and the response would be affected at that level.
Would you expect, or do you have an opinion whether or not somebody with that blood alcohol level, either the 2.2 or the 2.4, would have difficulty doing kind of large gross motor skills, like swinging a stool?
Absolutely, absolutely.
And would that matter whether the person was an experienced drinker or no?
And not at that level. It's a significantly high level.
Okay. And you would expect to find that in Mr. Davies, those concerns or those symptoms in Mr. Davies given his blood alcohol level?
Yes.
Okay. All right. I have nothing further.
Cross.
Dr. Henson, you never saw Mr. Davies that night?
Just
in person, sorry.
Yeah, thanks for clarifying. Yes, not in person, just the video.
And you've been a police officer at the start of your career, right?
Yes, I did.
And one of the best ways of evaluating impairment and seeing that person in front of you. Is that true?
In person certainly is better than video, yes.
And you talked about tolerance. You kind of talked about it just a little bit here at the end. Do you recall those questions? Alcohol tolerance?
Yeah, it was not termed tolerance, but I think that you could insert that in that last hypothetical, that some people may perform better at a 0.10 than others, and that's due to the tolerance.
And that could be the same for 0.20 as well.
0.20 is going to alleviate some factors with regards to tolerance level. However, you are still going to be grossly impaired no matter what your experience is.
Okay, so, but would you agree that a novice drinker who rarely drinks is going to show impairment at a 0.20 differently than somebody who uses alcohol pretty routinely and has a tolerance?
I would agree with that. A novice drinker may not even get to a 0.20.
They could black out, right?
Well, usually they vomit. And then,
Okay, yes.
usually they vomit. So there was one study that I did for the Department of
I'll
Psychology.
stop you.
Okay.
Next question.
And somebody at a 0.20 who has more higher tolerance, they might not be puking at a 0.20.
That's true.
And there's just a lot of factors that depend on what that impairment looks like at a 0.20 based on that individual.
Yes, from a gross motor skill standpoint, there are some differences, but you
Um,
still wouldn't want them hitting the brakes or the accelerator at a 0.20 no matter what their experience is.
But their weight can affect how they show impairment at a 0.20.
Weight could have some variability in extreme levels because you have some outside influence other than the alcohol.
Food that's in your stomach prior to drinking that could affect how we see a 0.20.
It's going to deal with the absorption, but in this case, food's not a factor. Food isn't going to change that value, and food's not going to change your mental condition. It may change the height in which you get to the peak alcohol level. But in this case, there was between 8.5 and 9.5 drinks in his blood at the time it was tested, and that wouldn't change based upon food consumption.
But you don't know when he drank any of these drinks. You can't say that necessarily without a drink history.
All we know is that's what was in his system. If he started drinking at 6 p.m., then he had a lot more than the 8.5 to 9.5 drinks.
But you don't have a drink history for Mr. Davies.
I do not.
And to be clear, you reviewed the medical records in terms of finding that alcohol level. Is that fair to say?
The alcohol level and statements regarding intoxication.
Okay. You didn't review the medical records for medical purposes in terms of head injuries or anything like that.
I did not. I'm not an expert on the head trauma part.
And I want to talk about would you agree with the statement that while we can talk about generalities at a 0.20 and, you know, talk about those certain symptomology and those kinds of things at a 0.20, it really is something that you have to look at that person and see how they exhibited a 0.20.
There are some generalities that are across the board, and that was not only borne out in literature, but also I've done the experimentation. But there are some that have some slight variation, but there are some behavioral manifestations and pharmacological effects that is pretty much straight across the board, but there is some variation.
For example, somebody may have slurred speech at a 0.20, but they may not.
It's all based upon the observer.
The observer and
Do you know how the person normally speaks?
someone can also have a decreased reaction time when they're at a 0.20.
That can have, they will have.
So
That's a given.
is it possible that somebody at a 0.20 might be less capable of reacting to a sudden attack?
Yes, that's what I testified on direct, and I agree.
Now, looking at your educational background, in all of your degrees that you talked about, none of those are in chemistry.
No, I had chemistry as coursework, but not a degree in chemistry.
None of those are in biology.
Yeah, same coursework, but not a specific degree in biology.
None of those degrees are in pharmacology.
Again, coursework, but not a specific degree.
None of those are in physiology.
Again, training in my undergraduate work, but not a specific degree.
And none of those are in medicine.
No, it'd be very light medicine at best, which would be more along the line of first responder. I'm not a clinician in the medical field.
Okay. And as a police officer, you received maybe some more advanced first aid training. Is that fair to say?
Fair to say.
And that was back in the 80s, 90s.
80s, 90s.
Okay. And in all of your training and experience, both government and private, you never worked at some sort of lab testing blood samples?
No, I did a stint at Joliet Forensic Crime Lab, but I was paid by the police agency, not by the crime lab.
And that was more of a observation of how the analyst in that lab did things?
It was, yeah, it was training on gas chromatography, mass spectrometry, and blood sample analysis.
And that was around maybe 40 hours.
That's about right.
And you talked about being qualified as an expert in several states, correct?
Correct.
And you would agree you've also been excluded as an expert in states as well?
My testimony's been limited, but not totally excluded. Sometimes there's limitations.
So part of your testimony has been excluded at certain points.
That's correct.
And this case involving Mr. Sehmer, how much were you paid to write your report?
To review all the evidence and everything, and then tender the report, that was $2,000.
And how much were you paid to testify here today?
Testimony's free, but my travel and time was $3,500. That my airfare, overnight stay, rental car, everything is included in that fee.
So about $5,000.
In total?
Yeah.
Yes, in total, and then extract out probably about 12 to 1,500 roughly in travel.
I don't have anything else, sir.
Can you redirect?
Yes, please. Dr. Henson, you were asked about the impact of food and et cetera in terms of the BAC.
Yes.
And you indicated what?
Well, food would impact if I'm dosing an individual or somebody's consuming alcohol. You're not going to achieve as high as a peak with food. It's going to be a little lower. So maybe if I dosed you and you had food, which I did oftentimes after a lunch, I would anticipate that would impact by about 0.02. So if I programmed you to get to a 0.15, I would expect you to actually be a 0.13 because the food is going to slow down that absorption and you won't get quite as high. Versus an empty stomach, you're going to go up much more rapid and you're going to have a little higher point.
All right. You were also talking in your responses to counsel about the fact that it is hard to determine how many drinks a person had without having a drinking history, correct?
In total, we know how much based upon the blood draw and specimens tested. Very accurate on that portion. But without the drinking history, I can't tell you how much was consumed during the evening or the day and evening. That I can't tell you.
You indicated in your report that you thought that BAC 2.0 to 2.26 would be somewhere between 8.6 and 9.77 standard drinks. If the drinking had started much earlier, say at like 4, would that number be larger or smaller?
No, that number would not change because I'm simply looking at how much was in his blood at the time. The number of drinks would be higher because those would be burned off. In other words, what you drank at 4 in the afternoon, at midnight, it's gone from your system. So you could calculate that and say, well, there was another drink there. Yes, but it didn't impact the blood result in the case. So that's why I know my numbers are accurate for the blood result.
But had the drinking started much earlier, the number of drinks that you would extrapolate would be different.
Would be higher, yes.
It'd be more drinks to get there?
Yes, yes.
Okay.
Because you have to take into account then the burn off rate.
Okay. So as people drink, they absorb and then it starts eliminating.
Right, your liver and your kidneys kick in and start oxidizing that alcohol.
So assuming, hypothetical, that he started drinking, then let's just say 6 o'clock. Now, or how many drinks would there have had to have been to have him get that level at the time of the blood draw?
Well, we know that approximation, give or take, at about 9 drinks. And then if it was 6 o'clock to get that level, I know that you're probably looking at an additional 5 drinks at a very slow pace, 1 per hour. Could be higher than that.
Okay, thank you. I have nothing further.
All right, may this witness be released?
Yes.
All right, you can step down.
Thank you, Judge.
Judge, I would move in the exhibits, please.
Numbers, please.
Yes, where are they? Oh,
I do.
Have a seat. All right, counsel.
Detective Hoffa, can you please state your full name for the record?
Paula Hoffa.
How do you spell it?
Paula Hoffa.
How are you employed?
I'm a detective with the Village of Heartland Police Department.
How long have you been with the Heartland Police Department in total?
17 and a half years approximately.
How long have you been a detective there?
Almost 10 years.
And prior to that, what was your position?
I was a patrol officer.
And can you tell us about your basic training in order to become a police officer?
I have a bachelor's degree in criminal justice, and then I went to the police academy.
When you graduated from the police academy?
I did.
And since you graduated from the police academy, did you become a certified law enforcement officer?
Yes.
Did you maintain that certification up until today?
Yes.
And in your role as a detective, what kind of investigations do you do?
I am the only full-time detective. It's a small agency, so I do all of the investigations. However, I do specialize in sensitive crimes, crimes against children, and death investigations.
And did you eventually become involved in an investigation involving Kevin Sehmer on around June 17th of 2023?
Yes.
How did you get involved?
The morning of June 18th, 2023, at approximately 2 a.m., I was contacted by my deputy chief on my cell phone, and I was advised of this call, and he asked me to come in and to start working on it.
And when you came in and worked on it, first of all, were you able to identify Kevin Sehmer?
Yes.
And how did you go about that process?
There was a phone number that had been given during the course of the night of June 17th at the festival, and the officer had found the phone number, gave it to me, and then we put it into our in-house police computer system and got the name of Kevin Sehmer, having prior contacts in Waukesha County at an address in Brookfield.
City of Brookfield?
Correct.
Okay. Did you try to call that number?
Yes.
Did you receive a response from calling it initially?
No.
After that, you learned that you lived in Brookfield, is that true?
Yes.
And you heard the specific address, right?
Yes.
Okay. And at some point, did you go to that address?
I did, along with my third shift lieutenant.
Did anybody else meet you there?
Yes, the City of Brookfield's third shift officers met us there as it's their jurisdiction.
About what time did you go over to Kevin Sehmer's address?
We arrived at approximately 5:23 a.m.
On what day?
That would be Sunday, June 18th.
And when you got there, what did you do?
We knocked on the door. My lieutenant was knocking on the door rather loudly for several minutes. I noticed there was a vehicle in the driveway, so I ran the license plate. I then also started calling Kevin Sehmer's cell phone and texting.
At 5:23 a.m., as you're at his residence, did you ever receive a response at the door?
No.
When you did anybody respond to the door?
No.
Okay. Did you eventually leave the house?
Yes.
Okay. And after that, did you ever receive phone contact from Kevin Sehmer?
Yes, I believe it was around 10:56 a.m. on Sunday, June 18th. He called back my work cell phone.
Okay. And did you talk with him about this incident over the phone in detail?
It was very high level, very brief information.
Did you have Mr. Sehmer come in for an interview?
So at that time, I was already responding back home to my residence, and he said that he wanted to talk, and I said, okay, I need to make some arrangements of either me going back into work or having another officer respond in to do the interview. And so then I started responding back into work and calling some of my bosses, and then Kevin called me again somewhere in between 11 a.m. and noon and wanted to know what was going to happen. And then that's when I made the arrangements that he should just come to the Heartland Police Department to speak with me.
And at the Heartland Police Department, is there an interview room that's able to both video and audio record everything?
Yes.
And is that the room you used?
Yes.
So first of all, Kevin Sehmer comes to the police department, right?
Correct.
And you meet with him.
Correct.
Do you see that Kevin Sehmer that you met with here in court today?
Yes.
Where is he seated? What is he wearing?
He's seated in front of the blue Kleenex box, and he's wearing a dark gray suit and glasses.
That's at the record reflects identification of the defendant.
Objection.
No.
Identification established. Next question.
And then you guys go into the interview room.
Correct.
So now initially, did you get just some biographical information about Mr. Sehmer?
Yes.
So what kinds of just basic biographical information did you get?
Well, prior to him actually coming into the interview room, I had run him through our Department of Transportation. And then when he came into the interview room with me, then I got like his name, address, phone number, all of that kind of thing.
And he told you he was married?
Correct.
And he had some kids?
Yes.
You got all that information?
Yes.
And then after you have this initial information, you start talking to him about this day, June 17th of 2022.
I did.
And did you have him go through kind of a timeline of events of that day?
Yes, I just asked him to tell me everything that happened, and I sat there and listened for quite some time.
So I'm going to bring up prior to bringing this up, did you ask Mr. Sehmer about if he drank any alcohol this night of June 17th, 2023?
I did.
And what did he tell you?
First, he said he had 4 drinks, and then later in the interview, he had said 4 or 5. However, he did tell me that the last drink that he had, he'd only taken a sip out of it.
So he had somewhere between 4 and 5 drinks, right?
That's what he indicated.
Did he tell you like a time frame from when he drank that?
No, however, he did say that he got down into the Heartland area around 8:15.
And did he say when he left the Heartland area?
Not specifically.
But you know that this incident happened around 11 p.m.
Correct.
So in terms of the drink history, you asked him what he had before that time frame, 11 p.m.
Yes.
So I'm going to ask to bring up, you reviewed this interview that you had with Mr. Sehmer prior to today?
I did.
And now I'm going to bring up, should be exhibit 18. Oh, that's not it.
There's a,
That's not it, sorry. It's exhibit 24. Okay, pause. And Detective Hoffa, do you see on your screen exhibit 24?
I do.
And do you know about how long in total your interview with Mr. Sehmer was that day?
It was approximately 2 hours. The last part of it wasn't like actual question and answer. It was more just procedural, getting things prepared.
Okay, and the clip on the screen, you can see it's 6 minutes and 55 seconds, right?
Yes.
And this looks like a fair and accurate depiction of the video interview that you did with Kevin Sehmer that day.
It does.
I would move exhibit number 24 into evidence, and then I'll ask to publish it to the jury.
any objection?
Judge, I do, but we would probably need to do it at sidebar, I'm sorry to say.
Well, it's better than sending the jury out, so come on.
Okay.
So,
I think you had moved and asked to publish.
right.
Over objection, then the court will grant the request. And exhibit, what is this, 24, will be received.
And Detective Hoffa, the actual time, day of time, and the date are up in the upper left-hand corner of this interview that you can see on your screen.
Yes.
And your interview started prior to 12:59:28, right?
It started at 12:34.
And this clip is 6 minutes and 55 seconds based on what you can see.
Yes.
And I'm gonna start playing it now, Judge. Well, nope, I moved it. I move exhibit 24 into evidence and request to publish.
Yeah, I received it and you may publish. Hold on.
Yep. You gotta go to 8.
Want to restart it?
Yep.
Looked like you had the mic off. Go ahead. You gotta click the little arrow thing. No, no,
I know where it is.
in the middle. Oh my God, this is like my VCR at home. You got the sound open,
Your Honor, can we take down the publication to the
Sure.
jury right now?
I can hear something. Is that coming out of your computer?
No, I apologize, Your Honor. This did previously work, and now
The audio, it's the audio that we're having trouble with.
I can hear something.
I think the audio is just low on the computer. It was all the way up. It was all the way up.
You want to move it on tables? Sometimes the cord gets futzy. That's a technical term. I can hear something. Where's that coming out of?
There's a thing.
is there a way to turn up the sound in the courtroom?
If you have this feeling somebody's going to get blasted out of their seat.
She shows it. There's a drive and it says how to do it. There's a little box.
like, they don't want to go to full blast.
Okay, let's
Turn it up more.
can we try it one more time? Or is it all the way up, Ms. Lemke?
Like, we're just.
Fine, that's fine. Restart.
Okay. To make the record clear again, saying Exhibit 24 is on the screen. I request to republish this to the jury now.
I've already granted that. Go ahead.
It's not on the screen is what I'm saying.
Oh, thank you. Turn it on. There we go.
Okay, thank you, Judge. And now I will actually really play it, starting at 00.
Like, we're just doing small talk and stuff. And then she, one of the two girls, they introduced me to the two guys.
Okay.
And, so I don't have any idea what their names were.
Yeah.
And, but I could tell that they were pretty intoxicated.
Okay.
And he had tattoos all over.
Okay.
Now, and I only did make a comment. I said, we were talking about tattoos before, which we were.
Okay.
And because she was saying, Tom's religious and so is this Lori.
Okay.
So, and I just said, yeah, a long time ago, somebody had said to me that if you got a tattoo that you're marking up God's work,
Okay.
and it was sad. And I mentioned that to the guy, and he's like, you must be one of those fucking Catholic boys.
Okay.
And I said, no, as a matter of fact, I'm Lutheran. And I said, but, and he was we instantly did not hit it off, if you will.
Okay.
So I got my drink. I think I had maybe one sip out of it, and that was it. I put it down, and then she introduced me again to the guys, and then her girlfriend. And then when I mentioned about the dads, he came over to me and he's like, "Yeah, look at these babies, And he goes, "I got one of my wife naked, and she's got her boobs." And he's like this, going like this, and pushing them together.
Okay.
And I'm like, I didn't say a word. I just said, I'm thinking of myself real impressive. And then again, you could tell there was tension between us and stuff. So when he called me a Catholic boy, so that kind of didn't go over real big, but
So were you upset by that comment that he made?
Yeah.
Okay.
Yeah. I didn't. I was just telling, maybe it wasn't appropriate, but I was just making a comment about tattoos and what I learned from years ago.
So when you said you were upset, then did you start yelling at him?
No, I just said I'm Lutheran, and and that's when things got a little blurry because it was a little loud in there, and he was saying things, and I was saying things, and I'm like, why don't you two get out of here? I said, why don't you go outside, practice falling down, kind of kidding around. I'll be out there in a little bit,
Okay, so you guys were all like talking?
Yeah, just talking shit, guys.
So both talking shit to each other?
Yeah.
Okay. And then you said, why don't you just go down and fall down?
Yeah, just why don't you practice falling down? I'll be right out there, And he had said something to me, like fuck you, this and that, and I don't even really recall. Now I'm being honest with you, I don't really recall using any swear words or anything like that. But I was still in control. I knew what was going on, but I had that feeling with him. I did not like him from the get-go. And
you know his name?
I have no idea. And so then his wife takes both of them because they're inebriated and takes them outside the thing to cool down and whatnot.
Okay.
So then I'm sitting there talking to her about Tom and then her girlfriend and stuff, just us two inside.
Because you're talking to Laura then?
Laura and this other her girlfriend, and I'm like, I said, what's his problem or whatever.
Okay.
And then all of a sudden he comes back in the bar and says some more shit to everybody real loud.
Okay.
I don't know exactly what he said, but it was directed towards me. And then I kind of lost my cool, and I lost my cool. I just said, what did you say? And then I went outside. The girls tried to say, they're drunk, and I'm like, well, and I swear to you, on my dad's grave and on my kid's life, I went outside and his friend and this guy had had stools
Okay.
in their hands. And
So the guy and his friend had stools?
Yeah, they're up in the air like this,
Okay.
you know, and I said, what did you say? And then, you know, now, like, now you're gonna hit me with a stool. I'm not saying this, but I'm thinking, oh, I'm gonna get knocked in the neck, you know, with a stool.
Okay.
And 2 stools. So, but so the one friend, he tried to hit me with a stool first, and I don't know really what happened, but all I did was block it, and that was it. And I didn't touch him, I didn't say anything to him, nothing.
Okay.
Then the other guy, the husband, he comes in, he winds up, and he's gonna, and I don't know what the hell happened with me if I it was like second part or something. I just held my hand there and I just pushed him with the stool in his hand, and I just pushed him away.
Okay.
He fell over onto the ground, and then I left.
Okay.
And I'm like, we're just doing it.
Okay. Dr. Hoffa, you were able to observe that entire clip?
Yes.
So at the end there, Mr. Sehmer says, I pushed him with that stool in his hand and I just pushed him away.
Correct.
Did you ask Mr. Sehmer if he ever punched Mr. Davies or him?
Yes, several times.
So there's just one other thing I want to clarify from this clip. At the beginning, Mr. Sehmer is talking about Tom.
Yes.
Who's Tom?
That is, I'm sorry, that is the friend that he came out to Heartland with.
And Tom Knopp?
Knopp.
K-N-O-P-P?
Correct.
And you spoke with him later?
Yes.
He also talked about Lori at the beginning. Do you know who he was referring to?
Yes, her name is Lori Jacobs.
Okay. It's a completely different person.
Correct.
Not Laura.
No.
So you did ask him about hitting Josh.
Yes.
So now I'm going to ask to take that down, ask to not publish to the jury right now. I want to bring up Exhibit 25. Okay, and Detective Hoffa, do you see Exhibit 25 on your screen?
I do.
Okay, and this is another portion of your interview with Mr. Sehmer on June 18th, 2023 at the Heartland Police Department?
Yes.
And this appears to be a fair and accurate copy, again, of part of this interview.
Yes.
I would move Exhibit 25 into evidence and request to publish. I would also note this is a short 30 seconds.
Over objection, the court will grant the receipt into evidence, and you may publish.
But you know, it was open hand. I do remember that it was open hand, but I don't recall him, and I do not recall hitting him in the face whatsoever. I recall not hitting, but pushing the stool, period, into him, and then he fell over.
So you're saying you pushed the stool into the guy and then he went down?
Right.
Okay. Did he go down at a pretty rapid rate?
Yeah, real easy.
Okay, and Detective Hoffa, you heard that clip, right?
I did.
And Mr. Sehmer is now saying he pushed the stool into the guy and the guy went down
Yes.
at a pretty rapid rate.
Correct.
I'm going to ask to take down publication to the jury, and I have one more clip, Your Honor. I'm going to bring up Exhibit 26 now. Detective Hoffa, do you see Exhibit 26 on your screen?
I do.
And again, is this a portion of your interview with Mr. Sehmer from June 18th, 2023 at the Heartland Police Department?
Yes.
Fair and accurate copy of it as it looks on the screen right now?
Yes.
I would move Exhibit 26 into evidence and request to publish.
Over the same objection, the court will receive Exhibit 26. You may publish.
And to be clear, Detective Hoffa, about how long is this clip?
1 minute and 7 seconds.
And we can play that.
Period. So I'm going like this right now, and I think he's going like this and trying to hit me, and he's doing that. I luckily got a good, with the open hand, I got a good grip of the, and I didn't grip it, but I mean, I got a good spot on the stool where I just, if you want to use the word violently, that's kind of unfair, but I would say, yes, I pushed him down with one open hand, and he immediately went down the ground, and I didn't say nothing to anybody else. I turned around and I walked away. That was it.
that point, okay, so right now the only discrepancy is that you say you pushed the stool into him and pushed him down, and everyone else is saying you made contact with his face and he went down. Either way, he went down by your force. Can we at least agree on that? He went down by your force.
Absolutely.
Okay, onto the sidewalk, correct?
Yeah, so that was so.
Okay.
Okay. And so Mr. Sehmer agreed with you when he said he was the one causing Josh to fall to the ground.
Yes.
And we can take that down now. Detective Hoffa, I just have a couple quick questions for you. You stated that you ran, well, first of all, DOT records, do those indicate height and weight?
Yes.
And you indicated previously you ran that for Mr. Sehmer?
Yes.
And what was the height and weight for DOT?
I believe it's stated Mr. Sehmer was 6 foot 2 inches and 275 pounds.
Now, do you know Mr. Sehmer's date of birth?
I do not.
You know about how old he is?
He stated he was 63 at the time of my interview with him.
Now, you were able to observe here during testimony that we just have video evidence from Tabby's Wine Bar and then Hometown Pharmacy, right?
Correct.
Did you or other officers look for other video surveillance that would have showed what happened out on the sidewalk?
Yes.
Where did you all look?
There is BMO Harris across the street on East Capitol Drive from Tabby's and the Hometown Pharmacy. We checked there. We checked there's some apartments across the street and also Palmer's Restaurant, Steakhouse. We went to all those places and checked for video surveillance. There's nothing that Palmer's did have an exterior camera, but it did not come anywhere near to crossing the street onto the other side of East Capitol Drive.
Did you or any other officers find any video surveillance of what occurred on that sidewalk?
No.
Don't have anything further, Your Honor.
Thank you. So, Detective, you obviously had a longer interview than we've seen this afternoon, correct?
Yes.
Okay. And one of the things you tried to figure out is why weren't you able to reach him? Is that right?
Yes.
Mr. Sehmer. And he indicated that his phone wasn't with him. Is that right?
Correct.
And that he found the text from you and then called your office or your department.
Well, what he said was that left his phone at Tom's house. Tom then brought his phone over to Kevin's house and said, hey, the Heartland Police are trying to get a hold of you. And then Kevin contacted me after some time.
All right. And you played a portion of the video where my client indicates that both Joshua and this other gentleman, Bryan, came at him with a stool. Is that right?
That's what he indicated.
And then you, after talking to him for a while, he ultimately agreed that, yeah, that probably didn't happen. It was just Joshua.
Correct. I
Is that true?
started, oh, sorry.
Is that true?
Yep.
Okay. So while what you played is what he said initially, he ultimately agreed, no, that's not right. I didn't, he being Bryan, the other guy, didn't do anything with the stool. Is that correct?
After I challenged him on that, yes.
Yeah. And in that last clip you played, I wanted to see if I understood your answer. You're not suggesting that my client ever said that he punched Joshua in the face, are you?
What Kevin and I agreed upon is I said to him that the witnesses indicated that he made contact with Joshua's face, and Kevin repeatedly said he did not. He used an open hand and violently pushed him. So at the end, he agreed with me that his force caused Joshua to fall.
The force of him pushing the stool that was being swung at him, correct?
That's what Kevin stated happened.
Yes.
Yes.
The issue isn't what you think. The issue is what he said. And he didn't say, I violently pushed him to the ground. He said he used violent force to stop the stool from being swung at him. Is that right?
There was another point in the interview where he did say that he violently pushed him.
Pushed the stool, not him, his person. Isn't that true?
Yes, we went back and forth on that matter of the stool, where it was, or if Josh had it, all those sorts of things.
You're not suggesting Mr. Sehmer ever said that Josh didn't have that stool, are you?
No.
And in fact, Mr. Sehmer was quite clear that Joshua had a stool that he swung at him.
Yes.
And that all he did was block that stool as it was swung at him. Isn't that true?
I don't know if he ever used the word swung at him, but he said that he pushed the stool into Joshua.
Well, I think we saw it in one of the videos. He actually used that motion, didn't he?
He used those motions, but he didn't say the words.
Well, the motion he was showing you was of somebody swinging the stool. Isn't that true?
Yes.
I have nothing further. Thank you.
Redirect.
Did Mr. Sehmer ever say during this interview that Josh tripped over the stool and fell?
No.
Nothing else?
You can recross on that limited scope.
No, thanks.
All right, you can step down. Ladies and gentlemen, we're close to the required stop time, so I'm going to conclude the testimony for today. I'll release you, direct that you not discuss this case amongst yourselves or with anyone else this evening. We'll have you back here tomorrow at 8:20, and Tom will give you any other direction in order to find your way out. I want to wish you a good balance of your evening. That's it.
All right.
Okay, so that should be fine. My volume should be fine as well. Hang on then. Right. As I say, we should be fine to go now, people. I'm going to find day 3. Bear with me. Bear with me. Whilst we do. All the attorneys are sitting down. I think it's to do with the it's to do again with the mic situation, the volume situation for the court and stuff, I think. Crystal, you feeling better? You? I'm definitely staying hydrated. Happy days, Crystal. Happy days. Thank you, Amy. I'm just paranoid now. I've got to put the booster down. I don't want to speak because I know I'm blowing people's heads off. Just to quickly address it. I know Bill said it, but I don't think he meant it in malice. The only thing we all poke fun and we all have fun about stuff and so whatever. But there are lines that we don't really want to cross, like say someone needs to lose weight and call them fat and stuff like that. I just don't want to be that kind of chat. Not to say that Bill, you're not in the corner. We all make mistakes. It's all good. You're not in timeout or anything. But yeah, if you can just not like weight shame or just call people, whatever. It's just, it's not something that we try and do here. We're all guilty of it, so, but that's what I meant by that. Right. Hang on. I got day 3 here. All right, okay. So a couple of hours this will be now. That's fine, Bill. It's all good. You did know. It's, as I say, just it's we've all been there. We've all made mistakes. It's what we do. We all do it. So as I say, it's because I need to lose weight. I'm on the heavy side. So the reason I do is because people like call me names on Twitter and stuff, which I don't care, but other people do. So so that's why we try and set a bit of an example on you. But like, yeah, you're all good, Bill. We still love you, man. It's fine. Right. So this is day 3. I think closing statements and stuff are on here. So the first witness is about, I think, 25-30 minutes. And then we go to closings. So it's probably about 2.5 hours here. So until, as in total, I think. Bill's not in the corner. As I say, hey, it's good that he did it because I can address it. Do you know what I mean? I could address it then. So, Bill, actually, you did us a favor because now I can address it. Everybody knows where the line is, even though I think most people do anyway. But it's all good. I'm more angry at Bill for messing up all the ladies he had. Right, I'm going to put this on now. So, the booster on. So I'm going to shut up. Right. Booster is on, so I'll shut up. Yeah, what do you say? Look, we push boundaries here. We do push boundaries. I think that's the only way I don't go is people's weight and stuff like that. You know, somebody said about hair. I mean, you know, that's fine. I mean, look, if the like look at Trooper Proctor and they're all bald. I mean, yeah, I mean, okay, right before I put the auto on because we've had a few people come in. No song, but I will do is the usual. No, actually, I will just say like I'm one to speak as well because I've done the whole legs in the air stuff as well. So I need to take that out as well. Even though obviously if you were there, it was not me saying it, but still somebody could get offended. So I need to stop doing that. So I will not play that. I was going to play that actually, but I'm not going to play that now. I'll just do the quick like and subscribe for you guys, and then we'll get to it. Press the like, press the like, press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Like and subscribe, everyone. Let's fucking go. Before I forget, because I nearly forgot here we go. Sorry, Carol, I forgot to do this. I couldn't do it until now, so here you go. Thank you to you, Carol. Hang on, let me just move this over there. Carol Draper bought you 5 coffees. Thank you, Carol. Buy you a coffee or 5 because you've been keeping some late hours. Thank you, Dylan. We appreciate you. Thank you to you, Carol. I appreciate you for those coffees. Thank you so much, my darling. Right. This is the thing. I can't joke anymore because it's gone. The trial's gone. But yeah, I'm just as bad. Bill, look, man, I'm just as bad. I just don't make jokes about weight and stuff. But I'm quite bad. Right, let's get to the trial.
All right. Is it appropriate at this juncture to make an inquiry and to engage in a colloquy with your client as required by law?
I think this is a good time to do that.
All right. Mr. Sehmer, I'm going to direct my comments and questions to you at this point, sir.
Yes, sir.
I ask you to raise your right hand. Do you swear what you're going to tell me is the truth, the whole truth, nothing but the truth, self you got?
Yes, sir.
Mr. Sehmer, I've asked whether or not you will be testifying in the defense portion of this case. Did you hear that question?
Yes, sir.
Your lawyer has told me he does not believe that you will be testifying. Is that correct?
Yes, sir.
Now, you understand the decision as to whether to testify or not testify is a constitutionally protected right. Either way, you have the choice. Do you understand?
Yes, sir.
That choice as to whether to exercise the right to testify or to choose to remain silent and not testify is your choice solely. Do you understand that?
Yes, sir.
In other words, Mr. Shiro, who is an experienced lawyer with many years of practice, while he may provide legal advice to you, is not the decider, cannot be the decider under the law as to whether or not you choose to testify or not. Do you understand?
Yes, sir.
Have you had sufficient time to speak to Mr. Shiro about this subject?
Yes, sir.
And have you reached a conclusion or decision as to whether or not you're going to testify or not in this case?
Yes, sir.
And what is that decision?
I will not testify.
All right. Has anyone threatened you in any way or promised you anything of value to reach that decision?
No, sir.
And you reach that decision freely, voluntarily, and intelligently?
Yes, sir.
Do you have any questions about your right to choose to testify or not testify for Mr. Shiro as we speak right now?
No, sir.
Mr. Shiro, have you had enough time to speak to your client?
Yes, sir.
And do you believe he's freely, intelligently, voluntarily waiving his right to testify in this case?
I do, sir.
Court will find that Mr. Sehmer is freely, intelligently, voluntarily choosing to testify, choosing to not testify in this case. I will accept his waiver of that right. and we will proceed to trial, bringing the jury in. Before we do that, is there anything the state feels I need to address?
No, Your Honor.
Anything the defense feels?
No, Your Honor.
All right. Kim, you can ask him to bring him down, please. Proceed accordingly. Ms. Opper, does the state have any additional witnesses?
No, Your Honor, at this time, the state rests.
All right. Thank you. State rests. That would transfer the case to the defense. Mr. Shiro, do you have any witnesses this morning?
I have one brief witness, Your Honor.
All right. And are you prepared to call that witness?
I am.
All right. Why don't you go ahead and do that?
I'll go grab it.
Who is it, sir?
It's a police officer, and I'll have to spell his last.
Okay, that's fine, sir.
Thank you. Sir, would you please state and spell your last name?
Last name is Maciejewski, M-A-C.
Would you please?
Good there and your voice up. All right, sir? All right, counsel.
Thank you. Sir, would you please state and spell your last name?
Last name is Maciejewski, M-A-C-I-E-J-E-W-S-K-I, versus Scott.
And sir, how are you employed?
With the Village of Heartland Police Department.
How long have you been so employed?
23 years.
Okay. Always with that department?
Yes.
Okay. And how long, was that the only law enforcement position? Oh, that seems long.
Yes.
Okay. Did you have an opportunity as part of your duties to interview some witnesses regarding an incident on June 17th of 2023?
Yes.
Okay. Did you have a chance to take a statement from a Mr. John LAport?
I did.
Okay. Do you remember when you did that?
It was sometime in the morning.
Okay. If I showed you your report, would that help refresh your recollection?
Yes.
Okay.
You may.
108. Could you take a look at that for a minute, please? Okay. Can you tell the jury how it was that you had this interview with Mr. LAport?
It was a telephone interview.
Okay. And did you have some information that you had received that indicated he might have some information?
Yes.
Can you tell me what Mr. LAport indicated or told you was what he was doing that night, the 17th?
He was,
This witness has testified. Is this being offered? How is this being offered, counsel?
For the truth of the matter asserted, Your Honor, under section 908.03 sub 8. It's a statement from a officer involved in an investigation, and I believe the statute makes it not hearsay by definition.
Bill, I have to wait a minute to make sure that my volume 2 wasn't too loud. What the fuck are you doing, Bill? Bill, that is way, way too much, Bill. Fucking hell. Bill. Like, Bill. The fuck you doing, Bill? Thank you so much, but the fuck you doing? Fucking hell, Bill. You do not need to send that much, Bill. I appreciate you, my friend. I do. Thank you so much for that. Bloody hell. $100. Fucking hell. I've had two, Gary and MJ have sent me 100 before. And now Bill. But jeepers, creepers, Bill. Don't need to send that. Or are you just sending it to show the ladies there's a bit of money here? Like, just throw, ladies, now we got to get him a fucking date. We got to get Bill a date now for this. Fuck, Bill. No, honestly, thank you so much, Bill. I appreciate you. Really do. Really appreciate you. You didn't have to do that, man. You really didn't have to do that. But thank you so much. Oh, fucking hell. Yeah, I know, and that's what I mean. You don't have to feel bad, Bill. Bill, you do not have to feel bad at all about anything. We appreciate you and love you here. It's all good. As I say, you said one thing and it was fine. We've moved on from it. It's not an issue. Don't have to send that much, Bill. Don't have to spend it on the juice. Yeah, I know. And Amy says meant no disrespect. I know, and I know you meant no disrespect, Bill. This is why I addressed it. You weren't timed out. You weren't nothing. I appreciate you. Thank you so much. Wow. Okay. Well, thank you again, Bill. I appreciate that, man. I really do. Thank you so much. And ladies, all the single ladies, Stormcatty says, Billy is single, ladies. If that doesn't, woo. Now let the ladies come to you, Bill. Again, thank you, Bill, so much for that. You really didn't have to do that. Really didn't have to do that. Thank you, thank you, thank you. I'll get back to the stream now because I'm just gobsmacked. You fucking didn't have to do that at all. Thank you, man. Robbins, I'm single. Dylan likes the blondes. I'm not fussy. And Dylan sang, it's a banner night. There goes my stick tips. He can, hey, if he takes you out to it, he can have their all back. I'd love to see you two go out on a date together. I'd love to see somebody actually go on a date with Bill. I would. Now get the no, stop. Bill, stop. Bill, please stop. Do not. Bill. Stop, right? The fuck? That's $300, Bill. Dylan, I have the money. I don't feel bad now. I have the money. Thank God for that. I don't feel bad now, Bill. Thank you, Bill. Thank you so much. And YouTube also says thank you because they get a huge cut as well. So, yeah, it came from my heart. Came from the heart and your just touch. Well, if you generally have the money, then I appreciate you. I really do. If you don't have the money, message me. I'll get it back from YouTube. Bill. Hey, Bill. All the ladies are starting to wake up now. Bill is very generous. Bill's a good man. What the hell, Bill? Even Daffy's like, hey, Bill. Robin's like, Bill, Robin, where are you from? Are you near Foxborough? Yeah, I don't have to send it back to him now. Terry, you're right. So, Bill, you could take Toots out. You can send Toots out for steak tips now. Dylan said, "Stop, Bill." Yeah, that's it. More than enough now. So, thank you, Bill. You brighten my day and all the chat people. I don't do it for the ladies. I know you don't, but you're fun. You're fun. You bought into it. You bought into the fun, Bill, and I appreciate that for you. You're in on it. You bought into the fun, and I appreciate you for it. I don't know where New Bedford is. I'm Boston. Robin, if you're single, ready for the mingle, then Bill's your man. I know, it's amazing, isn't it? It's amazing, isn't it? That's the most I've ever had. I mean, wow. Again, thank you, Bill. Did not need to do that. Yeah, Robin, are you between 30 and 59? Are you between 30 and 59, Robin? If you are, Bill, that even makes you even more special. There you go, Crystal. Aye, wow. I know you're all here for the stream, but I'm a bit gobsmacked at the minute. So, yeah. Manfred had an El Chatty wedding, Lou. I know. I know. This chat's the best. Yeah, I love it. Or is he abroad? Who starts Storm Chatty? Bill. Bill's from no, Bill, stop. Bill's from Boston. Bill is 57 years old, ladies, from Foxborough in Boston. Robin, are you single? Are you ready to mingle? Bill is 57. All jokes aside, Bill is a single guy. He would take you out for a night. He would be a gentleman, I'm sure. He wants companionship. He wants companionship. So if anyone does genuinely fancy going out for a meal with him, I'm sure he would take you. And Bill, stop it now, right? Stop it, please. You're embarrassing me now, Bill. Please stop. Thank you so much for 400. YouTube also says thank you. Uh, Bill is loaded. Hey, Bill, honestly, people now, the ladies are like, fucking hell. But keep all the rest of the money, Bill, for the ladies, right? Keep it for the ladies. Take them out for some steak tips. In all seriousness, though, I'm sure Bill will take you all out. Nothing dubious about it. I think he'd love the companionship to go out for a meal if anyone's up for it, with a few of you. I'm sure. It's nice. Sometimes you come to an age, it's nice just to go out with friends and just have a meal and stuff. So if anyone's up for it, Bill will generally take you out and have a good time with you. That's all joking aside. You can see how generous he is. He's got a hard goal. Look at him, $400. Fucking hell. 202. I think I get about. I get about 220 of that. I think I get. So thank you, Bill. Fucking hell. It would be great to get an El Chatty wedding. Carl Draper could photograph, yes. Yeah, some of you married, some of you gutted now you're married. I'm making hamburger helper. Yeah, Boston, Foxborough. No, Amy, stop it, Amy. Stop it, Amy. Yeah, Stormcatty, where are you from? Are you in Boston? Are you single, Stormcatty? And are you in Boston? And are you between 30 and 59? Right, I've got to start the stream. You need to stop. You need to stop now, Bill. Seriously, now you need to stop. But thank you. Another $100, Bill. Stop. I tell you why to stop it, because he got most of it goes. YouTube takes most of it, so don't. YouTube takes like 40%, 45% of it. So don't. You're only paying YouTube. But thank you so much. Thank you so much. I'm just gobsmacked with that. Thank you so much. I'll be buying Bill aspirin in the morning. Right on, Bill. Lobster, steak tips, surf and turf. We have 500. No more, Bill. Done. We're done. Bill has got Benjamins. Wedding in my yard. We have a bar, pool, and hot tub. Let's go, ladies. Oh, there you go, Stormcat. You're married. Gutted. There we are. Well, you know who we got here, Bill. But in all honesty, Bill is on Twitter. Go follow him, slide in his DMs, and I genuinely can see, he would look after you. Yeah, I don't know what to say anymore now. So, Katie, each time he sends it, the line is shocked. This is. I know. I always get embarrassed with money and stuff like that. I always get embarrassed. Always get embarrassed with stuff like that. So, thank you so much. And you're right, Katie. Married in Arizona. Oh shit! Yeah, sorry. Yes, you're right. Bill, stop, please. Yeah, because hey, Bill, stop, because Toots wants you to save the money. Bill, take Toots out for me. Toots, you be up for going for steak tips as friends, wouldn't you, with him? And Toots, bring a friend, whatever. Bring a friend. If there's anyone else that wants to go with Toots and Bill, meet up for a meal somewhere. Whether arrange it between yourselves, but go out for a meal as friends, an alternate corner meal or something. Right. Yeah, I don't know what hamburger helper is, so I don't know what that is. Right, let's get back to the trial. But yeah, again, thank you, Bill, and Dumpster Juice is back in the game now, probably. Thank you, my friend. Thank you, my friend. That really helps. Thank you. Really helps. Thank you so much. Well, that's like one. That I get about $270. So I'm not sure how much was that in UK money, but every penny helps. So thank you so much. Steak tips, scallops with Bill. AB, it's worth you flying in from California, my darling. Dylan, goodbye. Yeah, no, it's fine. Thanks. You're a hoot. I know it is, Butterloo. I got PayPal. It's pinned at the top. It's pinned at the top. Yeah, we're gonna watch the trial. I'm trying to get it back on. I can't get it back on the minute. My screen's frozen, Toots. That's why I'm waiting for it to refresh. And then I'll boost it. Right, hang on. Let me refresh it one more time and then it should be good. Right. We should be good, hopefully. Right, let's see if it's getting good.
Council approach.
Understand who we're speaking of. You spoke to possibly
All right, I believe the defense is going to rephrase the questions.
okay. So we understand who we're speaking of. You spoke to a Mr. John LAport, is that correct?
Correct.
And you had discerned some information to indicate that he may have seen something that was relevant to the case. Is that correct?
That's correct.
And Did Mr. LaPorte indicate to you that Mr. LaPorte, had seen of the two people, the one with the shorter man with the long hair, possibly pick up a stool and possibly walk in the direction of the larger gentleman? Did he say that?
Correct. He said it
And
was
then he
possible.
said, John wasn't too positive about the stool because everything happened so fast. Is that what he told you?
Correct.
Okay, I have nothing further.
Any cross?
And Mr. LaPorte also gave a written statement to your knowledge, right?
Correct.
That wasn't to you, that was to a different officer, is that right?
That's correct.
And in this statement about the stool, he wasn't sure about the younger male with the stool.
That's correct.
And you also went and spoke with the owners of Tabby's and getting video surveillance and things like that, correct?
I spoke to the owners of Tabby's on the phone.
Okay, who are the owners of Tabby's?
Mind if I?
Is your report still up there?
Yeah.
If your report refreshes your recollection, that's fine, but read it to yourself. And then I'll ask the question again.
Okay. Okay.
Who are the owners of Tabby's Wine Bar?
Sean and Tabitha McBride.
Not Mr. Sehmer.
Correct.
I don't have anything further, Your Honor.
Any redirect?
No, thank you.
All right, officer. May this witness be released?
He may, Judge, and I'm moving 108 into evidence. That portion of it that we just read.
Before he leaves, then, do you want to have him identify 108, please?
Yes,
No, just ask him the question.
Is that your report, 108?
Yes.
That involves the interview of Mr. LaPorte?
Correct. The phone interview.
It's a single page?
Yes.
What page of your report is it?
It's page 15 of 22.
Thank you. You're moving 108. Any objection?
No, Your Honor.
108 will be received into evidence.
Thank you.
May this officer be released. Any objection from the state?
No, Your Honor.
All right, you can go about the rest of your day. Thank you.
Thank you.
Grab it if I may.
The video kind of launched himself through the front door. So the court believes, and also I agree with the state, that separation in time.
Conference last night.
Oh, yes, we should put that on the record.
Yes.
Go
please.
ahead. And there are two elements to aggravated battery under that statutory section. And the court believes the factual record creates factual questions as to the elements in this case. There has been argument that Mr. Davies was struck. Strike that. There had been testimony that Mr. Davies was struck sufficiently hard. This is the medical examiner to cause acceleration of his physical body into the concrete outside of this establishment in Heartland, causing him to suffer a skull fracture and a subdural hematoma, which ultimately caused his death. There has been testimony by the medical examiner that under a medical standard equated to homicide. Again, the factual issue that the jury must grapple with is whether the legal standard for homicide, felony murder, has been established. But the court believes there is an abundance of facts here, while the defense has vociferously argued and will argue undoubtedly at closing that this was a circumstance where the defendant was required to defend himself. I still believe strongly that the facts established in the record could be read another way. Therefore, the court believes that the matter is appropriately resolved as a factual matter by the jury. The court will deny the motion. Is there anything else from the defense?
Judge, we had a jury instruction conference last night.
Oh, yes, we should put that on the record.
Yes.
Go ahead.
Judge, with respect to the substantive instruction, I know that the court has included both retreat and provocation. I believe that neither is justified. I believe that particularly with regard to provocation, it is my belief that the evidence suggests that whatever dispute had happened inside Tabby's had ended. And in fact, the evidence showed that my client was speaking with Mrs. Davies and Ms. Burke in a friendly manner, and that this argument had ended until such time as Joshua Davies came back to the bar and yelled some profanities about why his wife is still talking to my client described in a profane manner. And therefore, I don't think provocation is appropriate.
Thank you. Does the state have any comment?
Your Honor, that's one view. I know that's been expressed by Attorney Shiro in his opening statements and somewhat of a theme of his, but we have an entirely different view of that, and that the situation certainly was not over at that point. And the law doesn't require that. The law doesn't require a break, so to speak, in order to claim or for the provocation instruction to be appropriate. Even if we ignore everything that happens inside the bar, outside the bar, we have clear video showing the defendant advancing on the victim who was backpedaling. That's provocation right there. So these instructions are legally appropriate.
Thank you. The court did engage in this discussion during the jury instruction conference. It's really been largely repeated here. The court has chosen to include the optional instructions. I think it's under 811 and 815.
I think it's
810 and 815. Thank you. Of the form jury instruction. The focus here is on the provocation instruction. I understand the defense's argument and the effort of the defense to try to create separation from what can best be described as boorish behavior. That's really by the defense's own argument of the defendant directed towards the victim in this case while in the bar. But I don't believe that the jury has to accept separation in time. And really, if there is a basis for them to think this was a continuing moment, while there may have been some physical separation between the parties, briefly, the jury doesn't have to conclude that was over. Clearly, in some degree, they could conclude it was not the way that your client, based upon the video, kind of launched himself through the front door. So the court believes, and also I agree with the state, that separation in time is not required. You can have a provocation instruction with a single continuous event with no argument that there's some sort of time separation between moments. If the defendant if there is a potential that a defendant has provoked the circumstance, the court believes that language would be appropriate. So the court believes that there is at least a basis for the jury to consider both the issue of retreat and provocation as contained in 810 and 815, and I've included the language over the objection of the defense. I think that was the only objection, those two. Was that correct, Mr. Shiro?
That is, Judge.
All right. And so other than that, are the jury instructions acceptable to the defense?
Yes.
And the verdicts have been handed out, and are those verdicts also acceptable?
Yes.
Verdicts have been discussed and will be handed out. The state have any objection to the jury instructions as presented?
No objection, but I just want to clarify that I see 315 is in the packet. I don't know if the defense specifically requested it. Defendant elects not to testify. It's on page 12.
Oh, thank you. That was included by my clerk, but I did not ask. So let me ask, Mr. Sherrill.
Yes,
That
I would
is
like
an
it.
optional choice of the defense.
I would like it, and I see that it's in there, and I'm asking that it stay there.
Stay there. All right. Thank you for addressing that, Ms. Hopper. Other than that, the state has no objection.
No objection, Your Honor.
And as to the verdicts that were discussed, the state is in agreement?
Yes.
All right, so now it's 9:06. I'll see you back here at 9:25. All right?
Thank you.
Right, here we go. Hello, everyone. Just give me 2 minutes to find the spot. That's what she said. Right, hang on. Let me just set it all up ready. So, yeah, good to see you as well, Amy. Hope you enjoy the holiday, my darling. Right, just so people that new are here, shout out to everybody. Shout out to Brenda, who's a new member. Shout out to Bev, who's a new member. Shout out to Robin, who's a new member. Shout out to Toots for gifting 10 alternate corner memberships. Shout out to you, Robin, for gifting 5 alternate corner memberships. Really thankful to all of you. And shout out, obviously, to Bill for sending out 1, 2, 3, 4, $500 in chat. Thank you so much, Bill. Again, thank you, my friend. I really appreciate that. You said that was such a straight face. I'm glad. I'm glad. That's what she said. Yes. There you go. What is your PayPal? My PayPal is pinned at the top. I'll post it in here again. It's pinned at the top, people. So if just to explain, we don't do cash apps or thingy. Thank you, Lady Di, for gifting as well. It's in the top, but I'll just get it. So PayPal's the only thing that I get 100% of. YouTube, I get 54%. Coffee, I get 94%. Oh, that's why, because Sarah P's did it differently. That's why. Hang on, let me find this. Let me find it here. But as always, never need. I'm humbled. I'm absolutely really grateful to all of you. So this is the PayPal. Hello, Nicola. Oh, my PayPal is broken. Why is it broken? Oh no, there is. That's the PayPal. I'll put that at the top. But yeah, it wasn't at the top. I didn't realize it wasn't at the top. Sorry, I'll put it at the top now. Thank you so much for your generosity. We don't need anything more. But wow. Krista, no, you don't need to gift anything. You don't need to gift anything. PayPal's the only thing that I get 100% of. So what it is, YouTube take 35%, then Apple/Google Play take 10%. So roughly 10%. It's 10, 11%. So the creator gets roughly 54 to 55%. Now, some of it depends on where you're from. So if somebody from the UK sends it to me, I normally get about 57%, 58%. But from the US, I get 54%. So YouTube takes 35, I think it's 35. And whenever I've converted it, it's always worked out about 54, 55% that I get from YouTube. So yeah, that's it. You need to press friends or family. Yes, you do as well. So that's why. We don't need to. I'm only humble. I only stopped it to thank guys. Even being here helps because the ads and stuff like that help me. So the main thing you do is like, subscribe, share my streams. That's all I ask for. Get me in the algorithm. Get me in the algorithm, people. That's all I ask for. If you're in the algorithm, that means we get more people here. So all I can ask for. And thank you to you as well, Lady Di, for the 1 gifted membership. Thank you, darling. I appreciate you for that as well. Really do. Thank you so much. Oh, fucking hell. Hang on. We got to do this now. Hang on. And then I'll get the stream back. I promise I'll get... We've got about another 2 hours to go. Maybe less than 2 hours, people. Hang on. We have got lift off. Deb. Hang on. I think I got the wrong one. Hang on. Debbie. Oh, I got 2 up. That's why. Rhode Island lady sent 10 coffees. Thank you so much, Deb. Thank you for just being you. No, thank you. Thank you so much. I really appreciate that. Thank you, thank you, thank you. Thank you, Deb, for that, for the coffees. 10 coffees. And again, thank you to you, Carol, for the 5 coffees. 50 coffees will do me. Thank you so much, people. Thank you so much for everything. The memberships, everything. Thank you so much. There's no need for any of it, but thank you so much. Coffee or PayPal? Coffee again, 94%. PayPal, 100%. As long as you support friends and family. Free Zachary Anderson going back to catch up. No worries, Nicola. Catch you later, my darling. Also, you can remember you have to figure out PayPal. You're fine, Bill. You don't have to figure out anything. It's the PayPal is just a bank thing. So but don't worry, it's fine. Right. I'm more skint than I've ever been before. My presence, my gift. It's a massive privilege to have you here, Lou. It genuinely is. As I say, not everyone could gift people. It's fine. I don't want anyone to think that they need to gift or anything. You don't have to. Just being here, being helpful in chat, engaging, talking, liking, it all helps. Generally does. Not everyone can afford to support people. You support in different ways. So not everyone can afford monetary wise. So please, don't ever feel like you have to. You really don't have to. Yeah, I mean, there's a ballers, yes. Yes, the ballers are fine. But yeah, thank you. Well, I mean, I do for the coffees. That's the whole thing with the coffee. PayPal's more different. It's a bit more difficult with PayPal's. Let's see if I can do it on this then. Let's hang on, and then we'll get to it because I need to get to this now. The stream back. Hang on. Hang on. I need to go into my PayPal for a second. The only problem is I can't do PayPal on screen because people's names are on it. So I can't do that on screen because that means I would dox people. So I can't do it for that. I can only give you shout outs for that one. for PayPal. I just remembered. So, but yeah. Hang on, Robin. Robin, what are you doing? Thank you so much, Robin, again for the 5 gifted memberships. You really don't have to. Thank you so much, Robin. People, thank you so much. That's enough now. I appreciate all of you. Thank you. No need for more. No need for more. I promise you. No budget. No, they're all having an early night because it's been quite busy for them. So, you know, it's hard because they all work as well. Right, let's get into this then. Again, thank you everybody for the coffees, memberships, and every gift. Fucking hell. Let me get to the stream. So this is closing arguments now. Thank you, Amy. Love you too, my darling. I'm not. It's a weird chat. What's that mean, Giovanna? Did you go through? Yeah, hang on. Yours won. Oh, Jonathan's here. It's fine. Oh, Paddy the baddie. Oh, Paddy the baddie. Oh, Paddy the baddie. Yeah, it did go through. Yeah, Nicola Maxwell got one. Henderson got one. Mother of Beagles got one. Jean Alt got one. And Megan got one from you, Robin. Jonathan's in the house. 10 total. Yeah, 10 came through, Robin. 100% 10 came through. 10 came through. And Bill, don't worry, you've been more than generous. You're fine, Bill. Don't worry about it. No, thank you. Lost control chat I have. I need to get this back up. Sorry. Where's Jonathan gone? Hey fella, how you doing? Goodness gracious, similar is generous. Right. Jonathan is here, so behave everyone. Right, let's get back to this. Come on. Take Dumpster Juice. Come on, let him take you out, Dumpster Juice. Let him take you out. Let's share the screen. There you go. I'll put the booster on for you. Hang on. Right, here we go. This is the state first for you.
All right. Well, good morning, everybody. Thank you very much for your service in this trial. I'm glad we were able to wrap it up a little bit quicker. Got it now?
Yeah, I think it's on. Tap it.
Testing, testing.
I can hear you, so that sort of tells me it's on. Go ahead.
Or I speak loudly, yes. So again, thank you very much for your diligence in paying attention to this trial and the facts. I know the testimony wasn't always the easiest. First of all, it could be emotional at times, but second of all, I'll be the first one to stand up here and tell you, we have 4 different people seeing 4 different things at 4 different times, right? That's human life, right? We've all experienced this. This isn't a Hollywood movie script where they're gonna come in and perfectly match, because they're seeing different things. They're viewing things from different viewpoints, right? And let's not forget the violent attack that they had just witnessed and the trauma and the shock that their brains were undergoing at the time they're witnessing this and then trying to recall it. And of course, there's been some passage of time. It's been about a year. So all of that leads to this situation we have here where we have different versions of events. But the question is, are they credible? Did you believe these 4 people who came in and told you about what they remembered and how this played out to the best of their ability, right? And same with the videos. You know, I surely wish we had a better quality video outside on the sidewalk, but we don't. So we presented to you the best that we have.
And we presented a couple different versions that the crime lab was able to enhance. Whether you find those useful or not is entirely up to you to decide. But we're not relying on just one witness or one video, right? It's the whole entire series of events and the recollection of the witnesses for you, ask you to piece together, can you clearly make a determination here as to what happened, okay? So I'm very grateful that you were patient and paid attention, because you're gonna have your work cut out for you. I'm not gonna stand here and say, this is an easy case. This is an open and shut case. And you know, should you take you 10 minutes to deliberate? I would never say that. And certainly on a record like this, where you have a lot of different viewpoints and a lot of different information to consider. So I appreciate that you're willing to do that work, and we're grateful for your service here. I want to start out by just talking a little bit about the events that that we have been discussing here for the last 2 days. And I'm going to start where we ended actually with our case, and that is the words of Kevin Sehmer, right? The question still remains why any of this happened. We still have never found an answer to that. No one was able to tell you why Mr. Sehmer was so upset about the choice of Josh Davies to tattoo his body. What difference does it make to Kevin Sehmer? We have no idea. But seemingly that was the underlying cause of this entire incident, is that immediately upon seeing Joshua Davies, he took exception to his appearance. He told Detective Hoffa in his interview that he didn't like him from the start. And I think that's readily apparent from the video inside Tabby's wine bar, that immediately upon meeting Josh, he's making derogatory comments to him. You're a sinner, you've marked up God's work, you're going to hell. That's not a friendly interaction between two people who have just met out on a Saturday night trying to enjoy a really very common activity that we all participate in. Hey, it's summer, finally, it's June 17th. Let's get outside, let's go to a band, let's have a couple beers, let's enjoy our friends, right? And to walk into that bar trying to meet up with Laura and meet Mr. Sehmer for the first time, what the heck happened? Well, he ran into Kevin Sehmer. That's what the heck happened to Josh. So Kevin Sehmer gives an interview to Detective Hoffa. I'm going to play a little clip of it for you. I'm not going to play the whole thing. This is, I'm sorry, can you turn on? So this clip that I'm going to play right now is from State's Exhibit 24.
And I lost my cool, and I say I lost my cool. I just said, what did you say? And then I went outside. The girls tried to, say,
Yeah.
they're drunk, and I'm like, well, and I swear to you on my dad's grave and on my kid's life, I went outside and his friend and this guy had stools in their hands, and
so the guy and his friend had stools.
Yeah, they're up in the air like this, And I said, "What did you say?" And then now like a year old. Now you're gonna hit me with a stool. I'm not saying this, but I'm thinking, oh, I'm gonna get knocked at with a stool, and 2 stools. So, but so the one friend, he tried to hit me with a stool first, and I don't know really what happened, but all I did was block it, and that was it. And I didn't touch him. I didn't say anything to him, nothing. Then the other guy, the husband, he comes in, he winds up and he's gonna not, and I don't know what the hell happened with me, if I had like, some, almost, it was like psychic power or something. I just held my hand there and I just pushed him that with the stool in his hand and I just pushed him away. He fell over onto the ground and then I left.
So let's unpack that a little bit. There are multiple lies or falsehoods stated by Mr. Sehmer in that statement when he's being questioned by Detective Hoffa. It's not in this clip, but remember he started out by claiming both guys were drunk. They were pretty intoxicated, he said. Well, the record's quite clear. Bryan Richardson had 1 beer the whole night. You can see Bryan in the video. He is not impaired. He's not intoxicated. But Mr. Sehmer wants to make it seem that way because that's to his benefit, right? I got attacked by 2 drunk guys. So he embellishes, he lies, he misdirects, whatever word you want to use. He's not being truthful with Detective Hoffa. Then he says, I walk outside and both guys have a stool above their head. 2 stools. He doubles down on it. He goes back to that later. 2 stools I'm confronted with. That never happened, ladies and gentlemen. Not one witness, not one piece of videotape shows Bryan Richardson with a stool in his hand ever. But he's got to say that, right? Because that makes it better for him. Well, I had no choice. I had to go after these guys. 2 of them came after me, and they both had stools. So he's got to make that up. Then he says, Bryan tried to hit me. Bryan never tried to hit Mr. Sehmer. Nobody saw that. That's nowhere in any video. Then he says, the husband, Josh, he came in and he really winds up. Those are his exact words. He really winds up. And I was able to just push him away. And he fell down and I left. Nobody, not one witness on that sidewalk saw Josh making a motion like this. Not one. It's not in the video anywhere. Now you could say, well, maybe it happened back closer to the Tabby's door and it's not on the video. John LaPorte would have seen it. Bryan Richardson would have seen it. Jen Davies would have seen it. His own wife came here, courageously told you those events that night. And she told you, yeah, I did see Josh with the stool and he had it up here. Never did she describe a swinging motion. Nobody did. It didn't happen. He's got to tell these stories so that it looks good for him. Well, I had no choice. I had to punch him or push him, as he would say. Nobody has Josh swinging a stool. In fact, I'm going to play another excerpt for you. My desktop here. No. I just lost my cursor here. There it is. Okay, thank you. This is Exhibit 8. This is the video from Hometown Pharmacy. This is the original version, not anything changed by the crime lab. Close out the PowerPoint. I just can't see it on here. Okay. See, we do test these things and I still have user error. See, not enhanced in any way.
Right now, we have a,
Yeah, when I started,
okay, I
Thank
was
you.
worried about the traffic call.
thank you. I started it at the beginning. And I pause it at 12 seconds. Through the door of Hometown Pharmacy, you can now see Josh Davies standing there. I'm going to click it ahead one frame, 13 seconds. Watch his right arm as I click through these frames. His right arm is down at his side right here in this frame. 14 seconds, still down by his side. 15 seconds, still down by his side. Now he makes a step to the right with his feet. And there you can see at 15 seconds, a motion like this with his right arm from his hip area up, right? He is not doing this. He is not doing this. His arm is down near his waist at all times, right before the blow gets delivered by Kevin Sehmer. I'll continue playing. I had paused it at 12, 13, 14, and 15. I'm starting again at 15. There he goes. And there's the follow through from Kevin Sehmer. 100% inconsistent with what he told Detective Hoffa. He claims he's the guy making this motion. I just went like this and blocked the stool. He did not. That's a follow through, folks, from a right hook. He stepped through it. You see his body turn. That is a solid punch to Joshua Davies' head. That's what that is. He did not make the motion Josh Davies made of that. He stepped over. You see his body physically turn. That's the force of the punch. Nobody saw Josh Davies swinging a stool out. It did not happen. Mr. Sehmer, in his interview with Detective Hoffa, is trying to make himself look good. He's trying to justify his actions. He's telling her misinformation, falsehoods, because he wants to say, 2 guys started swinging stools at me and I had no choice but to hit one of them. Now, another thing that was suggested during the opening statement of Attorney Shiro was that, well, there really wasn't a battery at all. We think Josh just tripped on the stool and fell on his own. Nowhere in the video do you see that. No eyewitness described that. They were all asked. Jen was asked. Bryan was asked. John was asked. Did you see Kevin trip over anything? No, I did not. I saw Kevin Sehmer punch him in the head and then he dropped to the ground like a house of cards. That's what I saw. He didn't trip. There's no evidence he tripped over the stool. None whatsoever. And in fact, that is directly contradicted by the testimony of our medical examiner, Dr. Bidirzycka. I've only known the woman 30 years. Bidirzycka. Remember how she described the level of force, the acceleration that would have had to have occurred in order for Josh to have the injuries that he did. That is not consistent with the trip, she said, because there would not have been enough acceleration from a simple trip or a stumble. I asked her, how much force do you think would have to be involved for injuries like this to be obtained? And she said, quite a significant amount of force, quite significant. Remember, she described the hemorrhaging in the brain that was so deep. She said it's actually pretty unusual to see that level of injury that deep in the brain because of the sheer force. Remember, she was using that term, the velocity, the shearing force when that head hit the ground. Sadly, because Josh was unconscious and couldn't brace himself in any way, fell down. John LAport described in detail, and I'm sorry because I know this sounds really cold, but he saw Josh's head bounce off the sidewalk. That's exactly what Dr. B said. Remember how she described the injuries in the front of the brain from the brain hitting the skull in the front? Her testimony, absolutely. And the event as we know it unfolded is that Kevin Sehmer forcefully, violently smashed Josh Davies in the head and caused his injury and ultimately his death. Interestingly, not even Kevin Sehmer told Detective Hoffa that Josh tripped on the stool. So that was new information in the trial. Even Mr. Sehmer never suggested that. He admitted that he pushed Mr. Davies forcefully, and that's what caused him to fall. I'm now going to play a clip from Exhibit 26, in which he expressly.
Period. So I'm going like this, trying to, and yeah, I think he's going like this and trying to hit me, and he's doing, as he's doing that, I luckily got a good, with the open hand, I got a good grip of the, and I didn't grip it, but I mean, I got a good spot on the stool where I just, if you want to use the word violently, that's kind of unfair, but I would say, yes, I pushed him down with one open hand, and he immediately went down to the ground, and I didn't say nothing to anybody else. I turned around and I walked away. That was it.
So not even Kevin Sehmer claims this was just a trip or a stumble because Josh was so inebriated, he had lost all of his motor skills. Remember that? By the defense, they brought in Dr. Henson to try and tell you that he had lost his gross motor skills, his fine motor skills, and he was so intoxicated that he couldn't even defend himself. Attorney Zillaby asked him that. Well, if he's this intoxicated, then he wouldn't have an ability to defend himself from a sudden attack, right? And Dr. Henson admitted that. There's no evidence, and you can see the Tabby's video, that Josh Davies was unable to comprehend what was going on around him, that he was stumbling, that his balance was impaired, that he could not function properly, right? Hey, I get it, folks. A .24, yeah, I'm not here to tell you he was stone sober. I'm just here to say it did not have the impact on him that you may expect. You just hear a number. You don't know anything about it. You don't know how much he had to eat. You don't know what his tolerance is. So look at the video with your own two eyes and tell me, was he grossly impaired by his level of intoxication? If so, where is it in the video? In fact, what we see in the video that I just played for you, number 8, is him walking backwards very adequately, right? Backpedaling 5-6 steps, whatever it is. Is that somebody who is grossly impaired? He's not grossly impaired. He's got a .24 BAC. He is not grossly impaired. You cannot reach that conclusion based on this record. Nobody said it.
Nobody. The people that are with him that night, and the video speaks for itself. Absolutely not. This incident is not attributed to Josh's level of intoxication. It's attributed to the actions of Kevin Sehmer. Had Kevin Sehmer not punched him in the head and knocked him out and caused him to fall to the ground and hit his head, he would not be dead. It's just that simple. That's why Kevin Sehmer is charged with felony murder, because he engaged in a felony. That is aggravated battery. He punched Josh in the head. Aggravated battery. And when Josh fell to the ground and hit his head, that's what led to his death. It's his actions, his conduct that caused Josh's death. No other conclusion can be reached on this record. I have an opportunity to speak to you again in rebuttal because it's my burden of proof. And in fact, as Mr. Sehmer has claimed self-defense, I have to overcome that and prove to you this case was not self-defense. So I'm going to reserve some of my comments for my rebuttal closing. There's other things I want to talk to you about, but I think they will be more helpful to you in the context of understanding the defense position that this was self-defense. Thank you.
The next closing statement will be given by the defense.
The state has spent a lot of time trying to make this homicide case about an argument where my client was acting boorishly and inappropriate. I think I told you in the beginning, I didn't think you would find that his behavior was okay inside Tabby's. It wasn't. But this case isn't about bad behavior inside this bar. It's not. Mr. Davies was never injured inside Tabby's. There are really two issues. They're complicated factually, but there's really two issues. First, not complicated. Did Mr. Sehmer batter, punch Mr. Davies? That's one issue. If you determine that my client didn't batter him, didn't punch him, then that's it. Then it's not guilty. As simple as that. I think that's what happened here. And I think that's what the evidence shows. But let's just kind of break it down so that you can understand, because it's a little complicated. The second issue is, well, if we thought he battered Mr. Davies, was he acting in self-defense? That is, was he doing whatever he did because he was being assaulted by Mr. Davies? I indicated initially, that is in the opening statement, that this was an argument that had already ended. Now, I'm not asking, nor should I ask, that you not consider the fact that my client had been acting badly in the bar. I mean, that's obviously evidence in the case. It's, however, as I again would state, that's not where Mr. Davies was hurt. So they had, that is Mr. Sehmer and the two women, were talking, okay? I doubt they particularly liked Mr. Sehmer, although they did both stay there and they were talking. It wasn't a long time. At some point, my client, gives a hug to Ms. Burke, but whatever. And they were standing together, the two women. And if Mr. Davies doesn't come in the bar and start screaming to Mr. Sehmer and to his wife, are you still talking that blah, blah, blah? There's no event. And there isn't. So while it doesn't mean that what my client had done previously doesn't matter, but it is like, well, okay, the facts of this case are that it really had kind of stopped. It didn't make him not a bore in his behavior, but it was over. And then Mr. Davies came back in. I think, based upon the evidence, is that he didn't like the fact that his wife was still talking to him. I mean, I kind of get it. It makes kind of sense. He's probably thinking, why are you talking to that jerk? I mean, he was just rude to me. So I get that. I mean, I do. I'm not critical of Mr. Davies. I'm not. I mean, I get it. He was mad at that point and probably more mad at his wife. But he was mad. And then when my client hears this, my client then goes out of the bar. And the two women try to stop him. It doesn't quite work. He gets upset. And they try to get him out. I mean, they try to get him to not go out because he had been angry already once. Okay? But then what happens? Okay? Now, you're going to see, this is what Ms. Burke wrote that night about what happened. And you remember, she was, she didn't go outside like Ms. Davies did. She says, from inside, I saw through the window that Josh had a chair raised above his head. Now, this is not Mr. Sehmer saying this. Okay, let's be clear about this. This is not Mr. Sehmer's statement. This is Ms. Burke's statement, a longtime friend of Ms. Davies and a friend of Josh's. She is the one who says that night he had a chair raised above his head to hit Kevin as he approached. That's her statement, not Mr. Sehmer's. I think I overheard someone say he has a chair or he's going to hit him with the chair. Again, this is Miss Davies and Josh's friend. That's what she saw that night, not Mr. Sehmer. She saw it that night. Now, Miss Davies, she says that her husband picked up a chair or a stool to defend himself. And she's, not very happy with Mr. Sehmer at this point. And she says, the man who I know as Kevin ran after him screaming at my husband about God and tattoos. My husband defended himself and picked up a chair or a stool to defend himself from this crazy person who went after him for no reason. Okay. Well, what does that mean? Well, it is that night, and I do understand that she was upset. Okay. This was, in fact, traumatic for her. Her husband was now in a hospital while they're doing, that is, medical professionals are doing things to help him. She has an opportunity to write this statement out. Now, and I understand that people, when they're upset, maybe they're not as clear as we'd like. But what's disturbing is that what she should have been upset about, if her current story is true, that is, if she believed, based upon what she saw, that Mr. Sehmer punched her husband, causing him to go to the ground. Is it reasonable is it in our life experience that you would exclude the single most important fact of this incident? This thing that has put your husband in the hospital, that you would not include what it is that she now says is the reason he was in that hospital, the punch. Now, with all due respect to Mrs. Davies, this is a difficult circumstance. I get that. But when I asked her about why she didn't include it, she seemed to suggest that, well, I mean, I thought we were all going home. I think that's kind of what she said. That's really not unreasonable. I mean, not only is it not reasonable, it's kind of ridiculous. It is impossible to believe that that's the excuse that you didn't write. He punched my husband. Had she really seen him, my client, punch her husband and has him go to the ground, it would be the single most important thing she wanted to make certain that law enforcement knew. He punched him, but she didn't. She went part of the way and said that he picked up a stool to defend himself, which is like what Ms. Burke said. I mean, the two women there both said the same thing. He picked up this stool. And I think Ms. Davies says he had it up here by his head. Ms. Burke said it over his head. I don't know that it really matters, okay? But if we take, for example, Ms. Davies' statement, it's here by, kind of above his shoulders. And she also, having acknowledged that he did that, she also in her statement doesn't say that he chucked, I think was her word. I hope that's right, but something like he chucked the stool at Mr. Sehmer. Now, again, just as it is difficult to understand or find credible that you would do this, you would write this statement and not include that he, Mr. Sehmer, punched him. It's also difficult to understand how you're actually writing about the fact that he had this stool to defend himself and not say, well, how did he do that? It is kind of an interesting absence, okay? Now we have I'm not including that he was punched, even though I'd seen it supposedly, but I'm not going to include what he did with the stool or chair. Everybody thinks it's a stool, a metal stool. So instead, she waits till the trial, not in her statement, to say, well, he just chucked it. Well, you would have said that night. Yeah, he had a chair, but he just threw it on the ground or threw it towards him, but didn't do anything. I mean, she says to defend himself. Well, okay, how? Now, it doesn't matter that she doesn't have all the details, but the two important details are, one, say that your husband was punched by my client, and two, and what he did with the stool that he was defending himself with. So those two witnesses, state seems to suggest, tell the same story, and they kind of do. The story, though, is that Mr. Davies had a stool and used it to defend himself. And in fact, somebody even screamed, he's going to hit him. I mean, that's what they said that night. That's what they said that night. It's a different story now, but I get that. But the government has to prove this case. And I'm sorry, it's a bit odd to suggest, well, I know this is really complicated. And I mean, they're all telling different stories. As if in our system, you can convict somebody of a crime, a serious crime, even though, well, nobody really knows what happened. They don't really know because they all saw things and they're all different things. And yeah, that's okay. Well, is it? Is it okay that they can't tell a story that makes any sense? Some of it is just simply not sensible. But that's what the state is asking us. Now, the other thing that's a little odd is that Ms. Davies, again, I'm not trying to be mean to her. She says that she was actually right with my client. I mean, with her husband. I mean, she was right next to him. Now, you're going to see these videos because I'm going to play them because they really kind of matter. What you're not going to see is Jennifer Davies anywhere near there. I mean, nowhere near her husband. I mean, she's just not there. Now, one of the witnesses says, well, she never came out, but she's not there, okay? Which is a little odd because given what you're going to see and already have seen in these videos, you're going to see that Josh does kind of launch himself. I mean, if you look at it slowly, you can see he literally is launching himself. And he then, something happens and he goes down. Now, the state can say, yeah, there's the follow through of a punch that we can't actually see. I don't know. I don't know how much counsel knows about boxing, but it's not like that. So she was right there. Presumably, if she were right there, remember how we see he just goes down. She'd be right there. And there are reasons that we would think, one, she wasn't there, and two, if she was, we'd have seen her, but she wasn't. So the videos, and we're going to play them, and I'm not going to play just one, and I'm not going to play the first one. We're going to use the enhanced slowed one, okay? Because I want to show you some stuff, okay? And I think it would be fair to say that any of us who have been dealing with this, and now you folks, have to deal with these videos, and they are hard, okay? They're hard. They're hard because you're looking at various different things. You're trying to look and see where maybe somebody's legs are, where somebody's hands are, where their head is, where they are, where they're moving. But I just want to show you these videos because you really need to see these. And with all due respect, the prosecutors claim that, oh, and this shows it all. Well, it does, but it doesn't show the battery that you're saying. That isn't what we're going to see. You can pretend you're seeing it, but you're not. So let's just take a look at it, if I may. Okay. And I apologize. You're probably sick of seeing these, but they are important. Okay. And without seeing them, it's hard to judge this. All right. Now this is the enhanced. Okay. They made it better, so make it easier for us to see. And then we're going to play that. And then I'm going to play it where it's slowed. Okay. So you get to see the same thing, but you're going to see it first fast, real time, and then halftime. Okay. So if you can.
Judge, I'm sorry to interrupt, but can you please tell us what exhibit numbers you're displaying?
This is exhibit 12.
Exhibit 12.
Thank you.
Thank you. Now, what we just saw was a couple of things. And I don't expect you to see everything you've seen, but we've seen a couple things. We clearly see Josh moving backwards, right? I mean, there's no question about that. And then he does seem to move a little bit to his right. And then we see him kind of launch himself. Can you back this up? Have this backwards? See how it looks like he's going up, and it does appear, and I can't tell you I'm sure, okay, I'm not. It does appear that both his legs seem to leave the ground. And then the next thing is, shortly after that, he is falling kind of to his right and down. Now, I'm gonna have her play the next one, which is what number?
Exhibit 13.
Number 13. This is the half speed. Thank you. Okay, so again, it's hard because even slowed, it's still a little complicated. And obviously looking through these windows, we know isn't perfect. I mean, it's just not perfect. So, but again, it does appear that, well, one thing that's utterly clear is that this isn't Josh standing there and getting punched. This is Josh moving. I'm using the word launching because his legs seem to get off the ground. Now, I'm going to tell you why I think he did that in a moment, but that's what the videos show, okay? Now, of all the witnesses that had some information, all but Mr. Richardson says that Josh had a stool at some point. Obviously, both Mrs. Davies and Ms. Burke are very clear that, yeah, he had it. They hear people yelling that he's got a chair. Mr. Richardson said, no, he never had a chair. Now, he has had some issues in the past, and you are able and can consider that incredibility. But it doesn't, you don't get to say, well, you know, I still want you to consider his testimony. You believe him, even though what he's saying is different than everybody else. We can't do that. We can't ask you to plug this into make you computers and say, all right, what does all this mean? Well, the state has to prove this case. It's not just like, oh, just figure it out, but it's all okay. Well, it's not okay if you're trying to prove that my client committed this crime, because it's not what they're saying he did. Now, Mr. LAport originally said that possibly Joshua had a stool or a chair, I think a stool. But later he said, no, that didn't happen. It's a little odd because you would expect him even to say, well, I wasn't sure, but now I'm sure he didn't have it. But in any event, his testimony is kind of not helpful to anybody, quite frankly, because he puts this whole event a half a block away. And if that were true, there wouldn't be any activity over here. If he'd be way to the left of this, I mean, it just didn't happen. I don't know why he recalls things the way he does and why he claims he saw what he saw. But it's so out of the range of anybody else's version of what happened. And it is utterly refuted by this video. Whatever Josh and Mr. Sehmer are doing, it's not a half a block the other way. I mean, it's right there. So I don't know what we can say about his testimony other than it doesn't support the state's burden of proof in establishing guilt. Now, do you remember when Mr. Armstrong talked about absolute difference? It's a little, let's look at absolute difference. What he said, and this is the dark one, the two dark videos, okay? What he says that objects that are darker, that are stationary, and they get lighter if they're in motion, okay? It's weird, I don't completely understand it, but that's what he said it does. So I want to show you these for a minute. There's two, okay? And I'm going to show them to you. They're in different speeds. There's a regular speed and the partial speed, okay?
This is exhibit 14.
Thank
Okay, now, one thing that is pretty clear already, just even in full speed, is that this is where Mrs. Sehmer said she was, and there's nobody there. And if she had been there, she would have had to have been moving around here. She would have been very clearly a moving object, a moving person, okay? She's not there. That's relevant because it's kind of an odd thing to be so wrong about when she was there. She just wasn't there. Right, now I gotta clear this. All right. Now we're gonna play it slower. And what number is this, please?
This is exhibit 15.
All right, I want you to tap. No, go back. Right there.
Starting from 4 seconds.
4 seconds. Stop. Back it up just a bit.
I'll do it.
Back it up. Tap, tap, tap. Stop.
Mhm.
Stop. I need you to tap this so that it stops there, please. Okay? Don't run it at their speed.
Mhm.
Okay?
Okay. Would you like me to slow down?
Yes. But you gotta back it up now. Stop. This. See that? That's a lot. It's now lighter because it's moving. Something has just moved, quite frankly, right at his feet. And there's something else that we see, which is this. Okay. You see how there's light there? We went from it being kind of dark. I mean, and it's all moving, but that is a moving object. That's why it looks light. That is the stool. Can I be 100% certain? I'm not going to tell you that. All I know is that Mr. Armstrong told us that's how this works. That if something is moving, it is lighter than something that is just stationary. And we've now seen two things. We saw this thing. We've seen that thing kind of come down. It looks kind of towards Josh's feet. And up here is something, now this lighter thing is here. Now, go ahead and play it at this speed. I think I have to clear this. Thank you. We have now seen two things from absolute difference. That's what they call it, so that's what it is. And what it is showing us, two very significant facts. This is the government's evidence. This is the government's expert brought this in. And what we've now seen are two really important facts that I think are somewhat irrefutable. One, something has come at his feet, and two, as he's lunging, as I've called it, we see movement. We see this lighter, whatever they call it, which is something that happens when something's in motion. And what's in motion here is not, as counsel says, him raising his hand. No, it's him with the stool in the position, quite frankly, that his wife had put in his hands earlier. Remember when he said he was like this? And what Ms. Burke says, he had it over his head. Now, of course, he can move, but the notion when she said it was like at this is exactly what we just saw. That's what we saw. So the videos do show that, one, Mr. Davies lunged at him. Two, that Mr. Davies had something in his hand, and it's the stool. Now, I'm not going to claim that I know everything about this absolute difference, but I know what he told me. And what he told me makes it clear that what my client said is accurate. Now, I understand that the state claims, well, this is all Mr. Sehmer's fault. Well, he did get in an argument with him. He did act like kind of a jerk. I get that. And then Mr. Davies comes back in and starts, yells at him and reignites this thing. I wish my client hadn't left, but it's not a crime to leave the bar and yell at somebody who just called you a name. But it's not a crime to do that either. Okay? Now, I have to differ with the prosecutor's belief that the medical examiner and Dr. Henson both essentially say, well, it doesn't matter. He was, he really wasn't drunk. I can tell you, I think without fear of contradiction, that no prosecutor in the state of Wisconsin has ever told a jury that a person with a 0.24 blood alcohol level was not impaired. That has never happened, probably in the history of Wisconsin jurisprudence. Nobody would say such a thing. It's laughable. It's quite frankly ridiculous, and it's just a bit offensive considering my client's on trial. That, 2-4, come on. He's got a tolerance. We saw him. Well, yeah, we did see him, but it's a video, and two, we don't really hear him say anything other than yelling some profanity. I don't know. I can't say exactly how it affects him, but I know nobody in law enforcement in this state or this country thinks that somebody with that much alcohol is not impaired and is not with less faculties. Now, why does this matter? It's not to make him seem like a bad guy. I don't care if anybody gets drunk enough driving. What difference does it make? But in this case, his effort to try to hit my client with the stool is made more complicated because when Mr. Sehmer blocks it forcefully, he doesn't have the ability to right the ship that he's just started down the path. He's up, his feet are kind of off the ground, he's trying to hit somebody, and that person forcefully resists that. Now, we did talk a little bit about the fact that everybody tolerates things differently, okay, and that's true. But there's a certain level of which, and I think Dr. Henson made it pretty clear that, well, at some point, everybody's impaired. Now, the other thing that's interesting is the medical examiner, she had an opportunity to see all the records, had the opportunity to the autopsy. What she never said, never provided any testimony about, was that there was any injury to the side of Josh's face. Now, the state is arguing that there was this unbelievably hard smash to his face. But not one bit of medical testimony or evidence suggested that Josh had any injuries, not any bruising, nothing regarding this, not a bit. So you can say, well, it was really it must have been a hard punch because he hit his head so hard. Well, she then suggested and agreed that, well, of course, if somebody is, pushing and somebody pushes back hard, the law of momentum, the law of motion, okay? You can throw yourself down if you're doing this and somebody's going this backwards, and it appears Mr. Sehmer, being quite a bit heavier, would be in a position to exert far more force than the lighter Joshua. Now, it is pretty hard to argue that my client hit Mr. Davies so hard that he did all this damage, and despite a plethora of medical people, medical personnel, nurses, doctors, and the medical examiner had all these records, and nowhere in there does she say, or did she find, that there was some evidence of any injury to his face. Now, given the degree of force that they're claiming my client exerted on his face, not on a stool that he was holding, that's hard to understand. Now, in Mr. Sehmer's interview, he wasn't utterly candid about everything. I mean, I think what the state didn't remind you of is that when he initially said there were two people with a stool, that later in in the interview, he said, yeah, you're right. I know, it was just Josh. It wasn't two people. So when he first said it, all right, he said it. I don't know why he said it. It may have been he was trying to protect himself. It may have been that given the circumstance of these two people, I don't know, I can't speculate. But you can't act as if he didn't say that, correct it. I mean, he did. He said, no, I agree. It was just Josh. It wasn't both of them with the stool or with chairs. So I don't know, other than the fact that what he said is utterly consistent with absolute difference, I don't know what else he could say. Now, as I indicated earlier, there's really two issues. One, did he commit a battery? Nobody, I don't think, is arguing that a person, whether they claim you provoked it or not, that you're allowed, once you provoke something, you're allowed to get hit in the face with a stool and you're supposed to just take it. You can't put your hand up. You provoked this, so you're going to get what's coming to you. That's not the law, okay? Now, the issue of provocation is interesting. It's a judgment you'll have to make, okay? I mean, whether the initial argument where my client wasn't behaving badly, I think it's enough to say, well, that's provocation. He doesn't get self-defense. I think most people would hate to think that if I misbehave, 10 minutes later, if somebody, calls me a name and I go want to talk to them about it, even if I'm moving fast, that, well, too bad. You're going to get anything you have. If they want to, baseball bat, too bad. You were a jerk, so you get hit in the head. I mean, but is it really a battery? I mean, is that reasonable? First of all, is it a battery to block a punch? Is it a battery to stop a stool that's being swung at your head? According to the state, that's not a battery. Or that is a battery, I guess. I don't know. I mean, that's not because they have to prove that he intended to harm him. That's what a battery is. You caused harm and you intended to. Is it intending to cause harm when somebody tries to hit you with a stool and you block it? That's not intending to harm. That's just stopping something. You go like this. Now, the second issue is, again, so if you say, well, that's not a battery, then the case is over. And did they prove that it was a battery? And remember, as the state acknowledged, they have to disprove self-defense. It's not like I have to prove self-defense. Once this has become an issue, which it clearly is in this case, okay, the state has to prove beyond a reasonable doubt that he wasn't acting in self-defense. And I think it's hard to say if somebody hits you with a stool, you can't block it. So, but it's their burden of proof. But I'd like to talk to you about the burden of proof for a minute. The judge is going to give you the instruction. Okay, there's a couple important facts. One, the defendant is entitled to every reasonable doubt if there's one. Okay, that is a reasonable doubt as to what happened. Now, I alluded to this earlier. If the state's witnesses cannot tell the same story, it doesn't mean you can't convict somebody, but it's hard to say, well, I don't have a reasonable doubt about what happened here when I don't get same stories, or where stories change, or locations change. He starts with the presumption of innocence and it remains. And it only stops if after you reviewed everything, you conclude that, well, no, he did this beyond a reasonable doubt. Now, one of the parts of the jury instruction says that if you can reconcile the evidence on any reasonable hypothesis consistent with his innocence, you must find him not guilty. You're not given a choice. If you say, well, we considered this evidence and yeah, there's evidence here that seems to suggest, and it's reasonable, that he didn't punch him, that all he did was block this. That's a reasonable hypothesis. Now, is it the only hypothesis? No, but if it's a reasonable hypothesis, and we know that absolute difference makes it a reasonable hypothesis, it's the actual truth, that Josh was swinging something. Now, the issue of this tripping, I have indicated, and I believe, that there are really three principal things that caused this. One is that he had left his feet and he was swinging a stool, which was blocked. Smaller force met larger force pushed it away, and he fell. The second is that he was intoxicated, grossly so. Now, again, it's not a judgment on him, but it does make it harder for him to do what he's trying to do physically, and it caused him to go down. And lastly, that there does appear, I don't know if you want to call it a trip or what you want to call it, but absolute zero showed that something came right at his feet, just as about the time he's about to launch. I don't know if that's a trip or that's just another factor, but those are factors that cause him, I think, in part to go down. But the principle is he's trying to swing a stool, and my client blocks it, and in his intoxicated state, he fell. One of the things that the jury instruction says is that we should consider these things, like what is a reasonable doubt, okay? And it's complicated, but I think they do a pretty good job of explaining it. One of the ways they explain it, because they try to do it in a number of ways, one of the ways is this a kind of doubt that would give you pause or hesitation in acting in the affairs of life, okay? And, lawyers both on the state or on the defense or civil litigation, they all kind of can talk about this a bit, not civil litigation, but, and they say, what are the kinds of things that we consider that are important in life? And would you not pause before you made such a decision? I've heard examples of like, well, if your child needed surgery and the judge and the doctors are saying, well, there's this and there's that, you could do this process, you could do this, or maybe don't do that. And some people say, well, that's something that's an important affair of life. And would this cause you to say, well, I'm going to pause and hesitate before I make that decision? I don't know if that's completely fair, but it does kind of illustrate how important this is. I mean, it really is important. And that is, before I say guilty, before we say guilty, I need not to have those doubts. I can look, I will examine it all critically, but at the end of the day, you can't say that I'm not in a position where I'm like, whoa, I'm really pausing on this. I don't know how you get there. How do we get to it? He did this. And I don't think the state did that. I don't think the state can do that. And when you hear the state keep saying, well, there's this problem, that problem, it's, yeah, it's a long time ago. And, I'm sorry, my client's trial is today. And I understand it happened a year ago. But they have to prove beyond a reasonable doubt that he did this. And we don't get to just say he was a jerk in tabbies. And don't worry that they can't, keep their stories consistent with the state's theory. You have to say no. There's both a reasonable hypothesis consistent with his innocence, and there are many, many reasons to doubt. And I think there are many reasons to doubt, and I'd ask that you find him not guilty. Thank you.
Any rebuttal from the state?
Yes, sir, thank you. So, ladies and gentlemen, I guess I'll just start by talking about some of the things Attorney Shiro just shared with you. He put up the absolute difference videos, 14 and 15, and he had his paralegal clicking through and showing you, and then he paused it on a certain time. I don't know what the time was, but he paused it at a certain time, and he circled two areas, one up by Josh's head and one at his feet. And he claimed both of those objects were the stool. So I have no idea what he's talking about. He said, look down here. This is the stool at his feet. And then he said, look at this object up here. And he circled that one. That's the stool. That's Josh swinging the stool. I don't know. I don't know who had the stool, where the stool was, who picked it up first. John LAport was very clear. He said Kevin Sehmer walked out of the bar, grabbed the stool, and threw it in the direction of Josh. And then I walked out to the curb in the street and picked it up later. Uncontroverted. He never even asked him about it again. There's a stool in here somewhere, ladies and gentlemen. Really doesn't matter. You don't have to sit here in your deliberations and figure out exactly who had the stool, when, and where. You don't, because Mr. Shiro was flat out wrong on one thing. He told you, I can provoke a fight and still claim self-defense. He said that. That is not the law, ladies and gentlemen. Judge Domino will tell you what the law is after we get done with our comments. It is very plain. He will read this sentence to you. A person who engages in unlawful conduct of a type likely to provoke others to attack, and who does provoke an attack, is not allowed to use or threaten force in self-defense. You provoke an attack, You don't get to claim self-defense. So if there is self-defense in this case, you know whose parts it's on? Josh's. Josh is using reasonable self-defense. Did he pick up the stool after Kevin threw it at him? Hold it up to try and keep this raging bull away from him? Maybe he did. That would be reasonable self-defense on Josh's part, if he did. You're not going to be asked who picked up the stool, who threw the stool, where did the stool land. You're going to be asked, is he guilty of causing Josh's death? Did he batter him, aggravated battery, in a way that caused his death? That's your question, ladies and gentlemen. There is no doubt, Kevin Sehmer provoked this entire incident. Give me 1 second, I'm gonna ask you to put up my table. It is up, okay, thank you. Thank you. Put up number 11. The video from inside Tabby's. We're going to talk about this. This is the one enhanced by the crime lab where they turned up the volume, so hopefully it's loud enough. Starting at 0. Pausing it at 47 seconds. Joshua Davies just walked away. Kevin Sehmer verbally attacks him the minute he meets him. Why do you have those tattoos? You're going to hell. You're a sinner. Joshua Davies walks away. First attempt by Josh to cool down the situation. Stopping at 103. Aggressive act number 1 by Kevin Sehmer. F you, pointing directly at Josh Davies. Provocation.
Hey, right this falling down, right out there.
109. Go outside and practice falling down. I'll be right out there. He has just told you, ladies and gentlemen, in that statement, his intent is to get Josh Davies on the ground. And he's inviting him to fight. I'll be right out. Go right ahead out. I'll be right there. Fighting words from Kevin Sehmer. Aggressive act number 2.
Come on, motherfucker, let's go.
112. Come on, MF. Let's go as he marches over to Josh's position. Look at the reaction of Laura Burke. What the heck is going on? Aggressive act number 3 from Kevin Sehmer, right there. Approaches him. What does Josh do?
Shut your fucking mouth.
Josh says, no, stop it. He's not bait. He's not taking the bait. He's not engaging. He's backing down. He is standing down and saying, stop it. No. He never moves a muscle. He looks over his shoulder. He doesn't turn around and confront him. He doesn't point at him. He doesn't curse at him. He says, stop it. Is it over now? Nope. Because then Mr. Sehmer says, shut your effing mouth. Aggressive act number 4.
Try that's a key word. Try
Stopped at 132. Aggressive act number 5, 6. Called him a girl, a Karen. I don't even know what that means. Bryan couldn't tell us, but he thought it was insulting. Fighting words from Kevin Sehmer. Josh does not respond in kind. Josh stays in his position at his table away from Kevin Sehmer.
Like I said, right out here.
Again, my intention, Kevin Sehmer says, is to put you on the ground. Go out there and start practicing. I'll be right out. Provocation. Both of you. Now he's a tough guy. He's going to take on both Bryan and Josh. He ain't afraid of that. Both of you go out there. I'll be right out.
Yes, this is the time. Kevin is not the Kevin doesn't put up with bullshit.
Aggressive act 9. Kevin doesn't put up with bullshit, pointing at Josh. Josh does nothing. Talking to his wife, agrees with his wife. It's not worth it. I'm going to go outside and wait. 2:02, in fact, he leaves. That's it. Josh walks away. Never uses fighting words. Never confronts Kevin Sehmer in kind. Now, Attorney Sherrill will tell you, well, that's it. It was over. No reason for Josh to come back in now. That was the end of the dispute. But it wasn't. Absolutely not. Josh is outside now. Next thing we hear from Kevin Sehmer. Fighting words. Is he cooled down? Is it over? Josh is outside. Is he cooled down? Does Kevin Sehmer think it's over at this point? Now watch Laura Burke. She got 2 drinks in her hand. She told you, I took his drink and I was trying to lead him out the back door because I wanted to separate him. I wanted to get him either on the back patio or back over to Beer Snobs to his friends. So she's got 2 drinks in her hands. Watch what Kevin Sehmer does. Takes the drink and plants it back on the table. Is it over? Is it over? He's not going anywhere. Real easy for him, if it's over in his mind, to just walk out that back door, go back and pick up his buddy Tom, or go back and have a drink with Laura on the back patio. It's not over. It's not over by any means.
I'm serving on.
250. Josh is back in the door. Look at his feet. He never even crosses the threshold. So for people to claim he came back into the bar is really an overstatement because he never enters the bar. He opens the door and he says to his wife, "Are you still talking to that asshole?" Well, can you blame Josh for saying that at that point? Can you really blame him? What he doesn't do is he doesn't threaten Mr. Sehmer. He doesn't call him any names. He doesn't use any fighting words. He doesn't go further than the threshold. He doesn't charge in, knock over 2 women, and get in Kevin's face and say, "F you." He opens the door and says to his wife, "Are you still talking to that asshole?" What is Kevin Sehmer's reaction to this?
What did you say?
Is it over? Is it over? Laura Burke's got him by the arm. Stop. No, no. Jen's in front of him, trying to block him. Jen, 5'2", petite woman. Kevin Sehmer, 6'2", 275 pounds. It's not over, folks. It's not over for Kevin Sehmer. He's going to go out there and he's going to make sure Josh practice is falling down for sure. No, 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 no. From Jen. Stop. Stop. This doesn't have to go any further. It does for Kevin Sehmer. What does he do? Pushes her aside and storms out the door. Now, he would have you believe that at this point, he gets outside and 2 guys are out there with stools, right? That's his original version to Detective Hoffa. I walk outside and there's 2 guys, all armed with stools, all revved up and ready to go. Well, then, Mr. Sehmer, wouldn't you just turn around and walk back into the bar where you just came from for safety? Why would you go out there in the first place? Why even go out there in the first place? But if you did, and you walked out there and there's 2 guys with stools over their head, wouldn't you just turn around and go back inside if you're not looking for a fight? Kevin Sehmer's looking for a fight. Kevin Sehmer thinks he's a tough guy. He thinks Josh is a little girl. This is provocation, folks. Provocation from start to finish. Charging out that door after Josh. You saw the hometown video. Josh is backing up, trying to get away from this raging bull. And he keeps going. He's afraid. He's afraid for his safety. Why keep going, Mr. Sehmer? Turn around and go back in the bar. Absolutely no explanation for his behavior other than he wanted to hurt Josh. He didn't like him from the start. He didn't like his tattoos. And he's going to be the one to finish this, right? He's not going out the back door with Laura, not returning to his friends. In fact, he ran. He goes up to Josh, punches him in the head, and runs. Leaves his friend behind at the band and gets the heck out of there. And when the cops go to his house at 5 a.m. to talk to him, doesn't come to the door. How drunk was Kevin Sehmer? Well, it'd be nice to know. If he hadn't run, police could have talked to him, gauged his level of impairment, maybe asked him to take a breath test. Who knows? We know Laura Burke said he was drinking all night. Every time she saw him, he had a drink in his hand and he was drinking vodka. Cops knock on the door at 5 a.m. He doesn't answer, so can't view him then. It's not till about 1 o'clock in the afternoon that he finally shows up at the police department and they can get eyes on him. Well, that's 12, 14 hours later. Kevin Sehmer's the one who's acting like he's impaired. He's belligerent, he's difficult, he's argumentative, and he's right. No matter what anybody says, he's going to get the last word. He's right. This was not self-defense by Kevin Sehmer by any stretch. This is a man looking for trouble. I don't know why. It's absurd. Laura Burke said he was perfectly fine at the band. When I met him out at Beer Snobs, he was a nice guy. We got along. All of a sudden, what switched in his brain? I don't know. But I do know he attacked Josh Davies outside that bar for no reason whatsoever. I know that he punched him in the head, causing him to fall down with such force that it damaged the inner core of his brain. That's not tripping over a stool. At the end of the day, ladies and gentlemen, you don't have to figure out why he did it. I don't have to prove a motive. I can't. I can't prove a motive to you. What was that button? Oh, you're in your phone. You need to go ahead. This is the last picture they took, Jen Davies said. There they are at the street party. Man lost his life over what? Don't know. But I do know Kevin Sehmer is to blame for it. Kevin Sehmer is responsible for his actions that night. Kevin Sehmer is responsible for Josh's death. There's no question from Bryan, who was there, Jen, who was there, and John, who was there. Kevin Sehmer punched him in the head and caused significant, great bodily harm to him and ultimately death. That's an aggravated battery, ladies and gentlemen. And the fact that death resulted makes it felony murder. Asking you to return a verdict of guilty. Thank you.
Here we go. Yeah, Matt Moore. If I play this to you, Lady Di, hang on. Matt Moore is my intro. You'll see him with Diane Minaj. Hang on.
Besides this is obviously going to be, you want to know.
That's Matt. That's Matt. And if I play it a little bit more, you'll see him finding out he's not guilty. Hang on.
Besides this is obviously going to be, you want to know what really happened, you need to watch this. This is the only place you're going to get this type of interview or I don't really know what this is, but I didn't do it. I'm innocent, Judge. I'm not guilty. I'm innocent.
We, the jury, being duly impaneled and sworn, find the defendant Matthew L. Moore not guilty of murder as he stands charged in count 1 of the indictment.
That was him finding out not guilty. It was last year. So he is somebody that I've had on for 6 months. He went on for probably a bit too long, but he lost everything. He retired. He was a millionaire. So unfortunately, he lost a son when he was young, and then a year before he went to jail, his son committed self-alleviated themselves. So killed themselves, and so that happened. And then when he started to get over his son dying, his wife took her own life. And then he got accused of it with no evidence whatsoever. When he was put in in jail, his mother and father both died as well when he was in jail. They took everything from him. His sister-in-law took the condo. He gave $50,000 to a lawyer to look after his affairs. The lawyer just took the money and didn't do anything. He had to pay you can only imagine like $500,000, $600,000, $700,000 for his attorney, who is Diane Minaj. She's a top attorney in Ohio, one of the best you'll ever see. He came out and he lost everything. He had no money. His house is all gone. No family members left. He's got a stepbrother from Florida. We had him on the show as well. Lost everything. He's now homeless. So that's the impact of, that's the side people don't see. Yes, he was acquitted. He was in jail for 15 months. He was acquitted. The jury made a decision up in, I think it was like 25 minutes, found him not guilty. We had a juror on as well, Connie. She came on. So he's got no money. He's tried to sue Ohio and the state and everything. And every lawyer wants him to pay money up front. And he can't afford it, obviously. Oh, yeah, here we go. So he's got a book. It's called Emily, A Staged Suicide in Ohio, by Matthew Moore. It's a book that he wrote. It's very easy reading. You could probably read it in a day or two. It's on Amazon. I think it's free on Amazon, but if you can't purchase the, hard one, I think it's like $10 or something. As I say, it's called Emily, Staged Suicide in Ohio by Matthew Moore. He gets the proceeds of that. But yeah, he jumps from house to house. He's got nowhere to call home. He's in Vegas. That's where he's from. But he went from being retired, got his own house. He had $1 million in the bank account, happily married, to losing both his sons, his wife, his mother and father, everything. Do you know what I mean? He's very bitter about it, obviously, as you can imagine, but he's still got quite a good outlook as well. So yeah, anyway, I know some of you are here for the for this verdict, so I'll get the verdict for you now, guys. I could talk about Matt in a little bit if you want, but you heard Brenda from the Glera doing the current retrial, being a fun. Oh, thank you, Brenda, my darling. Thank you very much. I don't have the link on me now, but basically just go to Amazon and put that in. Basically, that's how I always do. I could do that. So he's not living on the street. He's living with friends. He's bouncing around house to house, basically. But he's essentially homeless. Yes. Right. Hang on. Let me find the verdict. Here we go then, people. This is the verdict. I'll play it quite live. Just, I'll slow it down. Let me find the space for it and I'll slow it down to 1.25.
Before I bring the jury in, and the jury is ready to come in, I'm going to observe, first of all, that this is a case, obviously, where there is understandably high emotion. But I will tell you that this is neither a sporting event nor an opportunity to express oneself. If I have any sense of disruption by any person, I will not hesitate to clear this courtroom with the assistance of the Sheriff's Department that is present. I do not want to hear any audible reaction or response to this process. This process commands respect And that is exactly what I expect. If you have not yet, please turn off your phones. All right, Madam Bailiff, could you direct the jury in, please?
All rise.
Please be seated. Are you the jury foreperson?
Yes, sir.
Has the jury reached a verdict?
Yes, we have.
I'd ask that you hand that verdict to the bailiff, please. Court is going to ask the clerk to read the verdict.
We, the jury, find the defendant guilty of felony murder, aggravated battery with the intent to cause bodily harm as set forth in count 1 of the information.
Is there any request to poll the jury?
No, Your Honor.
Well, that was quick. That was very quick. Just guilty cut. It was a two-day. It was a 2-day trial. So on average, they say for every day of trial, it takes an hour of deliberation. So 2 hours, I think it took. If that's the case, then pretty bang on. We did a whole, yeah. I think. Oh, Hillary, come. Hey, Dally. Hey, Sal. I think it's up to 15 years. I think it's up to 15, but I don't think it's 15. I think it's 15's the max, I think, Amy. It depends what the yeah, I don't know 100%. I tried to look at it. But I couldn't find it. Thank you, Heather, if you're here. Thank you for sending people over. When I googled it, it was 15 years. So oh, that's fine. That's fine, DNS. That's fine. Yeah, I think this court. Yeah, thank you, Heather. Appreciate you for the raid. Thank you so much for sending people here. Thank you, my darling. Hope you're well. There you go. Half Irish. Hello, my darling. How are you? Hope you're well. And Dali has come back as well. Well, we did a murder trial in a day, people. A murder trial in one day. Well, we've been streaming today. If you've been here from the start, we've been streaming for 12 hours today, which is quite impressive. Yeah, sorry, I should have said Heller is EU. I should have said this is EU. Excited raid. There you go. That's the one. Jeez, pitch. So I think it's up to 15 years, but I don't think that's the max. There are mitigating circumstances to be had as well. On that one. Good night, Terry, my darling. Catch you later. 12 hours. Can you fucking believe it? 12 fucking hours today. 2 trials. Dedication, innit? We did 14.5 hours. We did. You're right. We did 14.5 hours Tuesday night as well. Chat keeps me going. You know that. Chat keeps me going. But But yeah, well, at least for the 14.5 hour trial, I fucked up, didn't I? Because I could only do. So after 12 hours, YouTube cuts it. I forgot. So the last 2.5 hours of that stream is gone. Bye bye. So the whole thing with dating and stuff that we did, gone. Bye bye. So that's why I had to redo the verdict. Yes, it's 1:30. 1:30 here. Finally caught up there in the towel, the first one, but I'm so glad to be here finally. There you go, Elsie. 8:30 Eastern tomorrow. Yes, 8:30 Eastern tomorrow, lady. We're back with Judge Boyd tomorrow. That's the treadmill, isn't it, Lisa? Treadmill guy. Yeah, I know. Law and Crime was the same. Everyone's the same. It's a fucking nightmare. I just forgot about it. If I had remembered, I would have just done another stream. So we lost 2.5 hours. I think is it 1:30 Eastern? The treadmill trial sentencing. Matchstick Sally, I know. Well, I'll be going to bed now as well. It's over 12 hours, people. We've been doing well. We've done well. I think, talking about that trial, I think it's probably the right decision. Guilty. I mean, I probably would have found him guilty. I think it's 1:30, I think. Hey, thank you for all the memberships, Robin. It's all good. We got Judge Boyd, day 2 and day 3. We're going to do 2 days in one tomorrow for Judge Boyd. Tomorrow. So yeah, there you go. 1:30 tomorrow. Well, if I got time and the Judge Boyd's going well, I might fucking stream it, but because some of you want to watch it. No worries, Yaya Trucker. It's all good. Yeah, no, we got Judge Boyd tomorrow. So obviously we did this whole trial, 3 days of trial. We did it in one day, and we did day 1 yesterday for Judge Boyd, and we done day 1A the morning yesterday, and we did day 1B the afternoon today. That tomorrow's going to be day 2 and day 3 tomorrow. All together now, all together now. Sorry to all the people who had to deal with Robin all day. Poor Robin. You're still going. Did you all watch? Yeah, we watched the verdict. Young is guilty. He was very quick. Guilty, done. In, out, shake it all about. Do the hokey cokey and turn around. That's what it's all about. Oh, okay. So yeah, I put the link in for Matt's stuff in the link. If you do fancy buying the book, he gets a large proportion of that. So, no, it wasn't second degree. It was a I forget what it was. It was a one under second, maximum 15 years. It was a felony charge. No worries, Stormcat. It's all good. Hello, Moonvale. Hello, everyone. Good day, Sheila. Good day, mate. I transported you from Hella. There you go. Thank you for that. Good day, Sheila. How are we? Put another shrimp on the barbie, or another prawn on the barbie. Good day, mate. You see, I got the thing down. Dilly Willy Banana Fana Full Philly. Manslaughter. It basically manslaughter, but they call it something else. But basically manslaughter, yes. But it wasn't manslaughter. Defense just droned on. I think he was the right call. I think, just what confused me is all the testimony. They're all different. Welcome, Moonvale. Good day. Good day, Sheila. I know you're not a Bruce, that's for sure. Right. What is that? The treadmill stuff, yeah? DNS 115. Oh, right. I don't know what you're on about. This is why I don't put your chats up, Jonathan. I don't know why. You're not a Bruce, you're a Sheila, Corn Pope. You're a Sheila. Hey, Jonathan. My computer freaked out and would not let me type in chat or phone. Now restarted my computer. Oh, no. Amy, that's not good. That's not good. Right. Test treadmill 115. Yeah. So there you go. 115. So I'll be going live. Oh, hang on. We got something else here. Hang on. I got to do this now, don't I? Hang on. Hang on. Bear with me. Strap in, people. Calm your tits and strap in. Hang on. Here it comes. Thank you to you, Leslie LC in chat. Pour me a coffee. Thank you so much. Thank you for your time. Enjoy your channel very much. Here's a coffee for the morning. Thank you, Leslie LC. Thank you, darling. I appreciate that. I will definitely need a coffee in the morning. I am fucked. I'm cream crackered. It's been a long day, Joey. You don't know you're not a Joey. You're a Sheila. Bruce and Burns. I'm Welsh. I know. See, everyone else likes my chat. I just can't put your chats up because I thought I would just be kicked out again. Bill, you buy you a puppy. My nieces would love a puppy. My phone does that on comments, replays all the time. My nieces just had a kitten. They had a puppy. They didn't really take to the puppy. They now got a kitten. They love the kitten. You need to go into court tomorrow. I'm not. Need me to go? Hey, there you go, John. Look at you. No, hey, you should go if you can go. What an experience that is. But no, you don't need to go, my friend. But what an experience that would be for you, John, to go in and see Judge Boyd. You know, for day 3. We'll be covering it fairly live, but I still got to do day 2 first. Tomorrow for Judge Boyd's day 3, and they're doing a show in the cars, so there's gonna be a late start, I believe. So hopefully we can cover day 2, which is gonna be about 4 hours, and then we'll catch up on day 3, which will probably be about 4, 5, 6 hours. So it'll be a little long day tomorrow, but we'll play at 1.25 again, so it's fine. We'll see what flowers and handbags she's got. There you go. Knackered, cream crackered, yes. Australia's a magical land. Cream crackered. I need to go to bed. You're right. But I normally take a little bit just to decompress. Anyway, there you go. Welcome. Thank you, Elsie, again. Thank you, my darling. Appreciate you. You used to work at the Outback Steakhouse. I know Aussie slang, mate. Oh, all right. Sheila. Thank you, Stonecatty. Yeah, they got a kitten. Blooming onion. Thank you, DNS. Well, if you're around, come back, pop in tomorrow. There you go. Say hi to us, John. Yeah, way from the back. This is my normal playful self. Chicken and shrimps. I say shrimps, but the Aussies don't like me saying shrimps. It's prawn. She's a fantastic judge, John. I agree with you. Fantastic. Put a private side in there, yeah. Queensland. Good day, mate. Good day from Queensland, mate. Oh, about a month ago. I'm not a big fan of kittens. It depends really. I try and start my day no later than 8 a.m. Do you know what I mean? I'll go to bed about 2, 2:30 now. Sleep for a few. I got my niece here tomorrow actually, so I'll have to be up fairly early. And then yeah, I've not done much this week. I've been streaming so much. I've let myself go this week. I've not done any walking or anything, so I've been lazy this week. I need to get back in the swing of things. So yeah, I need a lot more sleep than I used to, but I don't get enough sleep. Tuesday night I had about 3.5 hours sleep after the 14.5 hour marathon, but I'll probably get about 5, 6 hours tonight, hopefully. Sunny, no socks. We're still here. Jonathan, we know the menu by heart. It was a fun job. Shrimpy reduce. Good night, everyone. Good night, DNS. Bev will be back tomorrow. Oh, hey, DNS, we'll see you next week, but we'll see Bev tomorrow. Thank you, my darling. Good night to you, Brenda, my darling. Amy Lynch, does he even sleep? I love you, Master Chef. Australia, oh. Oh. A Frenchie. He'll give you a Frenchie, but a French kiss, he'll give you dumpster juice. Blocker name is Gemma. No, I'd prefer a dog over a kitten, is what I mean. Yeah, uber lazy. Yeah, yeah. I don't need an active dog. You'd have to. Well, to be fair, I've got a field right here, so I'll just open the door and just go. Oh. So Bev is a second account. She's got 2 accounts. Bev is crying, I think, or whatever it's called, and DNS disposal. So when she's working, she uses DNS disposal. But when she's off, she uses the Bev made me cry or whatever it's called. See the dogs is in. I've kittens for you, jeepers. Oh, Chastel, it was a band. No. There you go. It's called Bev's Crying Now. That's the one. Right, I need to get down. Married at First Sight. Oh, jeepers. Hey, we need to get Bill on that one. Let's get Bill on Married at First Sight. Yeah, dumpster juice. Boxers. No, next Saturday, next Friday, Stormcatty. Next Friday, the 9th. With Jonathan, don't worry about it. No one knows what he types half the time. Right, let's see. Yeah, well, I've been kicked out of StreamYard so many times now. Right, do you want to hang on? Some of you missed this morning. Let me play this, and I'll leave you. Right, let me play this. Then I'm gonna leave you to it. Because I'm tired, but I love every one of you. Because I'm tired, but I love every one of you. Ooh. Right, does this work? Let's hope this works, right? Are we ready? Ba-da-ba-ba-ba-da-ba. Hopefully you're able to see this, right? Da-da-da. Oh, I can get the banner down. Hang on.
It might not be, but we'll be back tomorrow. Hazel is up next for you over on BBC One.
Rolo.
And that's what I'm playing now. That's what I'm playing now, Sally.
Rolo.
Rolo is the brown one. I forgot. What's the... Okay, I'll play it again now because they're cute. So Cooper and Rolo. Cooper is the brown one, like, you know, the light brown one. And Rolo is the darker brown one. Rolo's the one licking.
Rolo.
So these are... These are...
We'll be back tomorrow. Hazel is up next for you over on YouTube.
Sally keeps scrolling's babies. They're her babies.
Rolo.
So there you go. Yeah, you can... I do not go anywhere near a kitten. Nowhere near it. I'm not a fan. Yeah, we should do a show. We might do members only, right? With dog pics and stuff. We'll do that. We'll do members only with just dog pics and stuff. So we'll do that. There's a Discord for mods, basically. Hippie chick. There's not like we're trying to revamp it, which Jonathan's trying to revamp it, but it's not really open yet. Not massively, anyway. We've got some people in there. Right. Okay. I will love you and leave you, people. I am knackered now. So enjoy yourselves. Have a great evening. I hope you enjoy yourselves. And we'll see you at 8:30 Eastern tomorrow. 8:30 Eastern tomorrow, people. So with that, I'm going to put the ad on. Thank you so much for being here. But we've been here for nearly 12.5 hours, so I need to go to bed. So thank you, everybody, for being here for this trial. 3-day trial in 1 day. We did it. And we'll see the rest of you tomorrow for day 2 and day 3 of the Can Read trial. So yeah, and thank you to Hella. Thank you, EU, for sending everyone over. Appreciate you, my darling. Thank you, everybody. Take care of yourselves. I'm going to fall asleep here. And with that, have a good evening, everyone.
Thank you.